nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulange. Meski beta lama jauh di rantau orang, beta ingat bama janji pulange. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh lebo, rasa girang dan badendang pulange.
Cek. Cek.
Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangin. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulange. Meski beta lama jauh di rantau orang, beta ingat bama janji pulange. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulange.
Hakim belum ready. Oh, nggak tahu, kirain dari sini. Cek, cek. Good morning, ladies and gentlemen. Allow me to read the rules for participants for today's symposium. Participants shall join the room 15 minutes before the International Symposium is started. Participants shall change the name format, participant _ full name. Participants shall turn on the video, mute the microphone, and use the virtual background. Participants shall or may raise hand only in questions and answer session. Assalamualaikum warahmatullahi wabarakatuh. May peace be upon us all. Good morning, the honorable speakers, the distinguished participants, ladies and gentlemen. It is very delighted to me to warmly welcome you to the 4th Indonesian Constitutional Court International Symposium, ICCIS. This symposium aims to generate many ideas in the perspective of constitutional law and comparative law. We also offer many new perspectives from the development of the theme that will be discussed in the next 2 days, which is Constitutional Court, Religion, and the Constitutional Rights Protection. Ladies and gentlemen, it is very pleased to me to warmly welcome the honorable guests that attend the opening of the symposium today, Justices of the Constitutional Court of the Republic of Indonesia, His Excellency Professor Saldi Isra, Her Excellency Professor Eni Nurbaningsih, the Honorable, the Secretary General of the Constitutional Court of the Republic of Indonesia, Professor M. Guntur Hamzah. Ladies and gentlemen, we are going to hear the welcoming remarks that will be delivered by Justices of the Constitutional Court of the Republic of Indonesia, Professor Saldi Isra. But then, before that, let's enjoy the video of the profile of the ICCIS.
The 4th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of our previous international symposia in Surakarta in 2017, Yogyakarta in 2018, and Bali in 2019, the Constitutional Court of the Republic of Indonesia will hold the 4th Indonesian Constitutional Court International Symposium. The Constitutional Court of Indonesia provides an international academic forum to discuss various constitutional issues in comparative perspectives, with the theme Constitutional Court, Religion and Constitutional Rights Protection. The Constitutional Court of Indonesia gives opportunities to legal scholars, researchers, lawyers, and practitioners to participate in the Indonesian Constitutional Court International Symposium. For further information, please visit www.iccis.mkri.id.
Deliver her keynote speech in this symposium. The Honorable Secretary General of the Constitutional Court of the Republic of Indonesia, Professor Muhammad Guntur Hamzah, distinguished speakers and participants of the International Symposium, distinguished guests who are joining us from across the world. Pertama-tama, first of all, I would like to express my warm welcome to all speakers and participants in the 4th International Symposium organized by the Constitutional Court of the Republic of Indonesia. Each year, we hold this academic forum at the global level for academics to discuss the real issues surrounding Constitution and the decision of the Constitutional Courts. I'm sorry, especially to participants who attend in Bandung. I cannot be at the venue with you because of my obligation to take a part in plenary and panel session today. I have to be in Jakarta in my office. Hopefully, we can meet in Bandung this evening or tomorrow morning. In conjunction with this international symposium, the Indonesian Constitutional Court tomorrow will also hold an academic forum for constitutional justices called the Second Conference for Constitutional Courts, Supreme Courts, and Constitutional Councils of Member States and observers from the Judicial Organization of Islamic Cooperation, or JOIC. One of the objectives of holding these two series of international activities is so that the Indonesian Constitutional Court can continue to follow developments in contemporary discussions among constitutional justices, academics, and researchers from various countries. Getting back to the International Symposium that we will be participating in today, the organization of this year's symposium is somewhat different from previous years. Due to the COVID-19 pandemic, it is impossible to hold physical meeting in the presence of many people, so this international symposium is being held online. However, as a new habit of new normal era, online international conferences also bring advantages. Namely, such discussions can be attended by many online speakers and participants from various countries and from various regions in Indonesia. According to the latest data from organizing committee, this symposium will present 28 speakers from Australia, Austria, Bangladesh, Hungary, India, Indonesia, Malaysia, Palestine, Singapore, Turkey, and Vietnam. Meanwhile, more than 500 people have registered to take part through Zoom. This number does not include those who will take part via the Constitutional Court live streaming YouTube channel. Thus, our two-day event will provide much wider benefits, not limited to speakers or the Constitutional Court, but also to academics, researchers, and to the public. Distinguished guests of the symposium. The theme for this international symposium is Constitutional Court, Religion, and Constitutional Rights Protection. I do believe for some people, this theme might seem to be too sensitive because it discusses religion in state life. But I do believe also for other people might be view it skeptically by arguing that religion should not have a special place in the relationship between the state and its citizens. In this situation, Indonesia actually places religion as one of the important pillars in the life of nation, state, and society. And this issue has already been long discussed in Indonesia, especially during the preparation for the independence in 1945. In the Indonesian Constitution, Chapter 11 contains provisions specifically on religion. Article 29, paragraph 1 of the 1945 Constitution states, the state is based upon the belief in the one and only God. Although the Constitution has been amended 4 times, 1999 to 2002, the Article 29 remains unchanged. I can tell you, just a few articles remain unchanged in the amended Constitution. One of the basic reasons for that is the amenders, or MPR, did not need to debate a very hard issue, like the founders of the Indonesia did in preparation of our first Constitution. We had a bad experience when this issue was debated during the preparation for new Constitution from 1956 till 1959, which became deadlocked in the Constituante, or Constitutional Assembly, and therefore was cancelled by President Sukarno on July 5, 1959. Back to the symposium. About 10 years ago, the Constitutional Court here had to deal with a review file against the blasphemy law. Maybe the Honorable Justice Eni Nurbaningsih will tell more about this in her keynote speech. In handing down its ruling, the Constitutional Court, commenting on the concept of the relationship between the state and religion, said Indonesia is not a religious state based on only one particular religion. However, Indonesia is also not a secular country that does not pay attention to religion at all. So, what is the conception of the Indonesian state in relationship to religion? Indonesia is a religious nation state that has an obligation to protect every religious follower in carrying out their respective teaching and worship. This obligation is based on Article 29, paragraph 2 of the 1945 Constitution, which states, the state guarantees the freedom of religion for its citizens and to practice such religion and belief accordingly. Then there are also other articles in 1945 Constitution which provide constitutional guarantees of the rights and freedom of religion. This means that constitutionally, regulations regarding this right and freedom related to religion are available. The challenge now is how these rights and freedom can be enforced and protected through available legal mechanisms and instruments. One of the state institutions that can participate in upholding and providing protection for religious rights and freedoms is the judiciary. In practice, in various countries, the Constitutional Court or similar court institutions such as Supreme Court, the Constitutional Council, and the Constitutional Tribunal might deal with the cases related religious rights and freedoms. However, how far these religious rights and freedoms can be protected will certainly depend on the basic concepts and constitutional system developed by each country. Therefore, this international symposium provides a great opportunity to discuss the best practices from various countries, including Indonesia, especially regarding how the judiciary should place religion as an effort to provide protection for the constitutional rights of citizens. This academic forum is honored by a valuable participation of speakers who are qualified with expertise and practical experience to discuss this theme. Among others, our keynote speaker is the Honorable Justice of the Indonesian Constitutional Court, Professor Eni Nurbaningsih. Then we will also have His Excellency, the Turkish Constitutional Court Justice, Professor Engin Wilrim, and my dear friend, our dear friend, Professor I. Dewagede Palguna, who twice served as a justice of the Indonesian Constitutional Court. I know during his 2 terms, he had a very important role in determining the relationship between state, religion, and society in many constitutional court decisions. From international academic circles, we have a very prominent expert like Professor Nadir Sahosen from Monash University in Australia. I know Professor Nadir Sahosen, one of the very popular in discussion about the issue on moderate Islam in Indonesia. Professor Farid Sufia Sued from the International Islamic University of Malaysia, Professor Nikmatul Huda from Universitas Islam Indonesia Yogyakarta, and Dr. Dian Shah from the National University of Singapore. In addition, several professors and doctors, as well as young academics from abroad, will present various papers with the sub-themes on court jurisprudence and freedom of religion, comparative perspective on religion and constitutional practice, the relationship between constitution, politics, and religion, religious authorities and constitutional reforms, state and religion in constitutional debate, and protection of religious minorities in Islamic constitutionalism. Distinguished speaker of the International Symposium. International forums like this are also a good opportunity to expand academic networks. In previous years, after the International Symposium was held by the Constitutional Court, some of the speakers had the opportunity to present their ideas and opinions at various universities in Indonesia. Therefore, this International Symposium can be said to open a wider dialogue space between academics in Indonesia and international scholars. This international symposium is also a bridge for exchange of thoughts and state administration practices across many countries. It is important to keep a written record of our thoughts and opinions. In line with this, the Indonesian Constitutional Court has an international journal in field the comparative constitutional law called Constitutional Review. After going through a serious assessment, our journal has recently been indexed by Scopus. For this reason, selected papers that have passed by reviewer from the international reviewer will also be considered for publication in the journal Constitutional Review, so that the ideas and thoughts of the speaker at this symposium can be more widely read by academics, researchers, and the public. I hope that our academic discussion and dialogues will not stop when this international symposium is over, but that its wider academic network can be built, including constructive input and suggestions for the Indonesian Constitutional Court itself. For that, I would like to congratulate all speakers and participants in this global academic forum. In saying Bismillahirrahmanirrahim, I declare this fourth Indonesian Constitutional Court Symposium. Thank you. Terima kasih. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you so much, Your Excellency, Professor Saldi Isra. Distinguished participants, to get to know further the speakers of this fourth Indonesian Constitutional Court International Symposium, let's watch together the video of the speaker of the fourth ICCIS. Ladies and gentlemen, that's the picture of 28 speakers that will deliver the papers and presentations in the next 2 days. Distinguished participants, ladies and gentlemen, allow me to invite Her Excellency Professor Eni Nurbaningsih, Justice of the Constitutional Court of the Republic of Indonesia, to deliver the keynote speech. Your Excellency Professor Eni Nurbaningsih, the floor is yours.
Assalamualaikum warahmatullahi wabarakatuh. Om Swastiastu, Namo Buddhaya, salam kebajikan, salam sehat, good morning. His Excellency Justice of the Constitutional Court, Professor Saldi Isra, the Honorable Secretary General of the Constitutional Court, Professor Guntur Hamzah, distinguished speakers and participants, ladies and gentlemen. I am honored to be part of this symposium and would like to express my sincere gratitude to His Excellency Chief Justice of the Constitutional Court of the Republic of Indonesia for the kind invitation extended to me to give a keynote speech in the 4th Indonesian Constitutional Court International Symposium. The topic for this symposium, Constitutional Court Religion and Constitutional Rights Protection, is an important issue to the Indonesian people. This is because the Republic of Indonesia, a religiously diverse country. Freedom of religion is part of human rights and constitutional rights that must be protected in a democratic society. Therefore, obligations or responsibilities arise for the state, especially the government, to respect, protect, and fulfill the constitutional rights. Ladies and gentlemen, the protection of freedom of religion in Indonesia is guaranteed in the 1945 Constitution. The preamble to the Constitution outlines the Pancasila, or the 5 principles, as the state ideology, and the first principle of which is belief is Almighty God. The first principle of Pancasila becomes the main basis for the acknowledgement of religiosity in the state system. It has also encompassed a variety of legal arrangements like lawmaking and political activism in modern Indonesia. Since its independence in 1945, the Constitution has protected freedom of religion in Indonesia. Following the fall of the New Order government in 1998, the Constitution was amended 4 times between 1919 till 2002, signifying a stronger commitment to protection of freedom of religions. With the second amendment, inserting a chapter on human rights into the Constitution, this chapter reflects many of the rights and international human rights instruments, and freedom of religions is clearly regulated. As Prof. Saldi mentioned before, the main constitutional provision concerning religious freedom are stated normatively in Article 28E, paragraph 1, that states, each person is free to embrace a religion and to worship under their religion. Furthermore, in paragraph 2, it is also emphasized, each person has the freedom to be convinced of their beliefs and to express their thoughts and attitudes following their conscience. Later on, Article 28I, paragraph 1 specifies that the right to have a religion cannot be limited under any circumstances. As for Article 29, paragraph 2 asserts, the state guarantees to all persons the freedom to embrace their religion and to worship following their religion and beliefs. Ladies and gentlemen, based on the constitutional provision mentioned above, it can be seen that Article 28I, paragraph 1 and 2 constitute recognition of the right to freedom of religions and belief for anyone, while Article 29, paragraph 2 is affirmation of the role that must be performed by the state or government to guarantee its citizens to be independent in embracing the religions. These constitutional safeguards have had a significant impact on development of constitutional democracy in Indonesia today. However, the constitutional provision concerning the freedom of religion are considered insufficient to protect citizen fundamental rights. For this reason, Indonesia also enacted some relevant laws related to the protection of freedom of religion. In the elucidation of the blasphemy law, law on prevention of misuse and or defamation of religions, number 1 PNPS 1965, some religions are mentioned as the religions embraced by the majority of Indonesian people, which receive state protection and funding. They are Islam, Christianity, Hinduism, Buddhism, Confucianism. In addition, Law number 39 of 1990 concerning human rights, knowledge, and protects religious freedoms. Article 22 of the law repeats the constitutional guarantee that all people are free to adopt their own religion and to worship according to their religion and belief. If placed in a more universal context, the recognition of religious freedom, as mentioned in the Constitution and laws, is following the spirit of the formulation of religious freedom as stated in international human rights, including the Universal Declaration of Human Rights, the International Convention on the Elimination of All Forms of Racial Discrimination, which has been ratified through the law number 29 of 1990 concerning ratification of the International Convention on the Elimination of All Forms of Racial Discrimination, and the International Covenant on Civil and Political Rights, which has been ratified through law number 12 of 2005 concerning ratification of the International Covenant on Civil and Political Rights. Ladies and gentlemen, all of these international treaties guarantee freedom of religion or belief for everyone without discrimination. The consequences of this ratification are these treaties became national law, and the government was immediately obliged to respect, protect, implement, and advance the human rights contained in them. The idea of a democratic state based on the rule of law, which is also adopted by Indonesia, should be seen in the perspective the Constitution, namely the rule of law, which places the principle of belief in Almighty God as a religious value. The protection of citizen rights to freedom of religion means that when a violation of the Constitution occurs, citizens as the rights holders must be provided legal remedies to maintain their rights as a guarantee by their constitution. This guarantee is established by various legal instruments and judicial institutions to ensure the protection of freedom of religion by the state. The establishment of the Constitutional Court in Indonesia is triggered by a variety of reasons. In general, it is initiated by the process of political change from authoritarian power to constitutional democracy. It is in line with the momentum of the amendment constitution during the reform era. The third constitutional amendment of 2001 provided for a new constitutional court, which was duly established in 2003. The idea to establish a constitutional court was adopted in the amendment to the Constitution by the People of the Consultative Assembly, or NPR, as formulated in the provision of Article 24, paragraph 2 and Article 24C of of the Third Amendment to the Constitution. The Constitutional Court of Indonesia is one of the state institutions exercising independent judicial power in administering the judicial system with the aim of enforcing law and justice. The Constitutional Court has 5 authorities as set in Article 24C, paragraph 1 and 2 of the Constitution. Based on its power and authorities, the Constitutional Court essentially functions as a guardian of the Constitution, democracy, and fundamental rights. It must come to play a central role to ensure that the Constitution is adhered to by all state institutions, so that there will be consistency and harmonization in the drafting of legislation and state policies by enshrining the Constitution as the supreme law of the land, especially in keeping state institutions transparent and responsive to the protection of constitutional rights to freedom of religion. Ladies and gentlemen, since its establishment in 2003, the Constitutional Court of Indonesia has decided important cases concerning freedom of religion. It shows that the court has taken active steps to provide the widest possible latitude for the protection of freedom of religion in Indonesia. In 2017, the Constitutional Court granted a judicial review of the law number 24 of 2013 concerning civil administration law that will pave way for Indonesian native faith followers. In Indonesia, we call it penghayat kepercayaan, to have their belief officially recognized by the government. The judicial review was filed in 2016 by followers of 4 indigenous faiths who argue that the law violated the principle of equality before the law. The court argued that by leaving the religion feels blank, indigenous belief followers had also suffered problems in exercising their rights, including difficulties in marriage registration and accessing civil administration services. The religion field on family registration and electronic ID card of people adopting indigenous belief should know sound that they are native faith followers, without details about their in this native faith follower cases. Ladies and gentlemen, the court considered that the disputed articles provided no uncertainty and we violated principle of equal justice for all citizens. The court further said that articles in the law that required people adopting indigenous native faiths to leave the religion column in their ID card blank were discriminatory. These articles state different things that should be the same, namely citizens who live in beliefs that are recognized according to law and regulation in accessing public services, and citizen native faith followers. According to the Constitutional Court, the limitation of this right has nothing to do with respect for the rights and freedom of others and is not related to the fulfillment of just demand in the life of a democratic society. On the other hand, the limitation of this right actually leads to unfair treatment of citizen native faith followers. Thus, it turned out that the reason for the limitation of right as regulated in Article 28G, paragraph 2 of the Constitution have not been fulfilled, so that the different treatment constitutes a discriminatory act. In deciding the case, the court found that Article 61, paragraph 2 and Article 64, paragraph 5 of the Civil Administration Law contradict the Constitution, and these articles are not legally binding. Ladies and gentlemen, another Constitutional Court landmark decision can be found in the blasphemy case. In 2009, a coalition of non-government organizations lodged an application for judicial review of the blasphemy law with the Indonesian Constitutional Court, in which it argued that the blasphemy law contravened the right to religious freedom as set out in Article 28E and 29 of the Constitution. The applicants in this case consisted of several legal aid and human rights groups, including Impartial, Elsan, and many others. The applicants argue that the mention on only strict religions that I mentioned before, as set out in the Education to Article 1 of the blasphemy law, marginalized and discriminated against other religions and beliefs. Therefore, the provision of the blasphemy law was against the right to freedom of religion. The application refers to the right to be free from discrimination in Article 20XI, paragraph 2, and the right to adhere to a religion, which is included in a list of other rights that must not be limited in Article 20XI, paragraph 1 of the Constitution. In addition, the applicants argue that the blasphemy law was inconsistent with the rule of law as set out in Article 1, paragraph 3 of the Constitution. In deciding the blasphemy case, the court argued that Indonesia is a country with a belief in God, not as a secular state, as Prof. Sadi is mentioned before. This means that it's not a country that separates the relationship between religions and states. The court reasoning implied that Indonesia allows for a mutual connection between state and religion that permits the state to regulate these activities of religious communities, while at the same time ensure that the recognized religions have the opportunity to influence state policies. Moreover, the court explained that Indonesia has its own unique religious tradition. We call it tradisi keagamaan, and other countries should not intervene. The decision of the Constitutional Court is important because it held that the blasphemy law is valid and that it does not contravene the constitutional right to freedom of religion. Based on the analysis of constitutional cases, the Constitutional Court has become one of the main actors in Indonesia democracy. In the case of the native faith followers and the blasphemy case, the Constitutional Court has made strong decisions in constitutional review cases related to the development of freedom of religion in Indonesia. Apart from the important role of the Constitutional Court, it is imperative that the Constitutional Court must continue to improve their role in guaranteeing these religious freedoms. The important role of the Constitutional Court in protecting freedom of religion merits attention because an independent judiciary is indispensable to making constitutionalism more than an embellishment. Ladies and gentlemen, it is not possible to cover all aspects of the topic in a single keynote speech. Summarizing the above, I would like to note that the recognition and enforcement of freedom of religion is of fundamental importance for the development of constitutional democracy and the protection of constitutional rights in Indonesia and also the global world. I think that this fourth Indonesian Constitutional Court International Symposium will help us all better understand the issue raised for discussion, exchange positive experiences, and develop effective ways to solve modern challenges related to freedom of religion. I may come to the end of my keynote speech at this moment, and I do hope you could enjoy the symposium. Thank you very much for your kind attention. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you very much, Your Excellency, Professor Eni Nurbaningsih. Distinguished participants, ladies and gentlemen, now we have come to the sessions of taking the photo sessions. Those, I invite all of participants who have been in the Zoom meeting room to turn your camera on and prepare your best smile because we're gonna take some pictures to document for the documentations and photo sessions. I'm counting on 3, 2, 1. Once again, smile. 3, 2, 1. Okay, it's gonna be the last picture taken. 3, 2, 1. Thank you very much. Let's give a humble applause for all the honorable speakers that have delivered the presentations for the opening of this symposium. Honorable speakers, distinguished participants, ladies and gentlemen, that's the end of the opening of the 4th Indonesian Constitutional Court International Symposium, ICCIS. We will start our first plenary sessions, which will be led by a senior researcher of the Constitutional Court of the Republic of Indonesia, Pan Muhammad Faiz, PhD. Without further ado, I would like to give the floor to our distinguished moderator, Pan Muhammad Faiz, PhD. The floor is yours.
The 4th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of our previous international symposia in Surakarta in 2017, Yogyakarta in 2018, and Bali in 2019, the Constitutional Court of the Republic of Indonesia will hold the 4th Indonesian Constitutional Court International Symposium. The Constitutional Court of Indonesia provides an international academic forum to discuss various constitutional issues in comparative perspectives, with the theme Constitutional Court, Religion, and Constitutional Rights Protection. The Constitutional Court of Indonesia gives opportunities to legal scholars, researchers, lawyers, and practitioners to participate in the Indonesian Constitutional Court International Symposium. For further information, please visit www.iccis.mkri.id.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, may peace and prosperity be upon us all. Thank you so much, my colleague Mary, for introducing me. Today we're going to have a plenary session for about 1.5 hours, and there will be 3 distinguished speakers that have attended the symposium. One is first speaker, Professor Nadir Shah Hussain. Nadir Shah Hussain teaches law at Monash University with particular interest in human rights and constitutional law. And he is also internationally known for his expertise in Sharia and Indonesian law. As far as I know, Professor Nadir Shah Hussain also the first Indonesian who teach constitutional law in Australia. And that's a very prestigious achievement for all of us here. The second speaker, we have Professor Farid Sufyan Suhaib. He obtained LLB from International Islamic University, Malaysia, IIUM, and then he completed his LLM from Queen Mary University of London and obtained his PhD in law from IIUM. His writing are referred to in the judgment of Superior Court in Malaysia, and he was also visiting scholars at Queen Mary University of London between February and March 2016. And the third speaker, we have Dr. Diansa. She's an assistant professor at the Faculty of Law NUS and completed her LLM and SGD degrees at Duke University Law School. And my humble opinion, now she's a rising star in Asian studies, particularly in religious studies. And she just appointed as a member of Malaysian Consultative Council on Foreign Policy. Congratulations for Dr. Diansa. I would like to greet all the speakers now. Professor Nadir, good morning from Jakarta. How are you going?
Morning. Alhamdulillah. Thank you.
Nice. Professor Farid Suhaib, how are you? Could we check the microphone first for Professor Farid Suhaib?
Oh, thank you. Good. I'm good. There is some technical problem just now.
Okay, no worries. And also for Dr. Diansa, could you hear our voice clearly?
Yes, I can hear you very clearly. Good morning from Singapore.
Nice. So we will have about 1.5 hours to discuss on a special issue relating with religion and constitutional practice in Asia, in particular in Indonesia and Malaysia. Then we will first invite our first speaker, distinguished speaker, Professor Nadir Shah Hussain, who will deliver his thought and perspective on reform of Islamic law and the Indonesian Constitutional Court. So without further ado, I would like to invite Professor Nadir Shah Hussain to deliver your presentations. The floor is yours.
Thank you. Mas Faiz, could I get an access to share screen?
Yep, the committee will open the access for share screen, or we can also assist you for controlling the PPT. You would like to?
I can control by myself.
Okay.
Okay. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera untuk semua. Thank you very much for inviting me to speak in this panel. It's a great honor, particularly as I am more than most people here, actually unqualified to do so. Indeed, I was very doubtful whether I should say yes when the organizing committee approached me several months ago. At the end, I said yes with the intention to learn from the judges, professors, and experts who are here today, even if it is conducted virtually. As you can see from my screen, the title of my presentation is Reform of Islamic Law and the Indonesian Constitutional Court. And for the chair, Mas Faiz, please no need to call me Prof. Just refer to my first name, Nadir, is fine. Okay. So in Indonesia, Islamic law has been legally practiced in a limited fashion, mainly on ritual, family law, and economic Sharia. The Indonesian Parliament, as we know, has issued several legislation to legalize the selected application of Islamic law, even though Indonesia is not officially an Islamic state. As they are embodied in statutory legislation, this opens the possibility that such legislation could be challenged in the Indonesian Constitutional Court or Mahkamah Konstitusi. This could be problematic, as not all justices of the court have expertise on Sharia, and some of the justices are not Muslim. I've examined elsewhere the personal backgrounds of the Constitutional Court justices from 2003 to 2015, particularly their Islamic affiliations. My 2016 article of critical observations regarding the impact of Islamic judges, the so-called Islamic judges, on the issue of the relationship between Sharia and Constitution Indonesia. However, in my presentation today, I will not look at the personal background of those justices. Instead, I go further by examining some of their decisions related to Islamic law in order to answer the two main questions I pose here. First, is it possible that reform of Islamic law is also conducted by the judges of the Indonesian Constitutional Court? As you know that usually such reform is conducted by ulama or Muslim scholars, professor of Islamic law, or even judges in the religious court, pengadilan agama. Then the question is whether such reform is also possible be conducted by the judges of the Mahkamah Konstitusi. The second question, could we identify any reform elements in Mahkamah Konstitusi decisions on Islamic law related issues? So I would explain first the need for Islamic law reform and how such reform could be performed. Afterwards, I will discuss some of the court decisions related to the issue of Islamic law. And finally, I would argue that the court decisions have implication for the reinterpretation of Islamic law in Indonesia. On the one hand, the Quran and the Hadith are considered immutable regardless of history, time, culture, and location. Muslims may change, but Islam will not. This means that the rulings pronounced by Sharia are held to be static, final, eternal, absolute, and unalterable. However, on the other hand, how could Muslims face the challenges of the 21st century by returning to the practice and interpretation of the Quran and Hadith appropriate to the 6th and 9th centuries? Islamic teaching is in fact the product of a very slow and gradual process of interpretation of the Quran and the collection, verification, and interpretation of the Hadith during the first 3 centuries of Islam. This process took place among scholars and jurists who developed their own methodology for classifying sources, deriving specific rules from general principles, and so forth. The Quran and Hadith must involve human interpretation. The Quran and Hadith cannot be understood nor have any influence on human behavior except through the efforts of human beings. Therefore, even though Islam is based on the revelations of God, it cannot possibly be drawn up except through human understanding, which means both the inevitability of differences of opinion and the possibilities of error, whether among scholars or the community in general. Ijtihad in Islamic law can be defined simply as interpretation. It is the most important source of Islamic law next to the Quran and the Sunnah. The main difference between ijtihad and both the Quran and the Sunnah is that ijtihad is a continuous process of development, whereas the Quran and the Sunnah, as mentioned earlier, are fixed sources of authority and were not altered or added to after the death of the Prophet. And the methodology of ijtihad has been developed gradually throughout the history of Islamic law. The scholars of various schools of thought or madhab differ in the principles and rules they use. And scholars also sometimes went beyond the text. For instance, some scholars adopted the principle of masoli mursalah, public interest, which is neither commended nor prohibited in any primary source, but is based on the conviction that all the laws of the Sharia are intended for realizing the welfare or the good of humankind. Consequently, different methods of interpretation will lead to different outcomes. And contemporary Muslim scholars also use maqasid Sharia that provide the objectives that Sharia is bound to consider in every circumstance and every ruling. It is considered that a breach of this ruling brings about injustice. The Maqasid Sharia, as stated by Imam al-Ghazali and developed later on by Imam al-Shatibi, have represented the objectives of Sharia as accepted by all Muslim jurists and scholars. The Maqasid Sharia covers at least 5 things: maintaining religion, hifzuddin, life, hifzun nafs, offspring, hifzun nasl, property, hifzul mal, and reason, hifzul aql. A number of modern scholars are in favor of utilizing Maqasid Sharia approach not only to establish legal rulings, but as the most appropriate method to update Sharia and expand the objectives to account for modern changes to society. And then the new approach of how Islamic teachings should be understood in the modern context requires collaboration between religious leaders and scholars from related disciplines. It is what we call it collective ijtihad or collective interpretation. It's no longer individual interpretations. This collective effort is a viable tool through which a society can adjust itself to internal and external social, political, and economic change. Islamic scholars need to recognize that they are not the sole authority to solve all problems. In other words, in order to support collective ijtihad, they need to develop new interpretations of original sources while studying the interpretation of the past, both to learn from their insights and to understand them as product of their historical environment. Reform of Islamic law is a continuing process to adapt to social changes. Such reform is usually conducted by Muslim jurists and judges of the religious court. I would argue that using the idea of collective ijtihad, as explained earlier, the Indonesian Constitutional Court could also perform ijtihad when dealing with legislation related to Islamic law. The court decision is final and binding, and therefore would have some implications for Islamic law discourse. Let me put my observations in the context of existing literature. In their book, Simon Barth and Tim Lindsay argue that the court has consistently maintained the right of the state to make laws embodying Islamic doctrines. In particular, they highlight the impact of the court decisions on religious obligation and religious protection. Simon Barth, in his other articles, explained further that the court stands between ensuring that the state retains control over religious matters and appeasing Indonesia's moderate Islamic majority. Having reviewed some of the cases, I would argue that the court, the Mahkamah Konstitusi, has conducted collective ijtihad, just like religious court and Muslim scholars. And I have found that there are 4 models of court decisions that we should appreciate as part of ijtihad in the context of Islamic law reform. So first, the court decision serves as a justification of a modern nation state. Mahkamah Konstitusi accepts that Pancasila as state ideology and the Constitution as the highest law in the land, not the Sharia. This position is in line with contemporary Muslim scholars' position, who rejected the old traditional caliphate where the sovereignty belongs to God, not the people. As we all know, the fall of the Ottoman Caliphate in 1924 led to the notion of nation state in Muslim communities. There is no longer a single world government for all Muslim societies. Since then, the concept of nationalism, along with democracy, republics, and rule of law, have become political and legal discourses amongst Muslim scholars. And then we also have modern scholars like Muhammad Abduh, Ali Abdul Razik, and Hussein Haikal, who took the substantive approach to the Sharia, and they came to the conclusion that the universality of Islam lies not in its political structure, but in its faith and religious guidance. Therefore, the claim that the Khilafah is the only valid type of Islamic government is questionable. Who then has the sovereignty in Indonesia? Article 1(2) of the amended constitution clearly now states that sovereignty is in the hands of the people and it's exercised in accordance with the constitution. The court decision justified the important position here, the exception of the nation state, the constitution, and popular sovereignty. But at the same time, from Islamic viewpoint, the court takes also the position that, and I quote here, the basis of belief in God and teaching as well as religious values serves as a benchmark to determine whether or not certain law is good or even whether or not certain law is unconstitutional. This is based on 2009 Constitutional Court decision. What it means? What does it mean? It means the court will not ignore God's law, despite the fact they accepted the nation state and constitutionalism. As God's law also reflected in the first pillar of Pancasila. In other words, the court decision is to justify the position of Indonesia, neither an Islamic state nor a secular state, as we already also learned from the Honorable Justice Professor Saudi Isra and Professor Eni earlier. So I think the decision of the court here involving Islam have been standard. What I mean by standard is that there is no indication of replacing state ideology or putting Sharia above the constitution. Sharia will be considered alongside the national law. These all mean the democratic and constitutional mechanism now provide that as long as the state ideology remains untouched, any discussion, any legislation, or any position can be embraced by Indonesian Muslims and also Indonesian state. The second model of the court decision is to confirm the approach taken by Indonesian Muslim scholars to incorporate Sharia only in a selected area. Again, this could be seen as a standard position to appease Indonesia's moderate Islamic majority, but since the court decision is final and binding, the impact of such decision is enormous. The rejection of hudud application or Islamic criminal law is really important, as some Muslims in Indonesia might argue that their belief requires the state enforcement of hudud. Although this is the standard position, but this is also important because it confirms the position taken by the majority of Muslim scholars in Indonesia, not to implement hudud. The position of Mahkamah Konstitusi is very clear here. With a strong statement, the court rejected the application to insert hudud law into the religious court jurisdiction. So in the religious court jurisdiction case, selected aspects of Islamic law were held to be authoritatively enforceable by the state, and the court rejected the application to extend the jurisdiction of the religious court. In another case, which challenged some articles into the criminal code or KUHP concerning unmarried sex, by referring to religious Islamic concept of criminal law, the applicants asked the court to broaden the scope of the articles to include all extramarital sex, females on males rape, and same-sex intercourse. And the court rejected this application once again. While the court, and then the court also made it clear its position regarding state religion by pointing out that the applicant's argument was contrary to the Indonesian state conception or paham kenegaraan Indonesia of the relationship between state and religion. The third model of the court decision is to impose the state's duty in administering and facilitating religious freedom, in this context, Islamic law. Take an example of the case that challenged the constitutionality of law number 23 of 2011 on the zakat management. This zakat management law repealed the 1999 old law, and then this 2011 law contained provisions which significantly changed previous arrangements regarding zakat, particularly with regard to the role of National Board of Zakat, or Badan Amil Zakat Nasional, Baznas. So here the state guaranteed of the right to religious freedom for Muslims constitutes the main basis of the law. Bureaucratization of Islamic law is evident in many provisions of the law. And then the new law of 2011 on zakat management has made the bureaucratization of zakat broader. It centralizes the zakat management in hands of Baznas. And there was a challenge in 2012 by several zakat organizations about some of provisions of this zakat management law of 2011. They challenged particularly the provision of the Baznas and LAS, Lembaga Amil Zakat. And Mahkamah Konstitusi, in this zakat management case, without any hesitation, accepted the legitimacy of the law, which facilitates solely the application of Islamic law through the creations of a centralized government institution of zakat, Baznas. According to the court, Baznas was aimed to strengthen and coordinate the existing zakat services provided by society and individuals. Then the establishment was legitimate and did not violate constitutional right as proposed by the applicant. It seems well established that Article 29, Paragraph 2 in the Constitution of Indonesia constitute the main basis for the legitimacy of Islamic legislation. As we can also look at in the case of BPIH, Hajj Pilgrimage Cost, the court also took this approach, arguing that the state facilitation of the performance of the Hajj by Muslim citizens was a consequence of this Article 29, Paragraph 2 of the Constitution. The similar approach also in the halal certification case, that the court held that the halal product assurance law was made to guarantee the right to freedom of rights of Muslims. This is 2019 decisions. The last model, or the fourth model, is to promote maqasid Sharia. This is the case of the status of children born outside official marriage. The court has invalidated a long-standing legal rule stipulating that a child born outside an official marriage has a civil relationship only with its mother and not with its father. The court ruled that a child born outside formal wedlock does have a civil relationship with the man who, through scientific, technological, or other means, can be proven to be its father. For the court, it is not correct and unjust for legal rule to say that a child born outside official wedlock or through an extramarital relationship has a relationship only with its mother. And then I would argue that such decision is based on hifzun nasr as one of the elements of maqasid Sharia. Another interesting decision on this model is on child marriage. It is a court decision that may pave the way for the elimination of rampant child marriage in Indonesia. In 2018, the Constitutional Court ruled that the 16 years old minimum age requirement for women to marry was unconstitutional, because this is a discrimination between a woman's and man's age of marriage. And the court argued that the man can marry was 19, while then the woman only at 16. Therefore, this is contradiction of the Constitution. So, and again, despite the fact that the Islamic law, traditional Islamic law, will justify the young marriage, the child marriage, but the court here said that it's no longer constitutional, and this is based on hifzun nasr, in my view, one of the elements of maqasid Sharia. So, as a conclusion, the Indonesian Constitutional Court decision could be seen as performing its collective ijtihad. There are at least 4 models of the court decision which could be read in light of Islamic law reform to justify a state religion model in a nation state, to confirm the approach taken by Indonesian Muslim scholars to incorporate Sharia only in a selected area, to impose the state's duty in administering and facilitating religious freedom, and finally to promote maqasid Sharia. Arguably, these four models of the court decisions have implications for the Islamic law reform discourse. Thank you very much.
Thank you so much, Narisa Hussain. It's quite awkward if I not call you by Professor. Sometimes I call you Gus Prof. And it's very enlightening presentations. You're trying to answer to what extent that the court's decision have implication for the Islamic law reform discourse. And you conclude that the Indonesian Constitutional Court could also perform collective ijtihad when dealing with legislation related to Islamic law. And four models that you introduce, the court decision concerning the Islamic law reform discourse, will be a very good literature and reference for all of us as an academics here. Thank you so much once again. And for the second speakers, I would like to invite Professor Farid to present his paper entitled "The Malaysian Court as the Arbiter of Competing Narrative on the Essence of the Constitutions, Watching the Pendulum Swings." And you have 20 minutes to present your papers. Professor Farid, the floor is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Their Excellencies, Honorable Justices of the Constitutional Court of the Republic of Indonesia, the Honorable Secretary General, Professor Guntur Hamzah, Brother Moderator, Dr. Pan Muhammad Faiz, fellow panelists, Prof. Narisa Hussain, Dr. Dian Shah, esteemed guests and colleagues. First, thank you for the invitation for me to speak in this plenary session. It is an honor to receive the invitation from the Constitutional Court of the Republic of Indonesia to share some of my thoughts with the participants, with the colleagues. My topic will be on the Malaysian Court as the arbiter of competing narrative on the essence of the Constitution, watching the pendulum swings. Constitution provides the basic principles, structures and processes of the state together with fundamental liberties as a higher law that is not subject to ordinary legislation. It also expresses the shared values and ideals of the people, including the place of religion in the private and public life. The position of Constitution as a higher law, coupled with usually the expansive, deliberative process in formulating the basic law of the state, provides the public legitimacy to the constitutional document. So the general language of the Constitution, combined with the necessity to reflect on the constitutional history and underlying constitutional principles, makes a Constitution susceptible to competing narrative outside and inside the courtroom, when the court is compelled to interpret and apply the sometimes nebulous and elusive constitutional provisions and values. So the court, representing the apolitical organ of the government, in contrast to the legislature and the executive, is expected to adjudicate independently between the competing narrative of the Constitution. So the Malaysian experience extracted from the judgment of the court shows the difficulty of the court in weighing the contending narrative, which equally asserts to represent the essence of the Constitution. It could also be seen that the court is moving from one end to another in proclaiming which narrative prevails. If we look at the competing narrative in Malaysia, you have one, the role of Islam in public sphere continuing to be debated. With the onset, if you look at history, with the onset of Islamic resurgence in Malaysia, the competing narrative is heard louder. At one time, the government declared, to the surprise of many, that the policy of Islamization in the administration of public sectors. We have the Muslim activists, such as the leader of Muslim Youth Movement of Malaysia, Anwar Ibrahim, co-opted by Dr. Mahathir Mohamad into Barisan Nasional, the coalition government, until his unceremonious dismissal as Deputy Prime Minister in 1998. And you have the declaration of Dr. Mahathir Mohamad in 2001 that Malaysia is an Islamic state. So although such political maneuvering could be seen from the perspective of political competition, in particular between UMNO and PAS, The concrete action taken to elevate Islamic institutions, including Sharia courts and legislation relating to Islam, could not be negated. On the other hand, some would view such development with concern, including the impact of Islamization on the democratic principles. A secular character of a state is seen as the panacea of plurality of ethnicity and religion in Malaysia, where everyone would be treated equal. Everyone would be subjected to one state law and one state court, for instance. The belief that secularism could offer neutrality in multi-religious and multi-ethnic society sometimes is misplaced. Secularism is itself an ideology that seeks to divorce everything from the sacred. Secularism disenchants nature and desecularize politics without completely deconsecrating values, since secularism brings up its own system of values. Secularism in this respect is not neutral. It sides with religion or ideologies that view religion as having no role in public sphere or manifestation in the public. Thus, for those who has the understanding his or her religion requires manifestation in public, would be sidelined by secularism. France provides an example where secularism for some Muslims failed them as French citizens. Their manifestation of their belief in wearing headscarf, for instance, for Muslim women, are not allowed in public institutions on the understanding that this will taint the neutrality of the government. The illiberalism of secularism is sometimes overlooked. This could be seen from the cases relating to the European Convention for Protection of Human Rights and Fundamental Freedoms. For instance, the Leha Sahin case from Turkey, the old case. And recently, the European Court also allowed employer to prohibit employee from wearing headscarf if the corporation worries, for instance, that the customer will be uncomfortable dealing with employee with headscarf, probably because of their prejudices. So, and for the paramount importance of neutrality. So, coming back to Malaysia, what is in a word? Perusing the Malaysian Federal Constitution, one could find the word Islam repeated in 60 places, the word religion in 68 places. On the other hand, the word secular is absent from the Federal Constitution. Article 11, for instance, provides that everyone has the right to profess and practice his religion. The Federal Constitution provides that Islam is the religion of the Federation. It also provides that state law and federal law may control or restrict the propagation of religion among Muslims. It also provides every religious group has the right to establish and maintain institutions for the education of children in its own religion. Since Islam is under state matters, the Federal Constitution allows for the state to enact laws relating to Islam and to establish Sharia courts to administer Islamic law among Muslims. Although the word secular is absent from the Federal Constitution, commentators have been at pains to point out that the alliance, the coalition of political parties representing the major ethnic group in Malaya at the time, in proposing a declaration of Islam as the religion of the Federation, in the Constitution for Independent Federation of Malaya, has stated in the memorandum that such provision does not imply that the state is not a secular state. Additionally, Justice Abdul Hamid, a member of the Constitutional Commission, tasked with drafting the Federal Constitution, considered in his note to insert such a provision that such provision is innocuous or not really important. The Alliance government, in supporting the tabling of the draft constitution, asserted in the white paper that such a declaration in no way affect the present position of the Federation as a secular state. One would wonder why the word secular, which is repeated in the memorandum, the Constitutional Commission report, albeit in the dissenting note, and the white paper, the report to the Legislative Council, is absent from the Federal Constitution itself. Many commentators have spoken about creeping Islamization and stealth theocracy, or the expansion of status of Islam and its related institutions under the Federal Constitution that is upfront, explicit, and repeatedly referring to the word Islam and Islamic institutions. Many commentators have spoken about the need to defend and to elevate the secular position, a word that the basic document of the nation has shied away from mentioning. Adopting it could be labeled as creeping secularism, one would wonder. So whose story is in the history in interpreting the Constitution? For some, the Federal Constitution should be understood from the Memorandum of the Alliance, the statement of the father of independence, namely Tunku Abdul Rahman Putra Al-Hajj, the report, and the white paper. Those are generally referred as the framers of the Constitution, the parties that were involved in drafting of the Constitution of the Independent Federation of Malaya in 1957. Absence from this equation is the aspiration of the ordinary people, or the understanding of the, probably we could say, peasants, from the speeches of the alliance politicians regarding the nature of the Constitution in translating the aspiration of the members of the parliament. Absent from this equation is also the constitutional framework existed in the Malay Sultanates that formed the Federation of Malaya, which later became Malaysia in 1963, without which the Federation could not be a reality. This, probably sometime referred to the selective amnesia, could be found in the discussion of legal system. In the discussion of nation court system, for instance, one may refer to the instrument by the King of England establishing court system in states and territories in Malaya, with the inference that there were no court system in the states before the arrival of the British in Malaya. One may also refer to writings about the legal history of Singapore that purportedly only begin with the arrival of Stamford Raffles in Temasek. Putting the starting point of Malaysian Constitution to the point of the joint enterprise of the colonizer, namely the British, with the political parties allowed to continue to operate by the colonizer, would not provide the holistic understanding of the basic document. According to this narrative, the story of Malaysia started with the nation state of the Federation of Malaya, whose political leaders espoused secular nature of the state. The Constitution is modeled after the Westminster system of government, which also at the same time practiced secular character of the state. In this narrative, the constitutional history of the pre-Federation of Malaya is relegated to the history book, without any significance in understanding the construct of the Federal Constitution. The enduring recognition of the indigenous ethnic groups of Malay, Orang Asal, and the native of Sabah and Sarawak, the Sultans and the Conference of Rulers, the explicit declaration of Islam as religion of the Federation, do not amount to much in understanding the Constitution, because of the primacy of secular character of the Constitution, a word that never surfaced in the Federal Constitution. So what's the role of the judiciary? So the judiciary is one of the three organs of government. Its role is to apply the law in its adjudication between the people and the state and between the different organs of government. As a political organ of government, in the sense that it is not connected to any political party, the judiciary is considered independent. The judiciary as an independent organ is apt to be the arbiter of the competing narrative of the essence of the Constitution. It has the expertise and the legitimacy in construing the Federal Constitution. However, in some earlier cases, the court was seen as being hesitant in resolving difficult constitutional questions and took the route of kicking the can down the road, or even kicking the can over the fence to the Sharia court. Fortunately, the court have bitten the bullet with respect to whether or not we agree with such resolution. In this competing narrative, in some respect, the court have taken the central role in its articulation and resolution. Although some of the contestation occur in political and social discourse, involving political parties representing various ethnicity and religion, playing to their respective galleries of supporters, the court were expected to arbitrate because of the inability or unwillingness of the political parties to provide solutions through legislative means. In such contestation, the tools available to the court are limited. The courts could only interpret the law, not making the law. Admittedly, the demarcation between interpreting and making law is no longer an issue. However, in this context, the tools for the legislature could not be compared to the tools available to the court. In construing the Constitution, articulating and resolving the competing narrative, the courts have to ensure that it does not lose its legitimacy in one way or another. The court should not be seen as putting words in the clear text of the Constitution or retracting words inserted in the Constitution. In this context, the courts need to ensure that the tools used is judicially sound. Looking at the decisions of the court in the competing narrative of the essence of the Malaysian Constitution, through the adjudication of cases involving the jurisdictional conflict of civil courts and Sharia courts. It could be observed that the civil courts have acknowledged that the Sharia court as a parallel court system and defer its jurisdiction to Sharia court, where Sharia court have jurisdiction as mandated by Article 1211A of the Federal Constitution that was inserted through a constitutional amendment in 1988. In series of cases relating to apostasy, for instance, where parties in disputes applied for declarations from the civil court that they were no longer Muslims, the civil court declined jurisdiction and requested the parties to head towards Sharia court that have jurisdiction over the subject matter. We have several cases on this. Probably we do not have the time to look at these cases. But what could be seen, for instance, the case of Lina Joy, where a lady who was brought up in a Muslim family embraced Christianity and planned to marry a non-Muslim. Since according to the law, a Muslim could not marry a non-Muslim, she applied for her religious status in the national identification card to be amended from Islam to Christian. The apex courts observed that the question of status of a Muslim, status of faith of a Muslim, should be decided by a court that is competent on the subject matter, namely Sharia court. Thus, the court declined jurisdiction and deferred it to Sharia court in accordance with the constitutional amendment. Among the criticism to such cases is that deferral to Sharia court means a dead end. The criticism goes that Sharia court could not be expected to adjudicate on an application that is considered as an offense under Islamic legislation in the first place. It is interesting to note that Sharia court in several cases have given declaration that applicants no longer Muslim or had never been Muslim. However, beginning in 2016, we see that the civil courts have given decision to the contrary. The court asserted its jurisdiction to hear application for a declaration that a person is no longer Muslim. The case in question, for instance, Azmi Muhammad Azam, where a person who was raised by Bidayah Christian community and never practiced Islam but converted to Islam by his parents, together with their own conversion when he was 10 years old, applied for a declaration that he is no longer Muslim. The court observed that he is exercising his constitutional right to religious freedom, and there is no necessity to refer the matter to the Sharia court. Nevertheless, the courts are not consistent in its judgment. In another judgment of Jenny Peter against the Director of Jabatan Agama Islam Sarawak, decided that an application to leave Islam requires the matter to be adjudicated by Sharia court. So again, the issue of status of faith of a person was brought in Indira Gandhi's case. In this case, the husband from a civil marriage converted to Islam while the wife remained a non-Muslim. He then effectuated the conversion of his children to Islam. The mother applied to void the certificate of conversion that was issued without the mother's consent. The apex court declared that the consent of both parents is required regarding the faith of the children. So in this case, rather than deferring the matter to Sharia court to adjudicate, the civil court affirmed its jurisdiction on the matter. Another series of cases that we may not have the time to refer to one by one is when the court moved from a series of decisions to another is on the expansive reading of Article 3 of the Federal Constitution, which provides that Islam is the religion of declaration. So in some cases, the court refers to that provision, that general clause, to say that there is primacy position of Islam. In other cases, the court declined to do so. The court disregard that line of argument. So we see the cases on the use of the word Allah in the publication of the Catholic Church in Malaysia. We see the cases on the question of the constitutional right of Muslim to manifest their religion by wearing turban and so on. And we have the recent case of Iki Putra, where the federal court considered the challenge of validity of one of the provision in the Sharia criminal offences of Selangor, under which the applicant was charged for attempting to commit sexual intercourse against the order of nature with certain male persons. The respondent, namely the state authority, tried to argue in using Clause 3.1 of the Federal Constitution that says Islam is the religion of declaration. but this was not entertained by the court in granting leave for the matter to be trial, to go to the next stage of having a trial proper. So this would be an interesting case to consider when the case is brought to the trial proper. And then we have also the recent case of Maksud Ahmad regarding the Ahmadiyah followers in Malaysia. What's their status as a Muslim or as non-Muslim? Because we have fatwas, we have decision of the courts and so on. So this would be another interesting case to look at, where the court seems to provide better clarity in the jurisdiction of the court regarding apostasy. In ending my presentation, some commented that action of civil courts to defer to the jurisdiction of Sharia courts and to be sympathetic to the position of Islam under the Constitution will polarize the country. However, it should be noted that denying the jurisdiction of Sharia courts and asserting the jurisdiction of civil courts will do the same. If we acknowledge that there is a divide, then deciding one way or another will polarize the community. Religion is not only dear to Muslims, it is also for non-Muslims. Recent talks about new law restricting propagation of other religions among Muslims invite criticisms from non-Muslims regarding their rights to propagate their religions, although such laws are inconsistent with the Federal Constitution that allows for laws to restrict propagation of religion among Muslims. Judges also receive criticism in deciding one way or another. In some commentaries, Muslim judges were accused of unable to discharge their duties if their decision give way to deferral of jurisdiction to Sharia courts or the perceived cause of Islam. However, the same commentaries did not ascribe the same level if the decision is converse. The converse could also be true for non-Muslim judges. Such a labeling of judges is not helpful to the discourse. It is important in this highly contentious narrative that the courts are seen to be deciding as a neutral body. It is not about which divide that the decision of the courts lay. It is about whether the courts have stayed true to the aspiration that a document that articulates the coming together of people with different ethnicity, religion, and worldview, using a coherent approach of constitutional interpretation. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much, Professor Farid. You used your time very wisely, and that's very interesting presentation. We'll learn many things from the Malaysian court's experience concerning the difficulty to competing narrative of the essence of the Constitution, and I believe these difficulties are also faced by other countries, including Indonesia. But I will not spend more time by repeating your representations because we will elaborate further on this issue during the respondent and Q&A sessions. Next, we will move to the last speakers of these plenary sessions. We are going to discuss in the higher level, not only in a specific country, but in Asia, to what extent the dimension and dynamics of religion and constitutional practice in several or comparative countries. So the speaker who will deliver her presentation is Dr. Diansah on religion and constitutional practice in Asia, dimension and dynamic. And Dr. Diansah also wrote a book on the politics of religion and constitutionalism in Asia, published by Cambridge. So without further ado, I would like to give the floors to Dr. Diansah.
Thank you, Dr. Faiz. If I can have my slides on the screen, please.
Yep, the committee will share your slide.
Yeah, I'm not able to see it here. Is that what is intended?
Not yet.
Okay, good. Excellent. Okay, Assalamualaikum, good morning, selamat pagi, honorable judges, distinguished guests, panelists, ladies and gentlemen, participants of this international symposium. First, I'd like to thank the organizers, teman-teman panitia, for your organization and for inviting me to speak in this plenary panel. Terima kasih. It is nice to see Nadir, who I've not met in a long time, and also to see Prof. Farid, albeit via Zoom. Next slide, please. Now, in my presentation today, I intend to sketch some patterns on constitutional practices on religion in Asia. What I mean by constitutional practices is not just decision by courts on issues involving constitutional interpretation, but also how the Constitution is perceived, interpreted, applied, and invoked by a range of actors and litigants, including the state or government and the public, on a range of matters implicating religion. And I'm glad, perhaps by accident or by design, that the two speakers before me, Prof. Nadir and Prof. Farid, have both addressed individual jurisdictions. So my approach is to analyze things at a more macro level. And the hope is that this will show us that there are differences as well as similarities with regard to the Asian experience on religion and constitutional practice. Now, to get into my main arguments, I will first set the scene using the case of Indira Gandhi in Malaysia, which Prof. Farid has alluded to earlier on in his presentation, but I'll go into the little granular detail. So this case involved a long battle on custody and religious conversion of children. Indira Gandhi is a mother of 3 children who were converted to Islam without her knowledge by her ex-husband, who converted to Islam or embraced Islam at some point during their marriage. Now, the children were born and raised in the Hindu faith. And Indira's marriage to her ex-husband was contracted under civil law applicable to non-Muslim marriages. So in 2009, after discovering that her children's conversion had been effected by the husband, Indira challenged the validity and legality of that conversion. And in a separate suit at the civil court, she obtained custody of her 3 children. But her husband went to the Sharia courts first without Indira's knowledge, and the Sharia court then granted him custody of the children. So what were the specific issues here? I will highlight 2 for the purposes of this presentation. The first was a question about parental consent on conversion of children. Article 12.4 of the Malaysian Federal Constitution cements parental rights over a child's choice of religion. But the question was, does this provision require consent by one parent or both parents? Because in this particular case, it was clear that only the husband went through this, or rather took the children through this conversion process without the knowledge of the mother. Then, second, we have this issue of jurisdiction. In Malaysia, issues relating to personal and family law of Muslims and what is called offenses against the precepts of Islam are exclusively under the Sharia jurisdiction. What this means is that in these issues, the Sharia courts have the final say. They cannot be adjudicated by or appealed to the regular civil courts. So in this case, the question then was whether the conversion of the children was valid. And because the children are now Muslims, and this is a question about conversion, can the civil court determine the validity of that conversion? Now, this is a very important question in Malaysia's context, because for many years, civil courts, on the basis of this provision, giving exclusive jurisdiction to the Sharia courts only in specific areas, the civil courts had the tendency, nonetheless, to decline jurisdiction whenever a matter involves Islam in general, even if that matter raises constitutional issues or constitutional interpretation questions. So the decision of the Federal Court in 2018 was an important decision for a number of reasons. First, the court held that the federal constitution mandates that the conversion of minors require the consent of both parents. And then stressing the role of the judiciary in upholding the rule of law, the court held that judicial review is an essential feature of the basic structure of the Constitution. And because of this, for the court, the civil court remains empowered to review the legality and constitutionality of a public authority's administrative action or decision. In this case, the religious authority who decided to issue the certificate of conversion for Indira's children without her knowledge. So aside from these specific issues, this case raised broader questions related to constitutional practice on religion. There are 4 questions here. Can you please switch the slide? How are the disagreements and political concerns of different groups and stakeholders embedded and expressed in key cases implicating religion? So this is at the level of society. Second, what factors might shape the outcome of majority-minority contests implicating religion? And following from that second point, to what extent does the dominant religion or considerations about religion more generally drive the prevailing constitutional discourse and practices in any given country? And finally, do constitutional arrangements on religion matter? And if so, how and when do they matter? At this point, I want to move into these broader questions raised by Indira Gandhi, and I want to look at patterns and trends in various jurisdictions in Asia. Next slide, please. The first is to consider constitutional arrangements. Asia is a fascinating laboratory for studies on state-religion relations and majority-minority relationships. There is a rich diversity at the societal level, and there is also a broad tapestry of state-religion arrangements that fall somewhere along the secular theocratic continuum, as you can see here on the slides. Some arrangements reflect and correspond to the religious demographics of the state in the sense that there is some form of constitutional preference or privileging of the majority religion. Other arrangements adopt a relatively quote-unquote neutral posturing or attempt to recognize and balance majority and minority religious interests, despite the prevalence of a dominant religious group. So a good example here is the Philippines and India. They adopt a secular arrangement in their constitutions, despite the presence of a strong Catholic majority in the Philippines and a strong Hindu majority in India. Even in the Muslim majority states in Asia, such as Afghanistan, Pakistan, Malaysia, Indonesia, there are also different permutations on state-religion relations. Afghanistan, Pakistan, and Malaysia, for instance, constitutionalize Islam as the state religion with religious freedom guarantees for other religions. But in Indonesia, the constitution provides that the state shall be based on the belief in the one and only God and guarantees the freedom of worship, each according to his or her religion or belief. In practice, however, the operation and evolution of these arrangements can be quite unpredictable, sometimes with even adverse or perverse outcomes. In Malaysia, for instance, the provision on Islam as the religion of the Federation has been used to justify restrictions on rights, on religious freedom, even though there is a clear sub-provision, Article 3.4, stating that the recognition of Islam shall not affect other provisions in the Constitution, including fundamental rights guarantees. In India, despite the constitutional promise of secularism, judicial approaches on politically charged questions about Muslim personal law have led to the erosion of Muslim women's rights due to the court's reluctance to subject personal law matters to fundamental rights scrutiny. This was evident, for instance, in the Sharia Banu case, or what is popularly known as the triple talaq case. Similarly, even though the Philippines has an American-style arrangement on religion-state relations, scholars have highlighted evidence of the persistent influence of a Catholic ethos in statutes, case laws, as well as state policies, especially those implicating religion and family matters. So, next question, slide please, the following slide. How do we then understand these patterns of constitutional practice on religion? I want to raise here a few contextual considerations that shape constitutional practices on religion in Asia. Some of the features here, as you can see on the slides, I must say do overlap and they are interlinked, but they give us an idea of the environment that courts have found themselves in and are continuing to face in adjudicating cases on religion. I'll go to the first point, majority-minority dynamics in the society, and I will consider this with a point on group survival and insecurities. These dynamics and concerns about group survival, ethnic and religious survival, have shaped the development of specific disputes relating to religion and religious freedom. For example, on the issue of proselytization and religious conversion, these concerns have emerged in Hindu-majority India, as well as in countries like Malaysia, Myanmar, and Sri Lanka. The package of race and religion protection laws passed in Myanmar in 2015 grew out of these apprehensions and anxieties about conversion, particularly conversion to Islam, and the perceived rapid minority Muslim population growth. In the Malaysian cases of Lina Joy and the Allah case, as Prof. Farid has mentioned earlier, the courts in Malaysia have suggested that the exercise of religious freedom is subject to broader considerations about the sanctity of Islam and the cohesion of the Malay Muslim community. Now, what becomes clear in many of these cases on religion in Asia is that where there is a dominant group, a dominant religious group in the society, this may trigger certain expectations about the state's behavior toward the dominant religion. So governments and at times courts have also become conscious about the need to protect the interests of the majority, the interests of the dominant religion, or to pander to their sensibilities, even if it means disregarding constitutional commitments, constitutional history, and the spirit underlying those commitments, as well as notions of justice and legality. So these majority-minority dynamics, in my opinion, is both a reflection of and a consequence of the political importance of ethnic and religious identities and the politicization of those identities. In Afghanistan, for instance, the politics of religion shaped constitution-making processes, and the outcome of those processes in the country after the fall of the Taliban in 2001. And we can expect such forces to continue to play a role as Afghanistan rebuilds its country following the withdrawal of the American forces. Similar patterns were also evident and are still evident in Sri Lanka, Thailand, Malaysia, Indonesia, although there are nuances in the degree, the process, and the outcomes. In Malaysia, for instance, religious revival movements in the 1980s, inspired by the Iranian Revolution, sought greater adherence to Islamic norms in governance. So the government responded, and they began pursuing, among others, state-sponsored Islamic symbolism, established institutions, including administrative bodies, to support the development of Islam, and they embarked on reforms of Islamic laws nationwide. For me, these are not problematic per se, but the concern is this persistent trend of utilizing religion and religious identities to serve a political agenda to maintain power. The use of state-sponsored media to propagate an official, state-approved Islamic doctrine and praxis, and the declaration of Malaysia as an Islamic state, for example, these have significantly shaped public psyche and expectations about the constitutional role and force of Islam in the country. Finally, some socio-economic considerations. These issues on religion, as many cases have shown, have underlying socio-economic considerations. Religious observance and the enforcement of religious obligations have become entangled with economic and monetary incentives. In Malaysia, for instance, the federal institution or body that coordinates and spearheads the government's initiatives on Islamic education, administration, and legal policies, this body received approximately 800 million ringgit from the national budget in 2018. So that's one facet of it. The other facet to the socioeconomic story is this. In societies where religious identities are socially and politically salient, in the sense that they provide a sense of group trust, security, and mutual benefit, competing religious rights claims may be viewed as a matter of group survival. And that question of survivability is often painted as a game of numbers, tied to political survival. The common story is that the majority, for instance, the Sinhala Buddhists in Sri Lanka, the Buddhists in Myanmar, or the Malay Muslims in Malaysia, they are vulnerable in the face of the growing population of the minorities, be it through biological reproduction or through proselytism backed by superior financial strength of particular religious groups. So the anti-Muslim campaign in Sri Lanka, for example, has not only targeted Muslim practices that are deemed offensive to Buddhism or to Buddhist principles and values, but they are driven by fears that Muslim population growth or the building of mosques will eventually displace the country's Sinhala Buddhist character. And these fears are in turn powered by the perceived Muslim dominance in business and trade, and these are seen as a threat to the economic prosperity of Sinhala Buddhists. And we see similar stories of this, as I said, in countries like Malaysia, India, as well as Myanmar. So I'll stop here for the moment, and we can discuss some of these considerations, contexts, and patterns in the Q&A session. Thank you.
Thank you so much, Dr. Diansyah, for explaining several interesting cases implicating constitutional law and religion, such as the Indira Gandhi case in Malaysia concerning parental consent for religious conversations. And Dr. Diansa has raised 4 important questions on this case, and then comparing variety of arrangement from different countries, such as Indonesia, Malaysia, Sri Lanka, Thailand, and Philippines, by bringing several contextual considerations from majority-minority dynamics, socio-economic consideration, group survival insecurities, to politicization of religions. That was a very fruitful explanation. Thank you so much once again, Dr. Diansa. Now we are moving to respondent sessions who will give comment or questions to the speakers. We have 3 respondents here who are researchers from the Constitutional Court of Indonesia. They are Muhammad Mahruz Ali, and then Bisariadi and Anantia Ayu. Respondents are free to give short comment or question to any speakers, but I will collect all comments and questions first, then from the 3 respondents, then the speaker can answer it one by one. If we still have time, we will give opportunity also to the participant to ask directly questions. Just raise your hand, then I will invite you to convey your questions. Now we will start from Mahruz Ali.
Thank you, moderator. Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen, speakers and all participants. First of all, I would like to thank this valuable chance, and it's an honor for me to directly discuss with distinguished speaker, Professor Nader Hussain, regarding Islamic law and Indonesian Constitutional Court decision. Secondly, I would like to appreciate the substance of the article, which was presented very clearly and provide comprehensive description of how relationship between reform Islamic law and Constitutional Court decision. As a researcher of Constitutional Court since 2009, I have extensively researched the model and implementation of Constitutional Court decision, including those related to Islamic law. The Constitutional Court decision is very dynamic and contextual with the conditions of the people. The Constitutional Court decisions not only review a law against the Constitution, but provide constitutional value in each of its decisions. I argue of some decisions are difficult to implement due to the different interpretation of the decisions by other court, especially the court under the Supreme Court or Mahkamah Agung. The speaker conclude that there are 4 models of Constitutional Court decisions have implication for the Islamic law reform discourse, which are summarized from several decisions. Namely, I found here 8 decisions regarding blasphemy law, the authority of Constitutional Court to extend the restriction of religious court, the criminal code and concerning unmarried sex, and the zakat management and Hajj pilgrimage costs and halal certification, and last 2 decisions regarding the status of the children born outside official marriage, or we call the Matica Mukhtar case, and then the last is minimum age requirement for marriage. Besides that, the speaker also explained about the Constitutional Court is to promote the Maqasid al-Sharia, which consists in complementary religions like Hafz al-Din, Hafz al-Nafs, and Hafz al-Nasl, and also Hafz al-Mal and Hafz al-Aql. The concept of Maqasid al-Sharia is related to the last 2 decisions, number 46, 2010, regarding the Matica Mukhtar case and also the minimum age requirement for marriage. These 2 decisions have provided a shifting paradigm in Indonesia regarding to marriage law. However, in the other hand, the decisions, or we can say Matica case, is difficult to implement because there are different interpretation and perspective in other courts, such as in Supreme Court or under the court under Supreme Court. This is one of the obstacles how the applicants achieve the justice. The Supreme Court or the court under like a religious court, sometimes only carry out what is regulated in the law and do not refer to the constitutional court decision. In the other words, the constitutional court decision is not considered by the judge in deciding the case. In addition, the legislator must revise the law according to constitutional court decision. So this is the two problem here. The obstacle or the hindrance to implement the constitutional court decision from the other courts and also from the parliament to revise the law based on the constitutional court decision. So the reform of Islamic law through legislation facing many challenges, even though the constitutional court decision is final and binding, and the constitutional court decision is equivalent to the law. So the justice delay after the constitutional court decision, while the constitutional court always stated justice delay, justice denied, it should be avoided. While the constitutional court decision itself implementing decision. At this point, I would like to discuss a few related to the constitutional court ijtihad, or as Prof. Nadir said that ijtihad is the same as interpretation. How the Indonesian constitutional court should interpret the constitution, especially related to the Islamic law, so that it's more easily to implement by the executor and the fulfillment of justice seeker constitutional right. So I hope this question and also response will be addressed by Professor Nadir. Thank you very much, Mr. Vice.
Thank you, Marus Ali. You raise a questions or problem, even or concerns. What about the implementation of the court itself? And the interpretation is various when it is implemented in ordinary court, and also differentiation between ijtihad and constitutional interpretations. Thank you so much, and probably it will be answered by Professor Nadir later. Next, we will move to the second respondent, Bisariadi.
Thank you, Mas Faiz. Assalamualaikum warahmatullahi wabarakatuh. And good morning. I do have 3 questions, one for each speakers, and I try to elaborate or ask these questions briefly. And for Pak Nadir, I found difficulties about distinguishing public and private in Islamic law, in the practice of Indonesia, to be exact. Now, especially regarding the power of the religious court. Now, in Indonesia, religious court have the power on civil matters. The religious court is regarded as family court. But then again, the power of the religious court in Indonesia is a bit, there's a practice of extending its power, not just on civil matters, but also now they have the power to adjudicate Sharia finance or Sharia banking issues, if there are parties who are willing to settle their problems in the religious court. Now, it is not just in the religious court in Indonesia, but also then there's these difficulties about trying to distinguish between public and private in the constitutional sphere, in the constitutional jurisdictions, as you mentioned, so that many of the constitutional court rulings also touch upon the Islamic or the issues between religion and state. Now, how do you see this problems about distinguishing public and private within the constitutional spheres? And more exactly, what it is in the practice of the Indonesian law. And to touch upon that, for Prof. Farid, do you see the same problems also happened in Malaysia about this distinguishing public and private? And do you see this problem is more troubles in the state levels rather than in the federal levels? I see much of those cases that you elaborated in your presentations, much as touch on the state cases, right, rather than in the federal cases. And my final questions for Mbak Dian. One of your slides mentions, oh, Mbak Dian, good to see you again. One of your slides mentions about the constitutional contextual considerations. There are 4 points that you mentioned, but that's I see that in the perspective of society or in the political system. Do you see there's also a considerations on the legal matters? For instance, does the legal traditions or whether this country have the traditions of common or civil law matters to these contextual considerations on constitutional practice on religions in those countries? I guess that's it.
Thank you so much, my colleague Bisariadi. First, one question for Nadir Shah regarding difficulty in distinguishing public and private law regarding religious courts. Similar question to Professor Farid. And for Dian Shah, is there any consideration on traditional legal matters on constitutional practice? We still have one respondent, Ayu. Please.
Hello, good morning.
Yep. Please, you can raise your question or give a comment.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, Excellencies, ladies and gentlemen, dear colleagues. First of all, I'm extremely pleased to be here, and I'm honored to have been invited by the committee to address this conference. And I'm particularly pleased to have been given the opportunity to listen to these great presentations and right to respond to Dr. Dian Shah this morning. This morning, I want to respond to Dr. Dian's remarks with the title, The Law and Politics of Religion and the Constitutional Practices in Asia. But I also want to share with you some impressions as opening, maybe remarks for further thought. There are namely 2 issues that I want to highlight. First, the role of the judiciary in upholding the rule of law and shape the relation of religion and constitution. From the cases that you brought into discussions, we can see that court and jurisprudence shapes the religion and state relations in general and the right to freedom of religion in particular. If we talk about the freedom of religion, it is widely known as one of fundamental rights. The issue came with the questions, are the freedom of the majority religions has the same term of the freedom of the minority or disadvantaged group? I see that the court has strong role with the judiciary discretion in order to protect fundamental right of the minorities or disadvantaged group. You are addressing Indira Gandhi case where the court, despite the legal and political tension from majority religions, decided to review the validity and legality of the register of Mu'alaf decisions to issue the certificate of conversion for Indira's children. Furthermore, the court, whether it is Constitutional Court, Supreme Court, or regular court, should realize and aware of their current and future contribution as key institutions that shape religion and state relation, as well as protecting rights of minorities through their judgment and jurisprudence. Second, this role has its consequence. When it comes to state religion cases, which is handling by the court, it certainly produces legal tension. I'm addressing one of your paragraphs from the paper that stated the presence of a dominant religious group may trigger certain expectation about the state behavior towards the dominant religion. These interactions do not just shape the country's constitutional practice, but they also inform the underlying constitutional culture in matters implicating religion. In society where religious identity are significant, we have Clifford Geertz research and the book named The Religion of Java. He has several research in the villages in Java. The research conclusions stated that religion shape political behavior, whether choosing political parties, political leaders, and pattern of association. The reality of religion in daily life, not only pluralistic, but also formal doctrine that emphasize global standard discourse. In Indira case, the decisions of the court is important because whenever question about the legality and legitimacy of religious institutions have arisen, their justiciability before a secular court has been a bone of contention on the ground that it threatens the autonomy of religious institutions, which are sacred and sensitive, especially for the majority religion. Regarding my comment, I have a few questions. So, how's your perspective in terms of justiciability of the right to freedom of religion on Asia's state? What is current challenge and future prospect in the broader spectrum? Second, in your experience, how court coping with the inner tension in legal order between the individual interest and the general interest, or between law and government policy? And to what extent, what methods does the court employ to diffuse this tension? Thank you very much for your beautiful remarks, Dr. Dian. Thank you also for the moderator, Pan Muhammad Faiz. That's all my comment.
Thank you so much, Ayu. Very nice comments and questions about the judiciary discretions, current challenges in Asia, and method of the court in making decisions. So we will give an opportunity to all speakers to answer all those questions. First, from Nadir Shah Hussein, and then it will be followed up by Professor Farid and Dr. Diansah. Professor Nadir?
Yes, thank you very much for the questions. So I think the problem with the implementations of the court decisions, I think it's not only related to Islamic law cases, but also in other cases as well, like a blasphemy law, or even like in the case of child marriage, for instance. I think there is a tendency for the constitutional court justices that they are really afraid if they make a decision that a particular legislation is unconstitutional, then there will be a vacuum of law, and then it will be a chaos. So then they make some arrangements like they give the time frame for the parliament to revise the law, and then it is up to the parliament how then they could revise the law. I think this is the negative aspect of court decision in the judicial review cases. They could not extend the approach into judicial activism, become the positive lawmaker. So and then and also it's up to the government how to create systems that can easily implement the Mahkamah Konstitusi decisions. So it is not up to justice of the Mahkamah Konstitusi. Their job is only to make a decision which is final and binding. Then it is up to the government and also to the parliament to implement it. And then if there is a questions about how could constitutional court decisions be more easy to implement, to be implemented, I think once again it is not up to the court to do that. And then there is also some issues, like for instance with wedlock cases with the children born outside marriage. There's a strong response from Muslim scholars, particularly Majelis Ulama Indonesia. They even issue fatwa against constitutional court decision. So then there is a problem, which one that we should follow? MUI's fatwa or Mahkamah Konstitusi decisions? From constitutional viewpoint, of course, then we have to follow constitutional court decision because fatwa is not legally binding. Then the government and also the parliament must immediately follow what Mahkamah Konstitusi decision is, regardless what the Muslim scholars say. That's why then I said that despite the fact that it is a standard decisions in many aspects of constitutional court decisions, but the power that they have, that constitutional court decision is final and binding, will have a huge impact. That's number one. And number two, regarding private and public, I'm not really sure how to best respond to these questions, because I cannot see how this relates to my presentations. Because the power of religious court in civil matters, even though it is extended to Sharia finance dispute, but it is still at the civil matters. It's not a criminal law. So, so there is no question actually about the private and public issues in my presentations. The fact that the Constitutional Court rejected the applications to extend the jurisdiction of religious court into criminal Islamic criminal law, that means the position is still the same. The religious courts only dealing with civil matters. And then if you have any dispute about the Sharia transaction with Islamic banking, then you can go to religious court. But if you want to challenge the religious court jurisdiction, then you can go to Mahkamah Konstitusi. I think that's how it works. So I think that's my questions. So thank you very much for those questions. Thank you.
Thank you, Nadir, for your answers. Then we will give an opportunity for Professor Farid to answer the questions.
Thank you, Dr. Faiz. The question that I received from Pak Bisariadi, I think, with regard to public and private law divide. I suppose if, because this came from the presentation from Prof. Nadir, if I could answer it, I'll try. When the term of public and private is used in relation to the discussion on the position of religion, I suppose one is the understanding that that religion only has a place in the private life. Religion has no place in the public sphere, particularly from the context of when you discuss about secularism and so on. So if that is the context of the discussion, then religion has no place in the legislation, in making law, in the policy of the government and so on. Religion has only place at home with the professing of the faith, the act of worship and so on. So that's one context where public and private is used. The second context, probably that's the context that Pak Bisariadi are referring to. With regard to the public law and private law divide. That public law refers to the affairs of the state, for instance, constitution, criminal law, and so on. Private refers to relations between the citizens or between the people, regarding family law, regarding contract. Those are relations between the people, not between the people and the state. So if in the second context, if I want to bring it to Malaysia, of course, in the first context of private sphere and public sphere, so certainly in Malaysia, it's a non-issue because the constitution itself provides provision for law to be made based on religion, on certain matters. So you have the Islamic family law, for instance. You have Sharia offenses, for instance. And of course, the constitution itself says Islam is the religion of the federation, and so on and so forth. So in that sense, it is a non-issue that in Malaysia, Islam certainly is in the public sphere. In the second context of public law and private law, in Malaysia, there is, to a certain extent, the application of Islam for offenses, what is known in the literature as Sharia offenses, offenses specific to the practices of Islam. For instance, the usual example would be about fasting, about praying, or even some conducts, attempted zina, and so on and so forth. So in Malaysia, certainly, to a limited extent, you have the involvement of Islam in the public law. Pak Bisaryadi also asked about the federal and state relationship. Certainly in Malaysia, you have the federation, as opposed to Indonesia, where you have a union, more concentration of power at the union level, at the central level. In Malaysia, there is the concept of distribution of executive and legislative powers, and to some extent, judicial powers. So most of, for Islam, the matters is given to the states, because historically, Islam is state matters, because you have to understand that federation consists of the smaller units of states. So the state exists first, then the state then form a federation. So originally, and this is something close to the Sultanate's position, Islam is under state, so the power to legislate on Islam is given to states. So in this context, you can see all of the legislation. Well, I would not go on in detail, I think the time is not with me, but generally speaking, the power to legislate, the competency to legislate on Islamic matters is given to the state authority. And this raised in the recent case that I gave earlier on Iki Putra, where there is an issue of whether or not the state is competent to enact offenses similar to offenses that you have in the federal penal law. So that would be an issue to be discussed. Thank you.
Thank you, Prof. Farid, for answering those questions. And we'll have last speakers. Dr. Diansa, would you like to give more elaborations and answering the questions?
Yes. Thank you to all the respondents, and particularly Mas Bisaryadi, nice to see you again, and Mbak Ayu for your insightful comments and questions. I'll deal with both questions, i.e. from both respondents at the same time. The first is a question on to what extent do legal traditions matter, whether there are differences between the approaches of courts in the civil law tradition and the common law tradition. And this question also speaks to Mbak Ayu's first question on justiciability of religious freedom in Asia. So, of course, religious freedom issues are justiciable, and they continue to be litigated and addressed by the courts in Asia. But in terms of approaches, I would say that besides these contextual factors that I have highlighted in my presentation, the practices, dynamics, the mode of thought and reasoning in civil and common law jurisdictions do shape how courts approach and decide cases on religion or religious freedom. We know in common law jurisdictions, for instance, the doctrine of stare decisis or binding precedent shapes how courts decide and the outcome of cases on religion and religious freedom. The second is that there is a question of borrowing, especially amongst countries in the common law jurisdictions, borrowing of doctrines and principles. In countries like Malaysia and Singapore, for example, in deciding the parameters of religious freedom, courts have employed what is called the essential practices test, borrowed from the Indian jurisprudence. What this doctrine or test basically means is that the courts will assess if the religious practice in question is essential to the religion. Now, if the courts decide that it's essential, then chances are the courts will step in to protect those practices as part of the protection of religious freedom. So the Allah case, for instance, is one of those instances where the courts used this essential practices test to decide that the use of Allah by the Christians is not essential to the Christian religion, and therefore they said that that is not a practice that is protected by the religious freedom guarantees of the Malaysian Constitution. The third and final point that I want to bring up here, I am mindful about the time. The third and final point concerns the issue of borrowing as well amongst common law countries. But here it's borrowing of another doctrine, which is the basic structure doctrine. This has been applied in Malaysia in the Indira Gandhi case, and the doctrine was originally developed in the Kesavananda case in India, which states that there can be amendments to the Constitution so long as the result does not alter the basic structure of the Constitution. Now, the contextual question that different countries, including in Malaysia, Singapore, these common law countries have had to grapple with is what is part of the basic structure? Again, in Indira Gandhi, the federal court took the position that the federal constitution of Malaysia is premised on certain underlying principles, and these principles include separation of powers, the rule of law, and the protection of minorities. And these are the principles that are part of the basic structure of the Malaysian Constitution, and therefore they cannot be abrogated or removed. So those are my brief interventions or responses to the great questions posed. Of course, we can have a whole day's discussion about this, but I'll stop here. Thank you.
Thank you so much, Dr. Diansa. Yeah, you're right that probably we need more time for discussing these interesting, thoughtful, and stimulating issues. But if I may, I would like to ask permission from the speaker to extend the session just for 10 minutes, since there is one participant who has raised his hand to ask questions from the Dean of Faculty of Law of the University of Brawijaya. But we won't take a time allocation for the next speakers. Don't have to worry, since I received an update, there is a speaker who is unable to attend the symposium due to force measures. So I would like to invite one participant, Dr. Muhammad Ali Shafaat. Probably you can convey the questions or comment shortly, because we are running out of time.
Actually, I have lost my hand because reminding you the time, but my questions to Dr. Diansa, it's you already mentioned about the role of the court in shaping the relation between the majority and the minority. In one hand, you have identified the constitutional arrangement, and on the other hand, you say that this is very dynamic, influences by contextual consideration. Do you have the comparison concerning the role of the court? Whether maybe in some countries the role is control the majority and the minority, so the results not cross the line of the constitutional arrangement. On maybe in the other countries, the courts actually push the amendment of the constitution by his decision concerning the relation between majority and minority. I think that's my question. Thank you.
Thank you. Dr. Diansa, you may directly answer the questions.
It's a great question, and so complicated to put it into words in 30 seconds or in 1 minute. You know, usually I give a whole day's lecture on this, unfortunate for my students. What I will say is this, with respect to the role of the judiciary and how they think about religion cases, and the majority-minority relations. You can see this a lot in the judicial decisions themselves, how the courts reason, what are the considerations that they take into account. In the Allah case, for instance, about the use of Allah by Christians in Malaysia, there are passages in the decisions which, for instance, highlight the court's concerns about what the use of Allah would have to the sanctity of Islam, and how that would cause unease amongst adherents of the majority religion, i.e. the Muslims, because they might view that as something that is inimical or unacceptable to their religion. The idea that there are certain practices perhaps that, or religious freedom issues that perhaps for the majority are seen as a challenge to the cohesion of the Muslim community. So instances like this do play out in judicial decisions, and we can see this in, as I said, a range of case studies in Asia, as well in countries like India or in Sri Lanka. There's another fascinating case in Sri Lanka about conversions as well. Some years ago, there was a private member's bill that was presented in Parliament to basically prohibit proselytization and what is called unethical conversions. And that bill was then referred to the Supreme Court for review. And in one case, the court said that, you know, the practices of forced conversions, or what they call unethical conversions effected through particular socio-economic benefits and so on, would become a threat to the Buddhist religion or the protection of the Buddha Sasana in Sri Lanka. So as I said, these are just two examples, and there are many such examples that we can glean from judicial decisions to see this socio-economic and political factors and how they shape judicial reasoning on religion cases.
Right. Thank you so much for the answers. I hope it could give more perspective, particularly on the Indonesian experience. Well, we have run out of time. Thank you so much for all distinguished speakers who have conveyed their insightful presentation on the issues of court, state, and religion. It was very fruitful discussion where we could discuss it for a whole day, but we don't have enough time. Unfortunately, we don't have enough time and have to move to the next panel session. Thank you also to all respondents and participants for your comment and questions. To conclude this session, I would like to invite all the audience to give a big round of applause to the three speakers in this plenary session. I, Pan Muhammad Faiz, will end this session and give it back to the Master of Ceremony. Thank you once again. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Muhammad Faiz, PhD, as the distinguished moderator for our first plenary sessions. Ladies and gentlemen, we will go to the first panel session for today, and these sessions will be led by a senior researcher from the Indonesian Constitutional Court of Indonesia, Helmi Kasim. Dr. Helmi Kasim as the second moderator for today panel session 1. The time and floor is yours.
the Fourth Indonesian Constitutional Court International Symposium, ICC-IS. Following the success of our previous international symposia in Surakarta in 2017, Yogyakarta in 2018, and Bali in 2019, the Constitutional Court of the Republic of Indonesia will hold the Fourth Indonesian Constitutional Court International Symposium. The Constitutional Court of Indonesia provides an international academic forum to discuss various constitutional issues in comparative perspectives, with the theme Constitutional Court, Religion and Constitutional Rights Protection. The Constitutional Court of Indonesia gives opportunities to legal scholars, researchers, lawyers, and practitioners to participate in the Indonesian Constitutional Court International Symposium. For further information, please visit www.iccis.mkri.id.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen, our distinguished speakers, participants, academics, and every participant who participates in this conference today. In this session, there are supposed to be 3 speakers, but unfortunately we have confirmation from the committee that due to force majeure, one of our speakers from Vietnam cannot join with us, cannot participate with us in this conference. So there will be only 2 speakers in this session. Our distinguished speakers in this session is, the first one is Pak Palguna, Dr. Idewa Gede Palguna from Udayana University. We at the court familiarly call him Pak Pal. Good morning, Pak Pal.
Morning, Helmi.
Dr. Palguna served 2 terms as the Constitutional Court Justice of the Republic of Indonesia. At his first term, being the youngest Constitutional Court Justice at the time. And just not very long ago, completed his second term with the Constitutional Court of the Republic of Indonesia. Our second speaker, Professor Tarun Arora. Good morning from Bandung, Professor Arora. We are very happy to have you here. Professor Arora is from Associate Dean, School of Law, Central University of Punjab in Bathinda, India. Thank you very much, sir, for joining with us in this conference. Our first speaker, Pak Palguna, Pak Pal will provide his insightful comment and presentations on court, religion, and constitutional protection, especially from the perspective of Indonesia. Pak Pal will explore how religion is addressed within Indonesian law and constitution, and how constitutional courts serve or solve constitutional cases related to this matter. Without furthermore giving comments on this on Pak Pal presentation, I would like to just invite Pak Pal. In 15 minutes time, Pak Pal, the time is yours.
Well, thank you again, Kasim. And first of all, I would like to say thank you for the organizers for inviting me to this valuable moment. Distinguished speakers, my fellow distinguished speakers, and all participants to this international symposiums, let me present my presentations concerning protecting freedom of religion and belief and Indonesian experience. First of all, we all know that anthropologically speaking, religions as part of belief system is an important aspect in human life, so does for Indonesians. And the universal understanding of human rights conceptualizes religion as part of civil and political rights derived from natural rights. Meanwhile, we know Indonesia is a nation state which cannot be categorized as secular or theocratic states, because the conception of Indonesian nation was established upon a pluralistic society where diversity in many aspects of life, including religion, is one of its conspicuous features. This conception was the point of departure, as well as the very reason of the adoption of our state foundation, Pancasila, which consists of 5 basic principles, namely oneness of God the Almighty, just and civilized humanity, unity of Indonesia, democracy, which is guided by wisdom in assembly and representation, and social justice for all Indonesian people. And it means that pursuant to principle 1 of Pancasila, Indonesians are free to follow and to adhere their preferred religion and belief. Or in other words, Pancasila guarantees every Indonesian the freedom of religion and belief. Moreover, such freedom is also guaranteed by the constitutions of the Republic of Indonesia, the Constitution of 1945, as well as by law on human rights, meaning that the state bears the constitutional and legal obligation to respect, to protect, and to fulfill the citizens' freedom of religion and belief. In the meantime, there's also many international legal instruments which guarantees freedom of religion and belief, to which one of which, International Covenant of Civil and Political Rights, in which Indonesia is a party to it. It means that there is also an international legal obligation on the part of Indonesia to respect, to protect, and to fulfill the right. But despite such huge guarantees, it doesn't mean that Indonesia has been free from problems arising from or related to freedom of religion and belief. Such problems linger even when the country had just reached its 76 years of existence. Here is where the Constitutional Court plays its pivotal role. Ladies and gentlemen, actually, since the very day of its existence, the Republic of Indonesia had been designed as a constitutional democratic state, and it can be identified from the preamble of the Constitution, of our Constitution. But unfortunately, the idea had never been properly implemented in provision of the Constitution prior to its amendment. Even to some extent, instead of implementing it, the provisions were even contradictory with the preamble spirit. Then it was only logical why amending the Constitution was one of Gerakan Reformasi, or reform movement's principal demands in the 1998-1999. Now, with following the amendment of the Constitution, the shape, quote unquote, of a constitutional democratic state in Indonesia has become apparent. The amended Article 1, Paragraph 2 of our Constitution now says, sovereignty shall be vested in the hand of the people and be executed according to the Constitution. This implies democracy as well as supremacy of the Constitution principle, which is part of the first and foremost characteristic of a constitutional democratic state. The supremacy of the Constitution principle, which is derived from the doctrine of constitutionalism, generally means that all state activities must be conducted in accordance with the Constitution, since the Constitution is the fundamental law of the country. The Constitution owns the fundamental status, as that happens in countries of the same category, because it is construed as the agreement of the whole people of the country. And the constitutional right was established to safeguard these principles. That's why the court is called the guardian of the Constitution. And to that end, Constitutional Court of the Republic of Indonesia was entrusted by the Constitution, in this case, Article 24C, paragraph 1 and 2, with authorities to review the constitutionality of laws, to decide disputes on authorities of states organs whose authorities are given by the Constitution, etc. Another distinctive characteristic of constitutional democratic state is the protections of constitutional rights. And one of the
Apparently a problem with the signal, Pak Palguna.
Yes, sorry.
Turn back to normal, sir. There was a problem with signal, I think, but it is normal now.
I think this problem with my internet. I don't know whether it is because of the COVID or not. Thank you, Helmi. Yes, another distinctive characteristic of a constitutional democratic state is the protection of constitutional rights, where freedom of religion and belief is part of such rights. And it is clearly stated in our Constitution. Article 29, paragraph 2 says, the state guarantees the freedom of every resident to adhere his or her respective religion and belief, and to worship in accordance with her or his religion and belief. While Article 28E, paragraph 1 says, everyone shall be free to adhere a religion and to worship according to her and his religion. Paragraph 2 says, everyone shall be entitled to freedom to adhere a belief. And more importantly, Article 28I, paragraph 1, even expressly states that the right to adhere a religion, together with some other rights, as part of a non-derogable right that cannot be reduced whatsoever. The court safeguards these constitutional rights in general and freedom of religion in particular through its authority to review the constitutionality of law. It means that if there a law is proven not in line with the Constitution, either its process of enactment or its substance, the court will declare the law unconstitutional and no longer has its legal binding power. Now, according to the current mechanism, those who have standing to file petition for constitutionality of law before the court are parties who consider their constitutional right or authority has been infringed by a law, namely individual citizens, traditional communities with certain conditions, legal entities, and state institutions. Ladies and gentlemen, the quite phenomenal example of the court's decisions related to freedom of religion and belief is the decision number 97, 2016, as has been referred by Honorable Justice Eni Nurbaningsih earlier. In short, the case position was as follows. Some Indonesian citizens who adhere indigenous beliefs filed a petition of judicial review on law on population administration as with claim that some of the law's articles were unconstitutional for containing discriminatory substances against the rights to adhere indigenous beliefs, which were guaranteed by the Constitution. Those articles were Article 61, paragraph 1 and paragraph 2, Article 64, paragraph 1 and paragraph 5. according to paragraph 1, 60, Article 61, paragraph 1 of the law, every family card consisted of columns, including religion column. This column indicating the religion adhered by the relevant resident. And paragraph 2 of the article stated that for residents whose religion was not yet recognized according to relevant legislation, or those who adhere indigenous belief, the religion column should be left blank, yet the resident concerned will still remain be served and be registered in population database. Now, while Article 64, paragraph 1 of the law contain provision concerning substances that should fill the content of an electronic ID card, which in which religion was one of it. While paragraph 5 of the article 64, I mean, contained provision which was very similar to Article 61, paragraph 2 I mentioned earlier. In 18th of October 2017, the court handed down its decision that fully granted the petition. The court of the opinion that the petition was founded and ruled accordingly that the word religion in Article 61, paragraph 1 and Article 64, paragraph 1 was conditionally unconstitutional and had no legal binding power if the words, if indigenous belief were not included in it. While as to Article 61, paragraph 2 and Article 64, paragraph 5, the court ruled those articles were unconstitutional and had no legal binding power. The legal consequences of the court decision was, by referring to Article 47 of the Law on Constitutional Court, since the very moment of the decision was read out, the word religion in the Law on Population Administration must be interpreted legally to include indigenous beliefs, so that the religion column in the family card and in the electronic ID card of those who had had indigenous beliefs no longer left blank. Ladies and gentlemen, the only way the court safeguard the citizens of the Republic constitutional right, particularly the right to freedom of religion and belief, is through its competence to review the constitutionality of law. The court even has no authority to control its own decisions, let alone to enforce them. While infringement of constitutional rights, including freedom of religion and belief, occurs not solely because the existence of unconstitutional law, but also even mainly by acts or omissions of public officials. Let's take the decision number 97, 2016, mentioned above as an example. Though it's already been 4 years, the decision does not automatically end the discriminatory treatment to those who adhere indigenous beliefs. A prominent national daily just recently reported for 2 successive days cases in which discriminatory treatment toward those who embrace indigenous beliefs continued, and the reluctance among government officials to accept them remain unabated despite they knew the court decision. You can read the Compass Daily of 31st of May and the 1st of June 2021. Now, in many countries, problems concerning violations of constitutional rights caused by act or omission of public officials, and where there is no legal remedy is available, or all available legal remedies have been exhausted, are called constitutional complaint cases. Those countries anticipated these cases by entrusting their respective constitutional court with competence to adjudicate cases of constitutional complaint. But that is not the case here in Indonesia. Here, the court has no such competence, since the our constitution exhaustively limited the court's competence as described in Article 24C, paragraph 1 and 2. Then, strictly speaking, if we want the court to have competence to adjudicate constitutional complaint cases, it could only be done by formally amending the Constitution, which is, to my understanding, for the time being, and in the near future, neither visible nor feasible, except something extraordinary occurs. Yeah. This raises a serious question. Is there any possibility for the court to have competence to adjudicate such cases formally amended the Constitution? I would like to say, I'm sorry, can you hear my voice? Helmi?
Yes, we can hear you, sir, very clearly.
Thank you, thank you. Just curious, because there is some problem, I think, in my internet connection. I would like to say, theoretically, the answer is yes, there is. Because both judicial review, in terms of abstract review on constitutionality of law, and constitutional complaint are derived from the same source, theoretically, namely constitutional review, which is the function of any constitutional court in every country around the globe. Constitutional review itself, according to a prominent constitutional lawyer, Hausmaninger from Austria, is the product of a modern democratic system of government based on the ideas of rule of law, separation of powers, and the protections of fundamental rights. It has two major tasks. Firstly, to safeguard the functioning of democratic processes in the interplay of legislative, executive, and judicial institutions. And secondly, to protect the individual citizens against the encroachment of any state power in the citizens' private sphere of life. Judicial review and constitutional complaint mechanism are derived from the latter task of constitutional review. The purpose of both is to protect citizen constitutional rights. Judicial review protects constitutional rights by annulling unconstitutional laws, while constitutional complaint protects such rights by scrutinizing public officials' act or omissions which infringe citizen constitutional rights. From the above-mentioned theoretical perspective or point of view, in the case of Indonesia, there are two ways to make adjudicating constitutional complaint cases become the court competence without formally amending the Constitution, to my opinion. The first way is through legislative interpretation, which is theoretically called authentical interpretation. If this is the choice, the lawmaker only needs to extend, quote-unquote, to extend the scope of the term judicial review or pengujian undang-undang in bahasa Indonesia in the provisions of the law on constitutional court, so as to include review on public officials' act or omission, which is considered infringe some citizen constitutional right. If this is the case, adjustment to the law on constitutional court is unavoidable. The second way is through judicial interpretation. If in this case, it is the court who should make an interpretation when adjudicating cases brought before it that the term judicial review of law not only deals with questions on the constitutionality of law norms, but also the constitutionality of public officials' act or omission. In this case, the question is not whether a law is unconstitutional or not, but whether some public officials' act or omission has failed to obey some particular laws so as to infringe or violate some constitutional rights of a particular citizen.
Sorry, Pak Pal, to intervene.
Second way, yes.
Sorry to intervene, Pak. Apparently, our time is for this is come nearly to a close for your presentation, sir. Would you please?
Okay.
Yeah.
May I have time for my conclusion, please?
Yes, sir. Go ahead, sir.
Okay.
Sure.
Let me conclude. I'm sorry for before elapsing the available time, let me jump to the conclusion that, okay, the first conclusion is that Indonesia is a nation state. The concept of an Indonesian nation was established upon a pluralistic society in which diversity in many aspects, including religions, in religion and beliefs, is one of its conspicuous features. This is the very foundation of the adoption of Pancasila as our state fundamental, which consists of 5 basic principles, where freedom of religion and belief of Indonesian is derived from and guaranteed by the first principle of Pancasila. Indonesia is a constitutional democratic state with uphold supremacy of the constitution. The constitution is considered supreme, like in every country which upholds supremacy of the constitution, because it is construed as the agreement of the whole people. So that's the Constitution of the Republic of Indonesia. And protections of constitutional right is another feature of a constitutional democratic state, in which freedom of religion and belief is part of such rights. And because such rights are part of the Constitution, it is also part of the Constitutional Court to safeguard such rights. And referring to the current mechanism, the Constitutional Court can only protect the constitutional rights of the country and freedom, especially freedom of religion and belief, through the mechanism of judicial review, in which the court may declare a law unconstitutional and no longer has its legal binding power if the law infringes or violates citizen constitutional rights in general, and especially freedom of religion and belief. And here now there is a pressing need for the court to be equipped with competence to adjudicate constitutional complaint cases, since the infringement of constitutional rights, especially freedom of religion and belief, occurs not only by the existence of some unconstitutional laws, but also, or even primarily, by act or omissions of public officials who fails to implement some particular law or some decisions of the Constitutional Court. But to equip the Constitutional Court with competence to adjudicate constitutional complaint cases does not necessarily need a formal amendment of the Constitution, for it might be done by legislative interpretation or authentical interpretation to the law on the Constitutional Court, or by judicial interpretation made by the Constitutional Court itself. Thank you very much, and I'm sorry for the time elapsed. Maybe I have encroached another speaker's time. Thank you.
Thank you very much, Bapak, for very insightful presentations and comments. One interesting point, I think, is the lack of being fundamental rights of citizens, protection of constitutional court, protection of religion, still lacks of judicial forum, especially in relation to the constitutional court competence, which is why constitutional complaint is one of a way to solve the matter. Next, thank you very much, Bapak. And now I would like to invite my fellow researcher, respondent, Dr. Nalom Kurniawan, to respond, comments, or to ask questions and provide insightful comment on the presentation of Bapak Palguna. Time is yours, Mas Nalom.
Thank you, moderator, Mas Helmi Kasim. And thank you for the opportunity that has been given to me to be a respondent in this session. Ladies and gentlemen, distinguished speaker and participant, we have heard a very inspiring presentation from our former constitutional justice, Pak Palguna. He is also an academician from the Udayana University. I have several notes or questions, Pak Palguna, that maybe we can discuss for this session. First of all, in the concept of protecting the right to freedom of religion and belief, do the agnostics also get the same protection? Some experts say that agnosticism is part of belief that must be respected and protected. But some other experts say that agnosticism is not accordance with Indonesian principle Pancasila. especially principle number 1. I really want to know your view about this case. And the second is, one of the local wisdom of our local wisdom, Indonesia, is gotong royong. So that communal interests based on this principle tend to be prioritized. On the other hand, the principle and values of human rights are more individual. Is it possible if the implementation of human rights values in Indonesia can change culture, our culture, Indonesian people, from communal society become more individual? Third, in today's digital and information era, the behavior of expressing religious teachings and beliefs is very open, especially on social media. This often leads to hate speech and causes conflict between religious communities and also between people in the same religion. I really want to views about this phenomena. Does freedom of religion and belief include the freedom to express in the public? And the last, the fourth, about the cases of blasphemy have occurred several times in our country. In your view, are the regulation governing in this matter Indonesia is adequate, or this problem doesn't need, or there is another way to resolve a kind of this problem? I think that's all from me. Thank you, and Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you very much, Mas Nalom. There are 4 points raised by Mas Nalom Papal regarding freedom of religion, the aspects of cultural aspects of gotong royong, and also whether it includes freedom of expression, and in relation also to the spread of digital technology. Time is yours to respond back, Papal.
Okay, thank you, Helmi, and thank you, Nalom, for the questions. But I would like to apologize first if my answer is not sufficient, because I have some problem with your voice. It is maybe because of my internet connections. So maybe the first question is, if I can summarize, whether agnosticism is what it is in conformity with the Pancasila. Is that right?
Yes, correct.
Okay. To me, agnosticism, if we consider agnosticism as part of traditional or indigenous belief, it is part of the conception of Pancasila. Or we can review our understanding as a nation from the beginning, when our founding figures conceptualized what was the Indian, what should the appropriate state foundations for a nation like Indonesia, with diversity in many aspects of life, including its religion and belief, is one of its fundamental characteristics. The answer of the question is the acceptance or the adoption of the concept of a nation state, which established upon the pluralistic society of Indonesia, in which agnosticism is included within the principle of the oneness of God the Almighty. Because as I mentioned in my presentation, we are not a secular, we are neither a secular state nor a theocratic state. So we we should uphold the diversity among our fellow citizens, our fellow citizens of the Republic. That's what, according to my opinion. As to gotong royong, I think I don't agree. I'm not so worried with the conclusion. I'm not agree. I'm not 100% agree with the conclusion. Because what is maybe that was right when it is said that in the concept of human rights are primarily conceptualized from the perspective of individualism. But as written in many references of human rights, there is also an opinion, or there's also facts found by many authors that values of what is later called human rights can be found whether in every religion, whether it is Islam, Christianity, Hinduism, Buddhism, Taoism, and so on, etc. So the concept of human rights, the value of human rights, was actually also part of the wisdom of the said religions. So it is not absolutely or 100% derived from the individualisms. So as to be conceptualized as against the gotong royong principles. Even what is called the second generation of human rights, I mean the social and cultural rights, economic, social, and cultural rights. It is, to me, this is actually part of the gotong royong principle in there, in the second generations of human rights. So it is that is not necessarily that human rights is against the principle of gotong royong, which is the identity of the Indonesian nation. Now, a conflict as to conflict within internal internal followers of particular religions. I have no further comment on this matters because I have no expertise in the theological aspect of many religions. But as a lawyer, as a lecturer of a constitutional lawyer, I should say that freedom of religions is guaranteed by the constitutions, but it doesn't mean that it is without it cannot it is doesn't mean it is without border, because our constitution article 28 J paragraph 2 clearly says that human rights can be limited solely to protect the same right of others, and it must be done by law. So when there is a conflict within the same followers of particular religions, what is the role of the state? I think the role of the state is not to include with the interpretation of the theological aspect of the religion itself, but to protect the safety of the followers of the religion. I think that is the limitation of the state that can act in the case in such case. And according to the last question on blasphemy, there is a way to resolve this problem, and the only answer I can say is that whether it is depend on the criminal policy. in our the criminal policy of our legislative body. If blasphemy, if the lawmaker considers that blasphemy is still part of the criminal policy, meaning that that it is part of a criminal act, so it must be there. It must be there, and should remain a part of our criminal code. But if the criminal policy says that the matters of blasphemy is essentially private matters, it should be left to all individual of the Republic to solve this. It means that it's no longer part of our criminal code. That's all I can say. I'm sorry if it's not sufficient in my answer, in my reply for Nalom. Thank you, Helmi.
Thank you, Pak Pal. Thank you, Mas Nalom, for the response, the comments. And let's see if there is questions. This is question and session, question and answer session. Let's see if any participants would like to ask questions. Please raise your hand. Use the raise hand features or.
इंडोनेशिया की सुप्रीम कोर्ट में प्रेजेंटेशन है सुबह 6 बजे से बैठो.
Or raise your hands or type your questions on the chat column. So do you have any questions to ask to our distinguished speaker, Pak Palguna? Apparently, I see there is no questions from the participants.
Okay.
And in that case, Pak Paul, for the very interesting presentation, the very insightful perspective that you provide to us today, it is interesting to notice that while religious protection is a fundamental right, there is still possibility of limitation based on our constitution in a certain degree. And also, when you mention about blasphemy, which is, if it is still in criminal law, then there will be a problem of protecting the blasphemy matters. Well, Papal, thank you very much for your presentation, sir. And Mas Nalom, thank you very much for your response. And big round of applause for you, sir. Thank you, Papal.
Thank you.
Well, ladies and gentlemen, our distinguished participants, so we are going to proceed to our next speaker, Professor Arora. Professor Arora is a dean from University of Punjab. I'm so sorry for the mistake in my previous introduction, Professor Arora. And thank you, sir. And I would like to give the floor to you. Time is yours, sir, to provide us with your insights on this matter. And as a short notice, Professor Arora will be talking about religious protections and in relation to gender equality in Indian context. Professor Arora, time is yours.
Thank you, sir. So I hope I am audible.
Yes, you are. Your voice, we can hear your voice very clearly, sir.
Thank you, sir. Thank you. So, worthy chair, researcher Helmi Kasim, my fellow speakers, Papank, and other speakers, distinguished participants, ladies and gentlemen, greetings from India as well as Central University of Punjab. So I wish to extend a pleasant morning to you all. And before I start my presentation formally, let me express my gratitude towards International Constitutional Court for associating me with this esteemed endeavor and to present my views on freedom of religion and Indian context. It was a pleasure hearing in the morning Dr. Dhyan, who also spoke on doctrine of basic structure about and as evolved by the Indian judiciary. And now, before I start my presentation, I would like to share, I will start from where my former speaker has left. The question is of the interpretation. So friends, when we are talking about interpretation, and as a topic is highlighted by the moderator, that I'm going to speak on constitutional reflections on judicial approach towards revisiting freedom of religion and gender equality in Indian context. In fact, this paradox arose because of the denial of entry to the women in a famous temple of southern India that is known as Sabrimala temple on the ground of their menstrual status, means their age group of 10 to 50 years of age. And there was the question of interpretation, what my previous speaker has pointed out. The question of interpretation when it is in context of constitutional law, there are many paradoxes. These paradoxes have their seeds in the nature of constitution itself, because it is an outcome of dynamic, variable, socio-economic, social political forces. And since those forces are always changing, variable, dynamic, and in such a situation, administration of justice through the scale of law warrants fine-tuning between what is said and what is unsaid. There are many silences in the text of the Constitution, and construction of those silences, construction of the sounds out of those silences is a job of significance beyond words. Friends, our Constitution aims to establish an egalitarian society, gender neutral society. It is a leveler. It is not mere a lawyer's document, and it is a vehicle of nation's progress. The preamble to the Constitution of India reflects its spirit of affirmative action and equips the state to take special measures in the domain of legislative as well as executive activities to uplift the standard of marginalized. It envisions a transformation of polity by placing individual at the center of a just societal order as visualized by Edgar Bodenheimer and Roscoe Pound. Friends, if we look at the preamble to the Constitution of India, there are some distinctive features in parallels with other constitutions. There is liberty, equality, and fraternity. And then in the light of goals enshrined in the preamble, the provisions of the Constitution have to be interpreted constructively, progressively. And in such a situation, the silences of the Constitution need to be construed dynamically. Here lies the quandary, because there are numerous instances when the provisions of the Constitution have been given, have been constructed in a subtle way. Subtle opinion was there, which put the vulnerable sections on the margin. However, the Supreme Court of India restored the balance by taking the corrective actions to synchronize those silences by infusing the sounds in context of dynamism and constitutionalism. In view of this, my presentation, if you can see in the watermark, there are 2 candles. Those candles reflect the Indian methodology. Oh God, oh Allah, lead us from the dark towards the light. So against this backdrop, these 2 candle lights indicate the 2 judgments of Indian judiciary. One pronounced by the Supreme Court of India, 5 judges bench in the case of Indian Young Lawyers Association and others versus the state of Kerala and others. This is also known as Sabrimala matter. Other judgment is from a mosque where Dr. Noor Jahan Safia Niaz and others versus state of Maharashtra and others, where the female devotees were restrained from entering into the sanctum sectorum mazar of Haji Ali at Bombay. So our discussion revolves around the judicial approach towards these 2 judicial approach in these 2 judgments towards gender neutrality. So friends, when we look at the Sabrimala case, the Supreme Court attempted to find out the solution of the paradox of contradictions prevailing in India from ages, where on the one side, the glorification and veneration of women as goddesses was there, and on the other side, the women were denied equal status in various walks of life, such as prohibiting the entry of female devotees of a specified age group from 10 to 50 years of age in the temple at Sabrimala. And if we look at how this entry was banned, there are 3 kinds of legislation in India which deal with freedom of religion and introduces India as a secular state. First is the Constitution. The preamble itself says India is a secular country, and apart from that, there are fundamental rights guaranteed under Article 25 and 26 of Indian Constitution. Article 25 recognizes freedom of religion of individuals. And here is the word individuals. No discrimination on the basis of gender. And there is already a clause in Article 14 that no person shall be deprived, all shall be treated equally before the law. Apart from this, in Article 25 itself, that contains a non-obstant clause. It says, subject to public health, order, and morality, every person shall have freedom of religion. So the question is, every person and has freedom of religion, but it is subject to public health, order, and morality. And then Article 26 of the Constitution also allows the religious denominations, minorities, and further religious sects to have their own freedom of religion, on rules, on regulations, and the way of administration and management of their temples, shrines, and sects. In furtherance of Article 26, Clause 2, an act was enacted by the government of Kerala, that is Kerala Hindu Places of Public Worship Authorization of Entry Act 1965. So this is a parent act. So friends, we have discussed 2 things till now. First is the Constitution, second is the Parent Act, and under the Parent Act, a delegated legislation was framed by the government, and that government framed Kerala Hindu Places of Worship Authorization of Entry Rules 1965, and its Rule 3B denied the entry to the women of a specific age group, female devotees of a specific age group 10 to 50 years on the basis of custom and usages recognized under Rule 3B of these rules. So, in these two matters, courts evaluated the constitutionality of regulatory framework banning the equal right of female devotees. The regulatory mechanism, it prima facie appears that excluding the female devotees from the mainstream, and it was evaluated by the court on the touchstone of freedom, liberty, and equality. Though there is one dissenting opinion in the judgment of the Supreme Court that we will discuss in the coming part. So, in view of this, friends, we are going to discuss 2 or 3 issues. What was the meaning of freedom of religion in context of international human rights law and Indian constitutionalism? Second, how Supreme Court interpreted silences of the Constitution. Third, what is the relevance of constitutional morality in context of this social paradox? And how the Supreme Court defined essential religious practices, and then interrelationship between other fundamental rights, and what is its significance in the age of transformative constitutionalism. So since I have constraint of time, let me share with you that the full bench in its minority judgment held that the Rule 3B of Kerala Hindu places of worship authorization of entry rules is unconstitutional because it imposes a ban on female devotees due to their biological factors, and which is biological factors are the part of their reproductive phenomena. So it is beyond their control, and its validation was questioned by the Supreme Court itself in context of expression morality, because Article 25 recognizes freedom of religion of each individual subject to public health, order, and morality. So far as the scope and validity of the expression essential religious practice under Article 26 and right to manage its own affairs in the name of religion by a sect or denomination is concerned, the Supreme Court categorically held that this right is subject to Article 25, which provides a fundamental right. So the right to administer on affairs of a religious denomination is a general right, but it has its exception. And further, the court held that if we look at Article 17 of Indian Constitution, which prohibits untouchability, denial of entry to the women in a temple, female devotees in a temple, may invoke the clause of Article 17 because the temple is of the public character, and temple is being managed and administered by the state government under a specific law. So the moment a law is passed and there is a kind of financial aid from the government also to run the administration of the temple, to manage the affairs of the temple, it obtains public character. And in the institutions of public character being regulated by the state is under an obligation to ensure that no discrimination on the basis of race, religion, caste, creed, place of birth, or sex occurs. So in this way, the Supreme Court dynamically interpreted, though one of the dissenting judges pointed out that constitutional morality should not be invoked in the matters relating to religion. These are the sensitive matters, and her lordship was herself a female judge, but she declined to intervene and invoke the principle of constitutional morality in the matters of religion. And then she said that inviting untouchability in this
Excuse me, sorry to intervene, Prof. Arora, just to remind you of the time, sir.
Okay, sir. I'm going to conclude. And similarly, in next matter, Nurjahan Safia's case, the contention of state was that there were some instances of Eve teaching, due to which the entry of female devotees from Islam were restricted to the sanctum sanctorum. The Supreme Court, High Court of Bombay took its cognizance and emphatically expressed its concern that instead of addressing the evil of Eve teasing within the premises of Haji Ali Dargah, the court is denying, the trust is denying the entry to the female devotees. So friends, in this way, the High Court also recognized that female devotees have equal right to worship, practice, profess, and propagate their religion that cannot be declined or denied by the state on the pretext of extra constitutional grounds. And in this way, the Supreme Court recognized the right of the female to enter, to propagate, to practice, and to profess their religion. And also it reflects the judgment of, if we dissect the judgment and its various parts, Bodenheimer's principle of backward pull and forward push dictum, wherein the Supreme Court applied the doctrine of constitutional morality to construe the silences of the Constitution being a magnum opus. So with these words, I am thankful to the chair and Constitutional Court of Indonesia for providing me the opportunity to associate and share my views with this esteemed endeavor. Thank you everyone for patient and careful listening.
Thank you very much, Professor Arora. It is very interesting to notice the problem of the issue of constitutional interpretations and the power to regulate this religious matters specifically by each particular religion. It was interesting and also your comment on there are many silences in the text of the Constitution that should need dynamic interpretations. For further comments on your presentations, I would like to invite my fellow researcher, Dr. Abdul Ghaffar. Dr. Abdul Ghaffar, Mas Ghaffar, time is yours. Hello, Mas Ghaffar. We still cannot hear your voice.
Is my voice clear?
Yes, it's okay right now.
Okay. Thank you. Assalamualaikum warahmatullahi wabarakatuh. Thank you very much, Mas Hilmi, for handing me the opportunity. Apal Guna also, and Prof. Arora. Just information, Prof. Arora, Apal Guna is, I have to say that he is my life lesson teacher and also mentor, as well as he is my doctorate exponent before. So I have to say thank you to him. But today I want to comment to your presentation. Your presentation is really interesting for me and comprehensive presentation of Arora. I already did all your paper and page by page. I read all your paper and I feel really happy. I become part of the session, so I want to ask a bit something from your paper. I remember that you mentioned that the Indian Constitution provides equal rights between men and also women, especially regarding to the protection of the religious belief. However, Prof. Arora, in practice, like you mentioned before, and also in your paper, that there were at least 2 cases of discrimination against women mentioned. The first one was the case of the prohibition of female visitor aged 10 to 50 from entering the Sabarimala temple. I hope my pronunciation is correct. And then the next one was the case of the restriction of the female visitor from entering Haji Ali Dargah site. Is it right, Prof. Arora? And in the first case, the ban was set due to Futum custom. Yeah, please correct me if I'm wrong, which required devotees to do 41 days of fasting before entering the site. Since female aged 10 to 50 in general are in reproductive age, which have menstrual cycle monthly, this is the problem. So they barely are possible to finish the 41 days. This is for fasting, and therefore they are not allowed to enter the temple. Meanwhile, for those female visitors who are pre-puberty or menopause, they are still allowed to enter the temple. Therefore, this restriction may not be considered as social discrimination if it just matter of belief in religion. And the other second case is women are restricted from entering the Ali Dargah pilgrim, aside to the some Muslim belief. It is not recommended for women to visit a grave despite some other belief otherwise. That women may visit grave under certain conditions. So both cases were later decided by Supreme Court that women were allowed to enter both sides. So, Prof. Arora, I have to say that probably this is my question. Under the concept democratic state, does the state need to regulate to that extent? I think, should the state regulate issues related to the religious belief of its citizens, despite the Supreme Court decision? Yeah, to me it seems that the state has forced its citizens to change their belief. Sorry if I'm wrong. And also the first case, from the initial belief, women aged 10 to 50 were restricted also from entering to the Sabarimala temple. It states same. It state forced them to be allowed also. State means I'm in Supreme Court here. Similarly, in the second case, from the belief, there's this woman visiting the graveyard. Then the state forced it to be open for the woman.
Excuse me, Mas Gofar, considering time allocation, would you please shorten your comments or questions?
Okay. So the conclusion is, isn't it regular religious belief is human rights that should be granted both under international law, like you mentioned before in your paper, such CEDAW, International Convention on Elimination of Form of Discrimination Against Women, as well as under national law, including in your constitution. Yes, namely, I have to say Article 25 of the Indonesian Constitution. So I hope this is I got further explanation for you. And sorry if it's too long, Mas Ilmi. Thank you very much.
Yeah, Professor Aro, I believe there are so many interesting points that you need to explain considering his question and comments. But unfortunately, sir, because of this limited time allocation, because you might be able to explain us the whole day, but considering time allocation, we need to provide short, insightful comments on the response, sir. Professor Aurora, time is yours.
Thank you. Thank you. So thanks, Dr. Abdul Ghaffar, for making my analysis of my presentation. It is true that you have touched the aspect of CEDAW, Convention on Elimination of All Forms of Discrimination Against Women, as India is a signatory, number one. Number two, your good self pointed out about the customary aspects, and the state should have restricted itself from intervening in the area of customs, or because being a secular state. It is true, but at the same time, if we look at Universal Declaration of Human Rights, ICCPR, ICSCR, and otherwise, even the Constitution itself says in its Article 13, Clause 3, that the customs shall be a law, provided that all those customs are valid, not against public policy or the written laws or the codified laws. And the customs, which are against the spirit of the Constitution or against the rights guaranteed in Part 3rd of the Constitution, those customs shall cease to be the law of the land. So this is how the Supreme Court declared this custom of prohibition on the entry of women of menstrual age. Because if we look at Article 17, its spirit, and Constitution being a document of a social transformation, a revolutionary document, was introduced with a means to discontinue the discrimination, the perpetuities of discrimination. And the meaning of Article 17, untouchability clause, is so wide in context of India being a signatory to different international conventions and agreements, that it is not only denying the caste discrimination, but also discrimination in any form. So here biological factors are the basis on the basis of which are the grounds on the basis of which the entry to the women is denied. And when the question of essential religious practice was raised by the respondents, by the trust in both the temples, in first case of Sabrimala, the managers, the trustees themselves shared before the court that there is no written origin except there is Bhut Gita, that religious script in which it has been mentioned that the deity is in form of celibacy. It has to restrain itself from even the image or even the shadow of the women to maintain its celibacy. However, apart from, if we look at ahead, the trustees of the trust tendered before the court that since the temple was situated on the peak of the mountain and it was very difficult for the female to climb and pay the obeisance to the temple, and offering about 18 items are offered by climbing 18 holy steps, and it would be difficult for the female of this particular age group. So this was one of the contention of the respondents. Number two, and now when this custom was introduced, at that time we did not have that kind of infrastructure. Now the whole road with the transportation goes till up to the gate, main gate of the temple. So the women may travel by those accessible vehicles and they can be transported to that place. So in such a scenario, when the right to privacy has also been recognized in India because of by the 7 judges bench in Justice K.S. Puttaswamy's case. So religion is certainly the matter of relationship between individual and God. So the state should restrain itself. And here the state itself was assumed, was perceived as an intervener, because both the things, whether it is a trust of the temple or whether it is trust of Haji Ali Dargah, both are the registered trust and attained the public character the moment they attained their registration in the eyes of law. Therefore, in the institutions of public character, discrimination cannot occur on the basis of sex. So that's why the Supreme Court and the High Court evolved this theory of gender equality and gender neutrality. And recently in 2020, September, October, the matter has been now clubbed with other writ petitions considering gender mutilation in Islam as well as in Parsi and Jews sect. And this petition has been clubbed by the then Chief Justice of India. Now he is retired, and that decision has been sent for review to a higher bench of 9 judges. So it is now under review. Sir, I hope it could satisfy some of your queries.
Oh, thank you very much, Professor Arora, for your response and answers, explanations. My distinguished speakers, participants, ladies and gentlemen, there are still many aspects that needs to be explored. Many points, lots of points that needs to be discussed in this diverse matter of religious protection. Unfortunately, time is limited, and hopefully our interaction in this forum will continue in the future. So we can still discuss with Pak Palguna and Professor Aurora in another forum or by other means if we have more questions to discuss with these distinguished speakers ours. Yes, sir. Professor Aurora.
I would like to mention, if anyone has query, they can certainly address us on email also. And email, if you can provide them, I will be happy to welcome their queries and answer their queries.
Thank you, Professor Aurora. I would like to thank our distinguished speakers. Papal, thank you, Papal, and Professor Aurora, and my fellow researchers as respondents in this session. And this is the end of our session this morning. I would like to thank everybody for participating in this conference, and we are going to see you again in the afternoon session of the conference today. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you very much, Helmi Kasim, as the moderator for the first panel for ICCIS. Honorable Speaker, distinguished participants, ladies and gentlemen, that is the end of our first session, the fourth Indonesian Constitutional Court International Symposium. We will have 30 minutes for lunch break, and we're gonna be back for the next panel at around 12:30. Have a good resting time, and see you at 12:30.
The Fourth Indonesian Constitutional Court International Symposium, ICCIS. Following the success of our previous international symposia in Surakarta in 2017, Yogyakarta in 2018, and Bali in 2019, the Constitutional Court of the Republic of Indonesia will hold the Fourth Indonesian Constitutional Court International Symposium. The Constitutional Court of Indonesia provides an international academic forum to discuss various constitutional issues in comparative perspectives, with the theme Constitutional Court, Religion and Constitutional Rights Protection. The Constitutional Court of Indonesia gives opportunities to legal scholars, researchers, lawyers, and practitioners to participate in the Indonesian Constitutional Court International Symposium. For further information, please visit www.iccis.mkri.id.
Flow Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Flow Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya.
the fourth Indonesian Constitutional Court International Symposium, ICCIS. Following the success of our previous international symposia in Surakarta in 2017, Yogyakarta in 2018, and Bali in 2019, the Constitutional Court of the Republic of Indonesia will hold the fourth Indonesian Constitutional Court International Symposium. The Constitutional Court of Indonesia provides an international academic forum to discuss various constitutional issues in comparative perspectives, with the theme Constitutional Court, Religion and Constitutional Rights Protection. The Constitutional Court of Indonesia gives opportunities to legal scholars, researchers, lawyers, and practitioners to participate in the Indonesian Constitutional Court International Symposium. For further information, please visit www.iccis.mkri.id.
boleh leboh rasa girang dan badendang pulange Flo Bamora tanah airku yang tercinta tempat beta dibesarkan ibunda meski beta lama jauh di rantau orang beta ingat mama janji pulangnya biarpun Tanjung Teluknya jauh tapi nusaku tapi selalu terkenang di kalbuku anak timur main sasando dan menyanyi boleh leboh rasa girang dan badendang pulange meski beta lama jauh di rantau orang beta ingat mama janji pulange biarpun Tanjung Teluknya jauh tapi nusaku tapi selalu terkenang di kalbuku anak timur main sasando dan menyanyi boleh leboh rasa girang dan badendang pulange menjaga dan mentaati konstitusi untuk bangsa Indonesia.
The 4th Indonesian Constitutional Court International Symposium, ICC-IS. Following the success of our previous international symposia in Surakarta in 2017, Yogyakarta in 2018,
need to call my full name, just call me Rima, please. And as I stated earlier, that in this session, we have 3 speakers and 3 respondents. And I will be happy to inform you that the total time allotted to each speaker is about 30 minutes. However, each speaker shall present their paper for about 15 minutes. And then respondent will have 10 minutes to express their view or their opinion. And if we still have time, we will do the question and answer part. And for the first speaker, I would like to invite Professor Muhammad Ekram Mulhaq from University of Dhaka, who will present his paper entitled Secularism to State Religion, Constitutional Right to Freedom of Religion in Bangladesh. And for your information, Professor Ekram is a professor of constitutional law and comparative constitutional law at the University of Dhaka. He did his PhD in constitutional law and international law at Monash University in Melbourne, Australia. Professor Ekram, if you are ready, time and screen are yours.
Thank you so much. May I request the organizer to allow me to share my screen so that I would be able to share the PowerPoint slides with the rest of this audience?
Of course. The committee, please, would you mind to help the Professor Ekram to share his paper or presentation?
Thank you so much.
No worries.
Well, I'm expressing my deepest gratitude to the Indonesian Constitutional Court, Mahkamah Konstitusi Republik Indonesia, for giving me this great opportunity to speak on a very important constitutional issue. And greetings from the people of Bangladesh and the University of Dhaka, where I'm currently working as a professor of comparative constitutional law and constitutional law. Well, today's topic of my presentation is secularism to state religion, constitutional right to freedom of religion in Bangladesh. At the very outset of my lecture, let me tell you something very briefly about the constitution and the legal system of Bangladesh. Bangladesh was born as an independent sovereign state through Liberation War back in 1971, through proclamation of independence. And that was a unilateral declaration of independence in a non-colonial setup. That was, in fact, the first successful exercise of the people's right to self-determination by making a unilateral declaration of independence. And then Bangladesh adopted an autonomous constitution, and it has generally recognized different types of human rights. It reflects International Bill of Rights. It has recognized civil and political rights as judicially guaranteed fundamental rights, while economic, social, and cultural rights have generally been recognized as judicially unenforceable fundamental principles of state policy. And Bangladesh is a unitary state, and it has the Supreme Court of Bangladesh. And unlike Indonesia, we do not have any separate constitutional court in Bangladesh. The Supreme Court of Bangladesh has different types of jurisdictions, including to hear the cases regarding all constitutional issues. And the Supreme Court of Bangladesh has the power of judicial review. And interestingly, the Constitution of Bangladesh also has a basic structure. Back in 1989, it was judicially established for the first time in Bangladesh, following earlier precedents of Indian case of Keshavananda Bharati case. And there was a case of Fazlul Qadir Chaudhary back in before the Liberation War in Bangladesh. Well, and later in 2011, we have recognized express basic structure of the Constitution of Bangladesh. And use of international law, and comparative constitutional law are generally allowed in Bangladesh to give interpretations to different constitutional provisions. And this particular room for using international law and comparative constitutional law in interpreting Bangladesh constitutional provisions has in fact paved the way to widen the periphery of constitutional law Bangladesh eventually. Well,
Professor Ekram,
yeah.
May I interrupt you? Yeah, would you mind to do full screen for your presentation, sir? because the committee would like to display your picture.
Is that now the full screen? Is this now the full screen?
Yeah, that's right. Thank you.
Thank you.
Thank you, sir.
Let me say something about the research questions. That there are three important research questions in my lecture. Number one, what is the nature of constitutional protection of the right to freedom of religion in Bangladesh? What are the implications of the inclusion of both secularism and state religion at the same time in the Constitution? And lastly, what type of protection has the Supreme Court of Bangladesh provided to the constitutional right to freedom of religion? Well, let me clarify the scope of my study very clearly. I'll confine my study within the legal and constitutional perspectives, constitutional perspectives of the issues, because of course it has a different political dimension, and I'm not going to focus on the political dimension of all those constitutional issues. I'll try to confine myself within purely legal perspectives. The discussion will deal with evolution, legality, and constitutionality of different changes, apart from an analysis of the textual provisions. And the paper will then focus on the freedom of religion provisions in the Constitution of Bangladesh. And what is the impact of Islamization and secularization of the Constitution of Bangladesh on different provisions regarding freedom of religion in the Constitution of Bangladesh. And at the end of my lecture, I will focus on certain selected litigations having an impact on freedom of religion. Well, regarding the theoretical framework, there are, of course, different interesting doctrines that are involved in while we will be discussing the constitutional law of Bangladesh, like unconstitutional constitutional amendment, eternal provisions, or the basic structure provision, or what should be the place of religion in a constitution, because there are actually different models and theories that have been developed so far regarding incorporation or separation of religion from the state or the constitution. And most importantly, the Austinian school of thought, that legal positivism, has a very interesting influence on the constitutional amendments in Bangladesh, because generally we'll see that there are different constitutional amendments, including incorporation of the state religion in the Constitution of Bangladesh. I'm talking about constitutional amendment because the state religion was in fact added with the Constitution of Bangladesh by way of constitutional amendment. And there are a number of constitutional amendments that have subsequently been declared by the court to be null and void. However, in making those constitutional amendments, we see that there is a strong influence of Austinian school of thought that law is the command of sovereign, because we see that without enough participation from the people, many times, in fact, the Constitution of Bangladesh was amended. Well, my lecture will be divided into two different parts. Part one will include the discussion on secularism and state religion in the Constitution, while the second part will make the study on the constitutional right to freedom of religion. Well, regarding state religion, I must say that state religion, secularism, and Islamization of the Constitution in Bangladesh are connected with complex and vague constitutional issues of martial law, its unconstitutionality, constituent power, amending power, and unconstitutionality of constitutional amendments. I'm raising all these things because there are many amendments regarding Islamization of the Constitution of Bangladesh that took place actually during the period of martial regime in Bangladesh. However, in order to do appropriate justice to my topic, I need to make all these discussions, which is impossible to do within this very short span of time. That's why I'm just saying my limitations also. Well, let me divide the position of the Constitution of Bangladesh regarding secularism and state religion and Islamization. We can divide it into different phases, starting with phase one. 1972 Constitution, while the Constitution was adopted first. 1972 Constitution that contained in the preamble a declaration regarding secularism. Secularism was recognized as one of the fundamental principles of the Constitution. And also Article 8.1 of the Constitution recognized secularism as one of the fundamental principles of state policy. But the thing is that fundamental principles of state policy is not judicially enforceable in Bangladesh. So secularism that took place in fundamental principle of state policy part that is actually not judicially enforceable according to the constitutional mandate. Well, apart from these two provisions, the Constitution of 1972 incorporated a provision regarding secularism and freedom of religion in Article 12. That actually provided an explanation, a detailed guideline that how will the state actually implement secularism in the country. And in doing so, it has been said in Article 12 that the principle of secularism shall be realized by the elimination of communalism in all its forms. And the state will not grant any special political status in favor of any religion. Interestingly, we'll see later that by adding state religion in the Constitution of Bangladesh, the Constitution has in fact granted that special political status in favor of any one particular religion. So here lies a constitutional paradox even in Bangladesh. I'll go to that point later again. Well, and the abuse of religion for political purposes is clearly prohibited by the Constitution of Bangladesh. Well, let me now focus on phase 2. Phase 2 starts with martial law regime. During the martial law regime back in 1977, by martial law proclamation, Bismillahirrahmanirrahim was inserted in the Constitution. And secularism was substituted by another constitutional principle, which is called absolute trust and faith in the Almighty Allah. And secularism was also changed as a fundamental principle of the state policy, and secularism was replaced by the trust and faith in the Almighty Allah as a constitutional principle as well. And that particular regulation omitted Article 12 as well, that I have discussed just a little while ago. Well, then during this particular phase 2, after making that particular martial law proclamation, that gave a special extra constitutional protection to those constitutional amendments, that everything will be deemed to have been done in accordance with the law. And subsequently, when the parliament was formed, that provided a clear protection to that particular martial law proclamations as well. And as such, all those martial law proclamations and all those constitutional amendments got the validity eventually by the Constitution 5th Amendment Act when the parliament was formed during the democratic regime. And interestingly, what happened later? The court declared the entire Constitution 5th Amendment to be null and void, not on the ground that it recognized Islam as a fundamental principle of the Constitution, rather on the ground that all those amendments and laws were passed during the martial law regime, and martial law cannot exist in a democratic constitutional regime. So since that martial law regime was declared null and void, so subsequently some interesting developments took place in Bangladesh. I'm going to those developments later in phase 4 of the constitutional development in Bangladesh. By this time, during the phase 3, back in 1988, a state religion was added. A state religion was added back in 1988 by new Article 2A in the Constitution that says that the state religion of the Republic is Islam, but other religions may be practiced in peace and harmony in the Republic. One of the major criticisms of this particular phrases used in the Constitution is that it implies that other religions will be performed in peace. So one may put a question, does this mean that Islam can be practiced without peace and harmony? Well, there is a subsequent judicial development that back in 1988, this particular constitutional amendment that actually added state religion with the Constitution was challenged before the court. And the court remained silent for 28 years. The petition was filed challenging the validity and legitimacy of that particular constitutional amendment that has actually added state religion, and the court did not respond for 28 years. Court heard the case after 28 years. So that will follow within phase 4, because after 28 years, it has been eventually rejected by the court. Court said that I do not have a jurisdiction to deal with this particular issue. I'm coming to that point later. Well, what happened in phase 4 of the development? Constitution 15th Amendment Act 2011 was passed. And interestingly, it was passed during the democratic regime, and it reinstated both Bismillah Rahman Rahim at the beginning of the Constitution, and that also added state religion. And at the same time, that revived the concept of secularism. And as such, paradoxical standard started to happen in Bangladesh Constitution. It reinstated 1988 constitutional provision with a slight modification. In Article 2A, back in 2011, the Parliament added a phrase, but the state shall ensure equal status. So with the concept of state religion, the Constitution said that the state shall ensure equal status. Well, and it has also revived Article 12 of the original Constitution. As I was saying earlier, that Article 12 actually prohibited, Article 12 prohibited to give any special political status to any particular religion. And back in 2011, Article 12 was revived, and secularism was reinstated. At the same time, a special political status was given to Islam as a state religion. And some jurists think that this is a type of sort of paradoxical situation in the Constitution of Bangladesh. More interestingly, what was done back in 2011, an interesting incident took place, that the Declaration of Basic Structure, Article 7B was added to the Constitution of Bangladesh. That is the longest basic structure in the world constitutions. No constitution in the world has declared such a wholesale bunch of basic structure of the Constitution. Anyway, now secularism has been the basic structure. State religion at the same time has been another basic structure. So we can foresee that in future, there will be no possibility of making any sort of change in this particular area of law. Well, so in terms of secularization and Islamization of the Constitution, 50 years of Bangladesh can be divided into 3 different eras. Era 1, period of complete secularization, 1970 to 75. Era 2, period of complete Islamization, 75 to 2011. And the present era, that is era 3, that this is actually can be termed as an era of period of secularism along with Islamization, coexistence. That is actually the coexistence. Well, now let me focus on certain other, in part 2 of my lecture, that deals with different constitutional provisions regarding freedom of religion. There is Article 41 of the Constitution that says that everyone can practice one's own religion, and no one can be forced to perform any religious obligation in the state, and the kids cannot be compelled to have any sort of specific religious education in the schools.
Professor Ikram?
Yes.
Yeah, apologies for interrupting. Due to limited time, I ask you to conclude your presentation, Prof.
Well, I'm concluding in 2 minutes. Okay, thank you so much. So there are many other constitutional limitations that the Constitution has declared, that there cannot be any sort of discrimination made on the basis of the religion. And as such, the Constitution has tried to maintain an equality before law. Well, let me focus on a very important case, Siradul Islam Chaudhary and others in Bangladesh, that actually challenged the validity of adding state religion in the Constitution of Bangladesh. But subsequently, court said in 2016, after 28 years of filing that particular case, that the court does not have Lucas Standi. But there are hundreds of similar types of cases that were actually heard by the court, and the court granted Lucas Standi. And denying the Lucas Standi in this particular case was really interesting. And there are a number of cases in Bangladesh that actually say that yes, you can observe your constitutional right to freedom of religion, and the right to pronounce fatwa has also been recognized. But regarding legal matters, declaration of fatwa is completely prohibited. So what is the conclusion? The conclusion is that although Jacqueline in Oxford Handbook 2022 has divided Asian perspective of incorporation of religion in the Constitution into three different parts: prioritization, subordination, and separation. And that particular author has put Bangladesh in the first category of giving prioritization. But in fact, what happened in Bangladesh, it has a paradoxical constitutional standard, because in my opinion, Bangladesh belongs to all these three categories of prioritization, subordination, and separation. Thank you very much.
Very well. What an impressive presentation, Professor Ekram. And I just found new things, and I just took a note, like, and very enjoy your presentation. And now I would like to invite Dr. Irfan as a respondent in this session. To Dr. Irfan, if you are ready, time and screen are yours.
Okay, thank you, Mbak Rima, for your opportunity to given to me. And first, I will appreciate very interesting topics that's presented by Professor Ekram. And I have at least 3 or 4 questions. First, there are always a contradiction between principle of secularism and principle of religion. So how to keep proportionality between the secularism principle and the spirit of Islamic religion in the Constitution, so it's run in harmony in implementation. And the second is the Constitution in Fifth Amendment in 1977 substitute secularism contained in the original Constitution by or with insert Bismillah. So what is the contextual meaning of the word Bismillah in the preamble, and whether its influence in lawmaking process and also government policy? And the third, however, in 2011, the original provision of secularism was restored in the Fifth Amendment. What is the historical background of this fact? Is the principle of secularism is very important, so run the government policy, and how about with the religion principle? So maybe that's all my 3 questions, because the time is limited. Thank you for the answer, Professor Ekram.
Yes, Professor Ekram, you may respond Dr. Irfan's question.
Thank you so much, Dr. Irfan, for your very thoughtful questions. And it seems that you have a very good idea on constitutional law, and you have read something about the constitutional law of Bangladesh as well. Thank you so much. Well, regarding the first question of the balance between secularism and religion, very interesting question, that how does the court actually maintain the balance or harmony between secularism and the religious rights? Well, let me give an example of from a case that was decided back in 2011. That is actually an example that how does the court maintain a balance between these two. This is known as Tayyib case. That was regarding a fatwa that was declared against a woman. That woman became a victim of a fatwa. And eventually the High Court division declared that all fatwa are unconstitutional. No fatwa can be pronounced by any person whomsoever. Then what happened? Someone has appealed to the appellate division against that particular verdict, that how can the court declare all fatwa to be unconstitutional? Then the appellate division said fatwa generally is not unconstitutional. But if that violates any state law, then that will be unconstitutional. And the appellate division said that fatwa regarding all religious matters will be recognized, but not regarding any criminal law or any other issue that is covered by the existing law of the land. And as such, court maintains an actual balance between secularism and religion. Well, then come to the second question regarding the insertion of Bismillah Rahman Rahim. Well, that has been added at the beginning of the Constitution of Bangladesh, and that does not have any impact on the lawmaking process, of course, because that has not been treated as an effective or operative part of the Constitution that may have certain legal consequences. That doesn't have any sort of consequences still so far. Well, regarding the third question, what was the context of secularization and Islamization? Well, let me go back to 1972 Constitution when secularism was originally added in the Constitution of Bangladesh, because we all know that Bangladesh was born by liberation war doing against Pakistan, and Pakistan was an Islamic republic. So there was a counter reaction against that Pakistani ideology when Bangladesh was born, and Bangladesh adopted secularism as one of its fundamental principles of the Constitution. But of course, later at the time of different martial law times periods, Constitution was amended, and Islamization process started. But interestingly, the most recent amendment back in 2011, that actually added again Bismillah ar-Rahman ar-Rahim in the Constitution and added state religion in the Constitution. It was not done during any martial law time. It was done in democratic regime. So the thing is that in Bangladesh, both the process of Islamization and secularization happened in both the periods of martial law regime and democratic regime as well. But the most interesting phenomenon of the current constitution is that now both state religion and secularism have been incorporated as the basic structures of the constitution, which no one can change in future. Although I understand that this is a controversial issue of comparative constitutional law, that whether there can be any basic structure of the constitution or whether the current parliament take away the power of the future parliament. Thank you, Dr. Irfan.
Very well. Very interactive dialogue, and it's very interesting topic. Thank you, Professor Ikram and Dr. Irfan.
Thank you very much, Prof. Ikram.
Thank you so much. Assalamualaikum.
Waalaikumsalam.
And now, ladies and gentlemen, we are going to present our second speaker, Professor Muhammad Siddiq Armia from UIN Araniri, Banda Aceh, who will present his paper entitled Islamic Constitutionalism Through Constitutional Court, Does It Make Sense? And to Professor Muhammad Siddiq Armia, because I couldn't reach you earlier, how shall I address you? Professor Siddiq or Professor Muhammad Siddiq Armia, how shall I address you?
Yes, Professor Siddiq is enough, I think.
Professor Siddiq. And I think the voice, like, you need to talk more clearly and louder, because the voice is too.
Can you hear my voice?
The committee, can you help Professor Siddiq Armia to high up the volume?
Can you hear my voice?
Yes, we can, but the voice is still like I think, is it because your earphone, Prof. Siddiq? Would you mind to take it off and try it again?
All right, could you please hear my voice?
Very well, perfect. It's very good. Okay.
All right.
Thank you, Professor Siddiq. Let me to read your brief CV. Professor Muhammad Siddiq Armia is a professor of law at Faculty of Sharia and Law at State Islamic University, or UIN Araniri, Banda Aceh. He did his PhD in Anglia Ruskin University. I believe it is in Kingdom, isn't it, Professor Siddiq?
Yes.
In United Kingdom. Oh, okay, wonderful.
Right.
And Professor Siddiq, as I explained earlier, that you have only 15 minutes to present your paper. And Prof. Siddiq, if you are ready, time and screen are yours.
Thank you for the organizer and moderator as well. I will share my screen. All right. In this time, to discuss
the Islamic constitutionalism through its Constitutional Court of Indonesia, actually. The main question is, does it make sense for Constitutional Court to make the principle of Islamic constitutionalism? Next. There are three main content about my presentation. First of all, about definition of Islamic constitutionalism, and then Islamic constitutionalism in the 1946 Constitution of Indonesia, and then Islamic constitutionalism through Constitutional Court, and then the conclusion. Next. The definition of Islamic constitutionalism here is the discussion have been related to the 5 principles of implementation of Islamic constitutionalism that we call maqasid syariah. So the principle of Islamic constitutionalism, first of all, is based from 5 Islamic principles, and then expanded to be more than 5 principles that we call, first of all, is protecting religion, or it's called Hifzuddin, and then protecting soul and life, called Hifzun Nafsus, and then protecting mind and mental, called Hifzul Aql, and then protecting offspring, called Hifzun Nasab, and then protecting property, or in Arabic called Hifzul Mal. And then this is what I said, expanded more than 5, protecting community, that's called Ummah, and then protecting environment, called Bi'ah. So this is 7 principles of Islamic constitutionalism that we will be discussed in this discussion. Next. This is what I say, 7 principles of Islamic constitutionalism. So if we can define the Islamic constitutionalism like previously, and we can identify that 7 principles of Islamic constitutionalism in constitution or in the judgment of Indonesia Constitutional Court, you can say that is a part of Islamic constitutionalism. So you can see here 5 principles that are protected in Islamic constitutionalism. Next. In Indonesia, we can see that Islamic constitutionalism in the constitution has been explicit in 2 ways. In the first way, it shows in explicit way. We see in the Article 26, we see that Article 26, that the state guarantee the freedom of every citizen to embrace his own religion and to worship according to his religion and belief. And then Article 20H(e), every person is free to embrace religion and worship according to his religion. So in my opinion, I can claim this is the implementation of Islamic constitutionalism in explicit way. So the constitution clearly stated that principle of Islamic constitutionalism and stated it without doubt in the constitution, like in Article 26 and Article 20H. Next. And then the implicit way. In the implicit way, Constitution not clearly stated the principle of Islamic constitutionalism in its article. such as protecting mind and mental. So the implementation is stated in other ways. We can see in the Article 20H stating that everyone has the right to life physically and mentally and get a good healthy environment and get health services. So this norm in 20H article, we can see that the Constitution has explained and has stated implicit way rather than explicitly, but in implicit way. The norm of health services here also interpreted as mental health. So for the clear norm, it will be arranged in the health law. Next. Then the main question here is Islamic constitutionalism through constitutional court. Indonesian constitutional court is one of Indonesian state organ which has jurisdiction to implement Islamic constitutionalism through its judgment. Because Indonesia Constitutional Court has experiences of being negative and positive legislator. So I mean, the Constitutional Court of Indonesia have jurisdiction to make the principle of Islamic constitutionalism, whether in the way of negative legislator or positive legislator. The negative legislator here is like a principle which is written by Hans Kelsen without any changing of such a flow, but it just say null or not. But in positive legislator, the Indonesia Constitutional Court also has power to edit the law or edit the act based on the principle of constitution. Next. Then I will give some sample that the Constitutional Court has been implementing the principle of Islamic constitutionalism, because of there are a lot of principle of Islamic constitutionalism. For example, here I just choose one of them, and here I choose the principle of protecting of offspring, or we call Hifzun Nasab. The principle here we can see in the limiting age marriage. You know, in the judgment of Constitutional Court number 22 PUU XV and 2017. Here we can identify that Indonesia Constitutional Court has implement the principle of maslahah ummah or public interest in the context Islamic constitutionalism. Here we can see the Constitutional Court has make the minimum age limit for marriage is an authority of lawmaker. This is one of sample of principle of Islamic constitutionalism through protecting offspring. Next. Then we can see also in protecting offspring, the Constitutional Court are also preventing child exploitation. We can see here in the judgment number 33 PUU XV 2017. We see here that how Indonesia Constitutional Court preventing child right to be exploited in economic way. So in here, in this constitution, we can see the Indonesia Constitutional Court has played their role and authority to protect and to prevent child exploitation. We can see in this judgment how the Constitutional Court make an argument based on the Constitution and also based on international law, and we see that the judgment can accept it to be part of Islamic constitutionalism. Next. And then we can see also how Indonesia Constitutional Court protecting what we call hifzul mal. Hifzul mal here is protecting public property. Public property here, such as we can see in the judgment here, like protecting based on article of Constitution, Article 33, which is protecting all of state property, like mining and like electricity, like water and mineral, which is protected by Constitutional Court through this judgment. We can see here the judgment number 32, 2010, number 10, 2012, and then 2003. And then the conclusion. So in here, in my paper, I can explain that ICC has been indicated as one of Indonesia's state organ that implementing Islamic constitutionalism through its judgment. We can see here in protecting offspring, called Hizbun Nafsat, and protecting property. With ICC jurisdiction, it clearly makes sense that ICC has authorities implement Islamic constitutionalism through judicial process, and also expanding ICC jurisdiction as negative and positive legislator. Next. With ICC jurisdiction, it clearly makes sense that ICC has authority to implement Islamic constitutionalism. But it needs further discussion and
Professor Ekram? Professor Ekram? Okay, I believe it's about connection. The committee will help us to reach the Professor Siddiq. Yeah, thank you. And okay, and then maybe we can ask to and invite to Fuadi as a respondent in this session to share his thought or opinion. Fuadi, if you are ready, time and screen are yours.
Bismillah.
Okay.
Assalamualaikum warahmatullahi wabarakatuh.
Okay. Okay, apologies for interrupt, Fuadi. Yeah, Professor Siddiq,
Yes.
I apologize for the connection. And would you like to conclude your presentation before Fuadi giving his opinion, Professor Siddiq? Are you still with us? because I cannot hear your voice, sir.
Yes. Sorry, it's the connection, I think.
Yeah, it's okay.
You can still hear my voice. All right. I'm
Yes,
sorry
yes.
because this is convenient. Right.
Okay, please conclude your presentation, Prof. Siddiq.
All right. My conclusion is I can claim that Constitutional Court has implemented the principle of Islamic constitutionalism. My assumption is a seven principle of Islamic constitutionalism has been implementing through ICC judgment. But in this presentation, I just make two sample of implementing of Islamic constitutionalism through through Indonesia Constitutional Court. Thank you very much.
Okay, very well. Splendid explanation, Professor Siddiq. Thank you so much. I like the way you explain your paper systematically, so I can absorb your presentation. Thank you. And right now, I believe that Fuadi is here, and I would like to invite Fuadi once again as a respondent to this session. So, Fuadi, if you are ready, time and screen are yours.
Okay, thank you for the moderator who has given me the opportunity to respond to Professor Siddiq's presentation. First, I congratulate and appreciate to you, Professor, on writing this article. This article is brilliant and provides valuable knowledge for the participants, especially for me. I personally think one of the most challenges for Muslim scholars is to understand Islamic law from two perspectives. First, when the law was revealed by Allah Subhanahu wa Ta'ala with the intention to understand the purpose of lawmakers atau maqasidus syariah. Second, in the term of legal construction, application, implementation of the law, in terms of maqasidus syariah. So I want to respond from the perspective of Islamic legal reform. In usul fiqh, we recognize the postulate or the principle taghayyurul ahkam bi taghayyurul amkan wal azman atau taghayyurul ahkam bi taghayyurul azminah wal amkinah. In my opinion, there are at least three challenges for the Muslim scholar in understanding Islamic law reform. First, Islamic law is law that come from God revelation. Therefore, it will always be faced with social change. Imposition is Islamic law was mentioned in Quran and Sunnah, which was revealed in the past few centuries, can adapt with social change. The answers to this question can only be given after has been conducted on various elements of Islamic studies, tafsir, hadith, fiqh and usul fiqh. And one of the most, I think, the theory of maqasidus syariah. Second, from the historical aspect, the theory of maqasidus syariah was developed by Prophet Muhammad SAW. And last, the understanding of maqasidus syariah is the key to the success of mujtahid on his ijtihad. So in this occasion, I hope to hear the response from Professor Siddiq regarding to the possibility of redeveloping the principle of maqasidus syariah. Maybe not only 5 principles according to Imam Ash-Shatibi or 7 principles according to your article, maybe more than that in future social change. Juxtaposed with the main source of Islamic law, Al-Quran and Sunnah, the authenticity, the originality must be maintained. How to balance the authenticity of main source with the practice that is constantly evolving, and how Mahkamah Konstitusi, how Constitutional Court maintain that balance. I think that all my response. Thank you for your feedback, Professor, and thank you, moderator, for the time.
Yeah, thank you for Adi for your question and your opinion. And to Professor Siddiq, you may respond the for Adi question.
Many thanks for your response, Mr. Fadi. It's very nice discussion actually about Maqasid Sharia. I do agree with you that in Islamic principle we have like we call that the main source of Islamic law and the expanded source of Islamic law. The main source of Islamic law can define is like something that's fixed that we cannot change. It's based on the God right. So the God right we can change it. So if the God right say you must be a Muslim, you cannot change to be another religion. That is a part of a God right. That's an example. But in Islam, it also has what we call the field of interpretation. In the field of interpretation, the human being and the law scholar can expand and can what we call in Netherlands they call right finding or find the law. So the way of the find the law is can be depend on the situation and circumstance. So in the circumstance of 4.0, the law could be changed. For example, the using of ATM or the using of application of Islamic banking, that cannot be found in the time of Rasulullah. So that's where I say that the Islamic field can be changed in the base of a time, but something the God right we cannot change it. Look like the right of to worshiping the God and not to worshiping to another God. That's in my opinion is a part of a God right. So that's the difference of law scholar in Islamic law scholar and non-Islamic law scholar. In Islamic law scholar, the law is based on theological approach instead of principle approach. Sorry, you can still hear my voice?
Yes, perfectly. Professor Siddiq, yeah.
The law in Islamic context in based on not fully on philosophical approach, but is also to theological approach. So these two approaches has a main what we call sources for Islamic scholar. And then regarding your question about 5 principles that we here in Faculty of Sharia and Law have found 2 more principles, Bi'ah and Ummah is a part of 7 principles. But maybe in the next year to come, we can also find another principle as long as we can identify the principle in a scholar way. And then regarding the role of Constitutional Court, I can see that the Constitutional Court has potential power and jurisdiction, not only to make a judgment, but also to make a new law as well. We can see that's how Constitutional Court make a new law in terms of we call like positive legislator. That's we call that make a new law. Like in election law, they can make a new law, and in some of law of marriage law, they can also make a new law based on positive legislator. So I think the 5 principles of Shatibi, it could be expanded in years to come based on how the Islamic scholar can find a new way to finding and to solve new problem of law in Islamic context. Thank you.
Okay, wonderful. Thank you so much, Professor Siddiq, and thank you so much to
Thank
Fuadi.
you.
I'm so happy and feel honored to assist you both, Professor Siddiq and Fuadi, in this session. Thank you so much. And then,
You're welcome.
well, yes.
Thank you for the time.
Yeah. And now, last but not least, we have our third speaker, Ms. Neha Tripati and Mr. Anubhav Kumar from Maharashtra National Law University, India, who will be presenting their paper entitled Constitutional Tale of Religious Freedom, Comparative Study in Reference to India and Indonesia. And I believe that Mr. Kumar, who will be presenting their paper, and Anubhav Kumar is LLM student of Constitutional Law at Maharashtra National Law University. He specialized in constitutional, human rights, and energy law. Also, he has co-founded a research and communication group in India. That's very impressive, Mr. Kumar. And then, so you have 15 minutes to present your paper, and if you are ready, time and screen are yours.
Yes. Am I audible and visible?
Yeah. Yes.
So I'm really, I apologize because I cannot use my virtual background for some reason. So I may have to start with this only. So if you allow me, I'll start with my presentation. Yes. So a very good afternoon, good morning from India. Namaste from India. And,
Namaste.
Yeah. So my presentation is titled as Constitutional Tale of Religious Freedom and Comparative Study with Respect to Religious Rights in India and Indonesia. At the outset, I'd like to inform that my co-author, Ms. Neha Tripathi, who also is my professor, she has some medical emergency, and hence I'm the person who will be presenting the whole paper to you. So yeah, now I'll start with summarizing something starting with what exactly we are dealing with this research paper. First is that there are few elements of this research paper, and there are few aims which we try to achieve through this research paper, is to understand the comparative constitutional frameworks of religious freedom in India and Indonesia, which the title itself even indicates, and then understand how the establishment is, how the religious freedom, religious rights are established in the constitutional framework, specifically in India and Indonesia. And then we go on to study how religion, which is very basic for human existence, has in liberal constitutional and liberal democracy, premised itself to be one of the most prominent rights over the year. And then we also try to understand that how Indian constitutional courts or Indonesian constitutional courts over the year have adjudicated on religious rights. So for example, in India, we have different tests determined by the Supreme Court, which is also the Constitutional Court. And then we go on to conclude with the comparative study with Constitution of Indonesia and religious right given to Indonesian people. So I'll begin with discussing the importance of religion. And religion is something which has been inherent and which has been innate to every individual. And over the years, liberal constitutional democracy have embraced the religious rights of people. And since the liberal constitutional democracies have embraced the religious rights of people, there is multiple problems arisen in this arena, because religion and state do not go in hand to hand at some level at a liberal democratic spirit. Initially, religion and state were in consonance with each other. They were in comparative with each other. But then their time came after World War, and when there are religious rights recognized as ultimate freedom. I recognize Professor Mustafa, Professor Faizan Mustafa in India, going on to say that religious rights are the ultimate freedom rights after civil liberty rights of freedom of speech and expression and freedom of thought, freedom of life. So this is how the religious rights are poised to be discussed in this short study which we have tried to conduct. And it has also, and because religious rights have become so important in liberal democracies, they are also to be looked at from the prism of right to equality and human right genesis also, because these rights have over the year taken form of human rights and gross human rights violation over the year in different parts of India, Indonesia, and multiple countries, have led to this discussion of whether human rights, whether religious rights are human rights or not. So these are few pretexts of the discussion which actually leads us to deliberate upon the religious rights. It is also important to consider that religious rights in India basically, and when we move on to religious rights in India, we have to consider that the only way, the only optics how religious rights can actually be recognized as a constitutional right in India is to be giving them a fundamental to be giving them feature of a protection of a basic structure. I mean, in India, everyone is aware that India has a basic structure doctrine which says that certain elements of the constitution cannot be amended. And my fellow speaker in other panel, Professor Arora, was discussing about this constitutional rights of religious rights as basic structure rights which cannot be amended and taken away. In India, Article 25 and 26 of the Indian Constitution, 25 to 29 essentially, and 25 to 26 provides religious rights to people and person, not only the citizen, to the person, to practice, profess, and propagate their religion. Obviously, these rights are not absolute because it's a fundamental right, and fundamental rights are not absolute in India. It has some reasonable restriction of public order, health, and security of state, and also they are subject to other constitutional rights as recognized in several cases by the Indian courts. But the problem is that whether India is a secular state or not has to be decided first before we go on to delve into whether religious rights can be mandated by constitutional courts or not. And since India does not have a constitutional court altogether differently, the Supreme Court of India has determined so many tests to reach upon the constitutional rights of all constitutional and religious rights. So I'll go on to discuss upon I'll go on to discuss upon secularism now in my second limb of discussion. So we all are aware that India in this Asian ethos is considered to be a secular state, but in essence, it was not considered to be a secular state when it gained freedom and when it actually had its first constitution made in 1950. But however, it was introduced, the word secularism secular in Indian preamble was introduced in 1976 with 42nd constitutional amendment. The traces, however, were present. I mean, it's a paradox which I'm saying that in 1950 it was not considered to be a secular state, but it was just on paper, but the essence was already there. And in Constitutional Assembly debates also, it was considered that Article 25, 26, they all manifest the essence of constitutional rights of religious rights of constitutional people, and in some way they actually give secular rights and secular modus to Indian Constitution. It is also important to understand why India and Indonesia are in this context being discussed, because India has a predominant Hindu majority. Altogether, they have Hindu, Muslim, Sikh, Isais, and every other religion propagating there. But India is majoritarily predominantly Hindu, which has considered itself to be a secular state. And likewise, it's for Indonesia, where majority is considered to be Muslim, but they have also in their preamble went on to say that they believe in one God. So this is the pretext to decide why we are discussing upon constitution religious rights in Indonesia and India. Now I'll go on to discuss with some Supreme Court judgments of India as to how they have went on to decide what religion rights is. Because there is one important thing is to be considered, that religion word itself is a ubiquitous concept because it has not been defined in a sense that it has a constitutional mandate. However, it has been manifested through other rights of Article 25 and 26, but they are not manifested in a sense that the courts have the duty to determine what it means. So the Supreme Court of India in this one famous case called Shirur Math case, they actually went on to give a test to determine religious practices. I mean, in India, it is popularly called as Essential Religious Practices Test, ERP test. And to get the immunity of Article 25 and 26 in Indian Constitution, which precisely means that you have right to profess and practice your own religion, you have to prove that these are essential to your religious practices. And in that case, the court actually went on to say that this theological decision to be made, like whether this practice is religiously essential to your religion or not, shall be done by the Indian Constitutional Court, or Supreme Court of India. So in that case, it particularly decided that the onus of deciding whether a practice is essential or not lies with the courts. And this is where the Indian courts have been criticized vehemently from few cases. If we see Shirur Math case, and then there was this famous Haji Ali Dargah case where the Haji Ali Dargah Act was challenged. So in these particular cases, the court have gone on to say that the essential religious practices test has to be met to recognize the fundamental right of religion of people. So what I'm trying to take you through is to understand how religious rights in Indian Constitution and their interplay with Indian Constitution goes on to develop at a level where the Supreme Court itself has developed a character of being clergy, if I may point out in a positively or a very polite manner, that Supreme Court of India, in a liberal constitutional democracy where people have their own rights to determine their religious autonomy and religious structure, has gone on to be a clergy and assumed the character of clergy, wherein it has over the time gone on to determine every practice, whether it is religious or not, to determine whether they will be getting religious freedom or not. So this has been vehemently criticized, and there are few constitutional scholars in India to name, for example, Gautam Bhatia, who has gone on to say that the constitutional courts usurping the power of religious freedom of people is not correct, and it is not constitutionally mandated, and it is not constitutionally suffice to be taking away their power. And they have gone on to say that there should be one practice called anti-inclusion test. So anti-exclusion test, sorry, I beg my pardon, anti-exclusion test. So what is anti-exclusion test is basically all the, if you see Haji Ali Dargah case in India, where people were excluded, where the women were excluded from practicing, then there was Sabrimala, which is in down south in India, a temple where where the age bracket of 10 to 50 years of women were excluded from practicing because the Lord Ayappa, the deity there, was practicing celibacy. So if you see these religious restrictions or religious rights, religious practices, they are in a sense exclusionary in nature. And the courts have gone on to, the scholars have gone on to say that instead of going into determining whether what is religiously essential for a country or for a religion or not, the court should essentially determine whether practice is exclusionary in nature or not. And when they determine whether a practice is exclusionary in nature or not, which means that whether it is taking away the basic rights of equality, basic rights of untouchability, which has been taken away from people. So these are the few things which Indian Constitution, this is how Indian Constitution and the religious freedom which are constitutionally mandated plays on with interplay of individual rights. And mind you, the Indian Constitution places individual liberty and individual at the center of everything, every ethos of rights. So, in conclusion, it is said that the Indian courts has to move on from essential religious practices. This Sabrimala case, only Dr. D.Y. Chandrachud actually has gone on to say in his obiter that it is time to abjure ERP test and go on to anti-exclusion test. Now, moving on to Indonesian context, whichever we could, if time permits, within 2 minutes, I'll try to conclude what we have tried to draw a parallel with Indonesian courts is that Indonesian constitutional courts is that the first that Indian constitutional courts have been too active or have been actively taking upon decision on religious rights, and in context, the constitutional courts of Indonesia have been gradually taking up the role of consciously giving the religious rights to people. To understand this, that as I discussed also in my third part, which I am right now in, that the preamble of Indian Constitution discusses that only one and only God is mandated and which is found in Article 29 also. But but there are 6 religions which are constitutionally mandated by Indonesia. So there is a paradox in my opinion that if there is one and only God, the manifestation of 6 religious rights, which is thereafter to be given, which was also a case. Also, in my opinion, there was a case that the people of religion, the people of Indonesia, are to carry a national identity card, which actually describes the religion, and it actually went on to hamper some of the minorities' right also, because some religious practices which are practiced by those people were not covered into those 6 those brackets of 6 religions. So obviously this was the courts have taken a magnanimous step and tried to accommodate there here and there. But the major problem or major concept of deliberation in Indonesia religious rights is the blasphemy laws, which Constitution of which Indonesia, Republic of Indonesia has. In context, the Indian constitutional courts and the Indian Constitution themselves have a religious right, but and blasphemy rights are in penal laws, and whereas the blasphemy law in Indonesia constitutes of defamation and deviation of law, deviation of anything which the National Council says, which is premised into Article 1 and Article 4 of the Indonesian Constitution, where a person can be prosecuted for blasphemous act after getting an administrative warning, and then Article 4, which says that people can be actually imprisoned for this. So government in Indonesia has maintained right to determine the religion as it has in context with Indian laws, where it has been premised with, taken away with the Indian constitutional courts. So all in all, in conclusion, I would like to say that the religious rights are a right which are constitutionally mandated, and they manifest the liberal democratic values or liberal constitutional values of people. And these rights are individual in essence, and they should be people who take their decision, they religiously determine themselves, and they have religious autonomy on themselves. And in India, the courts need to go away from essential religious practices to anti-exclusion test, which gives more rights to people. And in constitutional courts of Indonesia, in my opinion, the Indonesian government needs to step back and let the courts and people determine their own religious and their own constitutional ethos. So that was my 4-part presentation. I'm sorry I could not present a PPT at a short notice. Thank you so much.
Okay, very well. Thank you, Mr. Kumar, for your presentation. I like your chosen topic, and I promise that I will finish reading your full paper after the session ended. It's very interesting for me. And for that, I would like to invite Miss Anne to share her ideas and talk. Miss Anne, if you are ready, time and screen are yours.
Thank you, Mr. Rima, as moderator. Excellencies, ladies and gentlemen, dear colleagues. I'm pleased to be here, and I'm honored to have been invited by the committee to address this conference. And I am particularly pleased to have been given the opportunity to listen and to these great presentations. Very good and very interesting presentation, and try to respond to Ms. Neha Tripathi and Mr. Anubhav Kumar this afternoon. For the first time, I want to respond to Ms. Neha Tripathi and Mr. Anubhav Kumar papers with the title Constitutional Tale of Religions, Freedoms, Comparative Study in reference to India and Indonesia. And first of all, I would like to address the issue about the general contextualism for the freedom of religions. Speaking of the freedoms of religions, there's 2 aspects to the rights to freedoms of religions that need to be considered, namely the aspects of internal freedom, or we can say that like a forum internum, and the aspect of the external freedom of forum externum. Internal freedoms, forum internum, which concerns the spiritual existence inherent in the every individual is the freedoms that everyone has to believe things, choose religions or believe, as well as freedoms to practice religions or has belief privately, so that these internal freedoms cannot be interventions by the state's external freedoms, or for whom external is one's freedoms to express, to communicate, to or manifest spiritual existence that he believes into the public and defends his faiths. Furthermore, freedom of religions in the eyes human rights has a complex positions in the constitutional configurations. Religious freedom has an important position too. Most the human activities are protected by article on freedoms of religions, freedom or expressions, politic freedoms. In freedoms of religions emerge that the most basic human rights in national and international political instruments long before the development of thinking about the semantics protections of rights, civil and political. However, it is related to religion freedoms in terms of the state finds many problems that the solution, especially if the problem is related to human rights. In Indonesia, there are many religions and belief, therefore it reflects heterogeneity and the recognition of human rights in freedoms of religion. The existence of religion in Indonesia is in a minority and majority position and guarded to have equal rights. This is guaranteed by Indonesia Constitution or Undang-Undang Dasar 1945, so that there is no principle of marginalizations which contradicts the concept of human rights regulated by the law. Normatively, Indonesian constitution has laid down the concept of more adequate protections and respect for human rights, regardless of the weakness might still be in at least the existence of article of human rights in Undang-Undang Dasar 1945 or Indonesian Constitution prove that Indonesian is a state of law that's committed to recognizing and respecting human rights to ensure the human rights are guaranteed to protect the Indonesian Constitution granting to authority for judicial review to constitutional courts with this authority potential or human rights violations through policies issues of the states can be not and resolved and human rights can be protected. So moreover, according to your papers in the conclusion state that the status of religious freedoms, especially with respect to religious minority, is highly questionable with various instances of suppressions of religion freedom and violations been noted officially. The dominance of majority threatens the existence of religion freedom and maintenance of liberal democracy in the states. This usually calls upon establishments of a robust mechanism for balancing in the interests and needs of religious minorities. Indeed, the judiciary through faced with the several oppositions and the challenges and been left with charges of a corrupt practice has played a central role adjudicating important constitutional question arising in pretext of individual right to religious freedoms. Based on my comment, I just have a question for you. That is, what is the Supreme Court's benchmarks in order to diffuse the tensions and the conflict between the religious interests with the state's interests. That's all my comment and the questions. Thank you, Mr. Moderator, for the times.
Okay, thank you, Miss Anne. And Mr. Kumar, you may respond, Miss Anne. But due to limited time, would you please make it short and fast, please?
Yeah, I'll try to make it quick. I'll just make one statement before I go on to answer her question, that I'm particularly impressed with what she has commented and remarked upon on religious minority rights, which being threatened by the majoritarianism growing all over the world. And that is not something which is really into India also, and which is also the question when in context to this, she has asked that what is Supreme Court stand. So I mean, yeah, this is a contentious thing which is to be answered by me right now. But I mean, to taking liberty of being very polite, I'll say that the Supreme Court or the Constitutional Court has. There could be two limbs of religious rights to be seen into. One is that, as you were mentioning about internal and external rights of religion. Another is that looking into whether their fundamental right of religion is being hampered. So, I have seen, in my humble opinion, that the Supreme Court of India, or maybe say constitutional courts in India, have been more interested into the first limb of the religious rights, which is going on to decide upon what actually constitutes religion, rather than protecting the religious rights which are mandated by the Constitution, which are also the fundamental rights. So this could be my small remark on what you have asked, and I hope so. If there are any more questions, I have my email ID and my co-author's email ID is also present there. Perfect. Someone can connect to me. Yeah, thank you so much.
Perfect. Yeah, perfect, Mr. Kumar. Thank you, Miss Anne and Mr. Kumar, for the interactive dialogue and sharing. And it's an honor to be your moderator in this session. Okay.
Thank you so much. Thank you so much for giving me this opportunity.
Okay, very well. Ladies and gentlemen, I believe that this is the end of session 2. Thank you for all speakers and for respondents in the session. And for the participants, thank you for joining the session, and please stay put. Mr. Lutfi Widakdo Ediono will moderate the next session. We will be right back. Thank you.
Mrs. Rima, thank you so much for moderating the previous sessions. Ladies and gentlemen, we're gonna go to the third panel sessions of today's discussions. And later, the next sessions will be moderated by Mr. Lutfi Widakdo Ediono. For Mr. Lutfi Widakdo Ediono, time is yours.
The 4th Indonesian Constitutional Court International Symposium, ICC-IS. Following the success of our previous international symposia in Surakarta in 2017, Yogyakarta in 2018, and Bali in 2019, the Constitutional Court of the Republic of Indonesia will hold the 4th Indonesian Constitutional Court International Symposium. The Constitutional Court of Indonesia provides an international academic forum to discuss various constitutional issues in comparative perspectives, with the theme Constitutional Court, Religion, and Constitutional Rights Protection. The Constitutional Court of Indonesia gives opportunities to legal scholars, researchers, lawyers, and practitioners to participate in the Indonesian Constitutional Court International Symposium.
Good afternoon, everyone. Gunler, Assalamualaikum warahmatullahi wabarakatuh. Selamat siang, ladies and gentlemen, friends, my colleagues. Welcome to the third sessions of the Indonesian Constitutional Court Symposiums. And first of all, I would like to introduce myself. My name is Lutfi Widagdo Ediono. I currently work as a researcher at the Constitutional Court of Republic of Indonesia. And for these sessions, we have three panelists. But unfortunately, one finalist from Palestine, Professor Asaid, unable to join us because his health issues. But we have two honorable speakers for these panels. First is I would like to introduce Professor Honorable Engin Yildirim. Professor Engin Yildirim has been a justice at the Turkish Constitutional Court since 2010 and was the vice president of the court between 2015 and 2019. And before his appointment to the court, he worked at the University of Sakarya, and he holds a PhD in sociology from the University of Manchester. And the second speaker is Professor Muhammad Ali Safaat from Faculty of Law, Brawijaya University. And he not just only an expert of the constitutional law, but also a human rights activist. And I would like to invite Professor Engin Yildirim. Professor Gunler.
Gunler, do you hear me?
Yes, we can hear.
And can you see me?
Yes.
Yeah. Okay.
Unfortunately, we can see you.
Yeah. Okay. Yeah.
Please open your videos.
I think my video is open.
Okay.
Anyway, let me start my speech.
On best dakika hocam.
Okay. First of all, good afternoon. Of course, for me, it's good afternoon. Good morning from Ankara. It's a very rainy and cold day for this time of year. It's not normal. Anyway, I'd like to thank the organizers of the conference for inviting me to deliver a speech. And I'll take this opportunity to talk about on the freedom of religion case law of the Turkish Constitutional Court. As an eternal clause of the Turkish Constitution, secularism occupies a very special place within the Turkish constitutional order. It's stipulated in the preamble and a number of articles of the Constitution. Since its official adoption in 1937, its meaning, content, and implementation have been one of the most hotly debated topics with the Turkish political and legal circles in the context of freedom of religion. The court has so far delivered 27 rulings in individual application cases and 121 rulings in its constitutionality review of cases. These cases have involved a range of issues, such as ban on wearing headscarf in universities and in the civil service, compulsory religious courses in primary and secondary education, religion bans on national identity cards, the high volume of the call to prayer in Ezan, political party dissolution cases, religion-based dietary requirements of inmates, election of church patriarchs, and confiscation of church property. What makes the Turkish case worth exploring is that the court has undergone a substantial transformation in its approach to freedom of religion cases in recent years. Once a staunch defender of what might be called a militant secular understanding, which recognized only a very limited space for religious activity in the public domain, it has come to allow a wider space for religious freedom in the public sphere. The Turkish Constitutional Court has been undertaking constitutional review since 1962, and it plays a crucial role in the political, economic, and social life of the country. It's composed of 15 justices with fixed term of 12 years and operate in the form of plenary, sections, and commissions. Article 148 of the Turkish Constitution stipulates the functions and powers of the court. On this basis, it examines constitutionality of laws in abstract and concrete norm reviews. It has also the competence of dissolving political parties and acting as a supreme criminal court for trying certain high-ranking public officials. The court's function as a judicial review body has acquired a new significance following the introduction of a presidential system in 2018. And it has also the power to see the constitutionality of presidential decrees. And finally, the court has also the competence to examine individual applications. Individual application is a procedure, it's a form of constitutional complaint where individuals and private legal persons who allege that their constitutional rights set forth within the European Convention on Human Rights and its additional protocols ratified by Turkey have been violated by a public authority. The decision of the Constitutional Court specifies what should be done to redress a violation and its consequences when required. Now, let me move on to, after this very brief sketch about the composition of the Turkish competences of the Turkish Constitutional Court. In the past, the court adopted a judicial approach, what might be called a militant or inflexible understanding of freedom of religion. It interpreted the principle of secularism in a way that religion cannot in any way interfere in state affairs, and its expression in the public sphere should be confined to strictly religious activities. It considered secularism as the most important constitutional principle and adopted, as I said before, a militant understanding of it. Not surprisingly, this led some problems for the enjoyment of freedom of religion. The most significant battleground between secularists and conservatives was whether university students would be allowed to wear headscarf in the college premises. Wearing headscarf at university was forbidden by the military government in the early 1980s. When the parliament enacted a law allowing it in 1988, the court annulled the provision because it concluded that this law violated the constitutional principle of secularism. Interestingly, in this ruling, the Turkish court understood secularism as a way of life rather than the separation of state and religion. It explained that although in a narrow sense, secularism is defined as the separation of state affairs from those of religion, it's widely accepted that it signifies the last stage of intellectual and organizational evolution that societies have experienced. It can be argued that the court's interpretation of secularism was based on the view that the state was under the obligation of secularizing society through imposing a modern way of life that leaves little, if any, room for religion in the public sphere. In another decision on the same subject, the court claimed that secularism in Turkey has a special historical particularity and must be implemented in a different way from the West. Furthermore, it urged the parliament not to set the headscarf free in the public area, in the public domain, because it would mean enacting law based on religious teachings, which obviously contravenes the principle of secularism. In a more recent decision delivered in 2008, the court observed that liberalization of the headscarf in universities would constitute a breach of the principle of secularism, as education can only be achieved on the basis of science, and the dogmas and dynamics which contradict with science should be avoided. In this judgment, the court extensively quoted European Court of Human Rights decision on the Leyla Şahin case, which ruled in favor of the headscarf ban in universities. The Strasbourg court maintained that wearing headscarves in universities constituted manipulation of religion for political purposes. Although it pointed out that as an individual choice, wearing headscarf is a component of freedom of religion, it took the view that headscarf, being a religious symbol, might be used to proselytize fellow students. The Turkish court accepted secularism as regulating not only political life, but also social, cultural, and intellectual life. For the Turkish court, attending classes with headscarf was not a subject related to religious freedom. Therefore, banning it was not regarded as a violation of individual democratic rights. The court believed that secularism as a constitutional pillar should legitimately regulate lifestyles of individuals participating in the public domain. For the Turkish court, since wearing the headscarf was a clear sign of a religious attire, it should have no place in the public life. Recently, the Turkish Constitutional Court has begun to adopt a more flexible, or what might be called a more liberal, understanding of secularism in its freedom of religion cases. This shift could be to a certain extent ascribed to the change in the composition of the court, which increased the number of justices from 11 to 17 following in a nationwide referendum. In any case, since the court acquired a new competence of concluding individual applications, which necessitated to follow closely the European Court's case law, it was not surprising that the Turkish court felt compelled to pursue a new judicial policy that was more sensitive to safeguard individual rights. In one of the first cases dealing with freedom of religion, the court examined constitutionality of introduction of selective courses regarding the Quran and life of the Prophet in the secondary education system. The court first noted that the Constitution views secularism as a political principle. As such, it's a feature of the state, not the individual or society. Therefore, a secular state should respect individuals' right to exercise and express their freedom of religion. The court argued that the courses did not violate the principle of secularism, as they didn't prevent the Ministry of Education from introducing courses for members of other faiths. It pointed out that there are two approaches to secularism. While the first approach is based on a rigid separation of public sphere and religious belief, restricting public display of religion, the other obliges the state to refrain from interfering in the right to freedom of religion, unless it has compelling reasons that are necessary to safeguard democratic society and public order. Secularism doesn't mean the suppression of manifestation of religious belief, because it guarantees the practice and implementation of religious faith. For the court, freedom of religion constitutes an essential ingredient of democratic secularism, creating negative and positive obligations on the part of the state. The former means that the state must not follow an official religion, and it must not intervene in the freedom of religion of individuals in the absence of compelling reasons. Whereas the latter requires removing obstacles to the exercise of freedom of religion, providing individuals with opportunity to learn and practice their faith. In the end, the court concluded that the introduction of elective religion courses in the secondary education did not run contrary to the Constitution. In an individual application, the court laid the ground for its new interpretation of secularism. The case was related to a lawyer's expulsion from a courtroom for wearing headscarf. The trial judge decided that lawyer's participation in the court hearing with her headscarf was in breach of the principle of secularism under the case law of the Turkish Constitutional Court. The applicant complained that the judge's decision for non-continuation of the hearing because of her religious attire violated her right to freedom of religion and right to equality. The Turkish court, after examining its previous case law and Leyla Şahin ruling of the European Court, found that intervention in the applicant's freedom of religion didn't meet the constitutional requirement of lawfulness because the interference wasn't prescribed by law, considering that no legal provision existed preventing any lawyer from wearing headscarf at courtrooms. Thus, Article 24 of the Constitution, where the right to freedom of religion is secured, was violated. Furthermore, the court also held that Article 10 of the Constitution, the principle of equality, was also violated as the local court had relied on singling out the headscarf as a strong religious and political symbol that is opposed to secularism. In line with its case law, the Constitutional Court observed that this differential treatment needed to be justified, but the local court had failed to offer a reasonable and objective ground for preventing the applicant from attending the hearing at the courtroom by wearing headscarf. In order to use secularism as a reasonable basis to justify the interference with the applicant's freedom of religion, it was essential to demonstrate the display of a religious symbol harmed right and freedom of others or disrupted public order. As a result, the applicant was put in a disadvantageous situation compared to those female lawyers who don't wear headscarf. This violated the prohibition of discrimination in the Turkish constitution. The Constitutional Court sought an evidence that wearing headscarf had an aggressive goal to interfere in others' beliefs and impose one's own beliefs on others. The restriction of constitutional rights cannot be justified on abstract assumptions. For example, we can't assume that wearing headscarf in the public sphere automatically conflicts with secularism. In order to reach such a conclusion, the state must provide evidence based on facts. The court further developed its new interpretation of secularism in another individual application. In this case, the applicant complained that her dismissal from public service for wearing headscarf violated her right to freedom of religion. In this case, the Turkish court conducted a proportionality analysis to determine whether there was an interference in the right to freedom of religion, whether it was prescribed by law, whether the limitation pursued a legitimate aim, such as the protection of public order, and whether the interference was necessary in a democratic society. It held that the interference didn't correspond to a pressing social need, neither that aims pursued to protect public were proportional. So the court concluded that the interference was not necessary in a democratic society. In the past, secularism was used to restrict the practice of religion by the court. According to the court's previous strict interpretation of secularism, religion should be left to the conscience of the individual and should not be represented in the public sphere. However, the new interpretation embodies religious freedom in the public area. Not surprisingly, wearing headscarf is no longer considered as a threat to the secular constitutional order. This approach doesn't clash with the view of secularism as a separation of religion from politics. What it means is that secularism means respecting all types of lifestyles, including those of a religious nature. It is within this context that wearing headscarf has come to be seen as a matter of religious freedom. I should remind that the Turkish Constitutional Court, in its new approach, should always emphasize the indispensability of secularism as a vital component of Turkish political and constitutional system. It has indicated that widening the meaning of secularism to cover religious freedom shouldn't be seen as undermining secularism, but rather it should be with democratization of secularism, which means respecting individual choices regarding religion. In addition to the above cases, the Turkish court has addressed with many individual applications involving other issues related to freedom of religion. Nonetheless, it mostly issued inadmissibility rulings in relation to these petitions because they failed to pass procedural thresholds. For example, they include cases dealing with property issues of minority religious communities, complaints about the high volume of the call to prayer, and also there are a number of pending applications related to the right to conscientious objection, on which the Turkish court has not yet ruled. A very recent important judgment has provided new safeguards for the protection of freedom of religion of minorities. The application involved state interference in the election of a religious leader of the Armenian community. When the Patriarch of the Armenian Church could no longer undertake his official duties due to ill health, the Armenian community sought electing a new Patriarch, but the state didn't allow it on the grounds that the then Patriarch was still alive and his official duties could be performed by his deputies. Instead, the authorities appointed a Patriarchal Vicar General. The local administrative court decided that 1863 regulation for the Armenian nation and the ensuing directives issued by the Ministry of Interior stipulate that an election for the seat of the Patriarch could only be held if the incumbent Patriarch dies or resigns from office. Hence, the state refusal of the request for a new election was in line with the law. But the applicants had complained that this decision was violated their right to freedom of religion. The Constitutional Court, in this case, first pointed out that the election of a religious leader constitutes a form of manifestation of religion under Article 24 of the Constitution, protecting freedom of religion. It then reiterated that fundamental rights might only be restricted by law. In the present application, this restriction couldn't be seen as being prescribed by law because the relevant legal provisions, which dated back to the Ottoman times, were not accessible and foreseeable that would enable individuals to be aware of the law. In the court's view, this could lead to arbitrary action by public authorities. It concluded that the state failed to demonstrate a pressing social need that overrode the spirit of Armenian traditions and the Armenian community's will, and therefore its interference in the applicant's right to freedom of religion could not be regarded compatible with the requirements of a democratic society. The magnitude of the ruling lies in the fact that it creates a precedent for similar cases related to the internal affairs of officially recognized religious minorities in Turkey. As one of the oldest constitutional courts in the non-Western world, the Turkish Constitutional Court has recently begun to adopt a more right-based adjudication. This shift has largely been due to the introduction of the individual application system, which has compelled the court to reflect the Strasbourg case law. But compared to the Strasbourg, in freedom of religion cases, the Turkish court seems to have a more liberal attitude for the applicants complaining about their interference in their freedom of religion. To conclude, we can suggest that the Turkish court has been largely able to interpret secularism in a balanced way that protects both religious liberty of persons and the secular character of the Turkish constitutional order. Thank you for your attention.
Thank you so much, Professor Engineer Drums. And for the audience, keep in mind that the Turkish Constitutional Court is established in 1961, if I'm not mistaken. So it's very interesting to understand and to analyze the dynamics in the court, especially related to the secularisms and also the debate between the secularists and also the conservatives. And to discuss it more, I would like to invite my distinguished researcher, Mas Reza, Muhammad Reza Winata, and you only have 10 minutes. Start now.
Okay. Assalamualaikum warahmatullahi wabarakatuh. First of all, thank you, moderator and organizing committee for this remarkable opportunity. It is an honor for me to give response to this valuable paper by Professor Engineer Dream. Thank you, Professor, for your outstanding presentation that enriched our knowledge about constitutionalism in Turkey practice. Based on the paper, I strongly agree with the professor's statement that Turkey's constitutional court plays a crucial role to achieve ideal legal system in the Turkey, especially protection on freedom of religion. One of the most fascinating insight in this paper, in my point of view, when the professor explained there is significant transformation in the relation between secularism and freedom of religion. So we can clearly understand that in the past, there was strict interpretation of secularism by Turkish Constitutional Court, which restrict the practice of religion. Then the religion only in the conscience of the individual or forum internum. However, currently, the Turkish Constitutional Court interpretation of secularism also guarantees religious freedom in the public sphere or forum externum. According to all of this information, allow me to ask several questions to Professor. First, in my humble opinion, one of the challenges in judicial review which related to religion is sometimes there is still multi-interpretation which exists in certain religion teaching. For instance, sometimes interpretation to religion teaching from Muslim conservative group is contrary to moderate or even liberal Muslim. Another example, some group of Muslims say headscarf is obligatory. In contrary, another group said it is not obligatory. So if there is gray area in religion teaching, how the justices of the Turkish Constitutional Court try to overcome this problem in order to balance between secularism principle in one hand and freedom of religion in other hand. And the second question, in this paper, you said that secularism as an eternal clause of constitution which occupies a very special place within the Turkish constitutional principle. From this statement, I have questioned what is the most common obstacles to enforce or execute current interpretation of secularism which guarantees more freedom of religion? Is there any disobedience from other state institutions, or is there resistance from the society that prefer to remain uphold the strict secularism? Thank you, moderator.
Thank you, Mohammed. Yes, I also encourage all the participants to, if you have any questions or comments, please give sign to the organizer. And Professor Yildirim, it's your turn now.
I'd like to thank the respondent for his comments. Now, secularism as a constitutional provision is one of the constitutional provisions that cannot be amended, cannot be removed. It's eternal. It's an unamendable. It should be there. So there is no doubt about that. The problems arise from its interpretation, especially in the public sphere. In the past, this created many problems, but currently, it seems the issue is settled. But we should remember that the majority of Turkish population it's Muslim, and they belong to Sunni school, Sunni sect. But we have also a significant Muslim minority, Shia minority. We call them Alawi. For example, they strongly reject these religious courses in the schools. They also complain about the official interpretation of religion by a state body called Directorate of Religious Affairs, which organizes religious life on the basis of majority's understanding of Islam. So different understanding of Islam sometimes clash in society. And we have some applications about these issues, but the Constitutional Court has not yet delivered any judgment on this method. Especially, there are some individual applications complaining about from this minority Muslim groups, not the mainstream, the minority Muslim group. And they say that their understanding of Islam is suppressed by the official bodies. So this is a problem. And the court will try to solve this problem in a balanced and delicate way. And the problem is that different religious groups have a different understanding of religion. They have a different understanding of Islam. And some of them, unfortunately, may sometimes try to impose their understanding to other people. And this creates problem, especially, for example, during the Ramadans, in the fasting season. It may create sometimes small problems. But the court, when it decides on these issues, it should create a delicate balance between respecting everybody's, whether it's Muslim, Sunni, or Shia, or Christian, or atheist, or whatever, freedom of religion, and protecting the political system based on strict separation of religion and politics. So it's a great challenge, and I think the Turkish Constitutional Court will be able to overcome this challenge. But it's not an easy solution. There is no easy solution to solve this problem. I hope I have been able to answer your questions.
And also the second question, Professor, related to what is the obstacles? Related with the question from Mohammed, we understand that Turkey is also part of the European Court of Human Rights. How to make a balance between it, especially in related to the freedom of expressions and freedom of religion.
I see. In all cases, we try to closely follow the Strasbourg case law in freedom of expression, in the right to privacy, or the right to a fair trial, and freedom of religion. But in freedom of religion cases, especially with regard to this wearing headscarf, the Turkish court differed itself from the European court, because European court, for some reasons, it has its own interpretation. For example, wearing a headscarf by a female student in a university is not a problem in, say, in England or in France or in Germany or other members of the European Council. But it was a problem in Turkey in the past. Now it's not a problem. The political system and the court solved it. And I believe the European court, in especially freedom of religion cases, especially with regard to female attire, has a strict understanding of it. And that understanding was borrowed from the Turkish Constitutional Court former case law.
Reza, do you have any following questions? Because I feel that you try to raise a questions.
Me?
No, Muhammad, Reza, the respondents.
I think it's enough. Thank you for the answer, Professor.
Thank you so much, Professor Engin Eldrum.
Yes, just one sentence before finishing it. Because we know that if we don't rule in a way that is in line with European Court of Law, the applicant would go there, would lodge an application, and the court, the European Court, would deliver possibly a violation judgment, and it would make the whole individual application system meaningless, because our individual application system is based on the implementing European Court of Human Rights case law within the country. But with the exception of the issue wearing headscarf, we more or less follow the European Court's line.
That's very well explained by you. Thank you so much, Professor Engin Eldrum.
Thank you. You are welcome.
Yes, günaydın in the Turkey. Have a good day.
I wish I were there. I wish I were there in Bandung.
Oh yeah. Unfortunately, this situation. But
maybe next time.
It's for the next year, probably. Professor, thank you so much.
Thank you.
Thank you. Have a good day.
Yes, thank you. Bye.
Bye. Next, we will have academics from Brawijaya University, Professor Ali Safaat. He is my friend. When I joined the court in 2005, he's my senior, and now he became a dean of the Faculty of Law of Brawijaya University. And as mentioned before, Professor Ali Safaat also a human rights activist. Time is yours. 15 minutes, Professor.
Okay, thank you very much, Lutfi. My voice is clear?
Crystal clear.
Okay. Okay, ladies and gentlemen, first of all, I would like to thank to the committee that invited me to this fruitful discussion, fruitful forum in this afternoon. And I will to present my paper concerning the role of the Indonesian Constitutional Court on determining the differentiation and relation between state and religion. I begin my presentation with the big picture of my paper, that through the Constitutional Review Authority, the Constitutional Court examined the law, including several laws relating to religion. And of course, the touchstone used by the court is the Constitution, where Pancasila
is part of the preamble, and in its chapter also regulates the rights to freedom of religion and worship. And the ICC has a role in determining the differentiation and relationship between state and religion, and also the relationship between religious and secular spheres. Religion may influence and become the substance of the state law, and when it becomes state law, it actually becomes secular area, so that the state could choose or limit religious law. The state authority to limit religious law, which has become the state law, has been strengthened by the decision of the Constitutional Court in reviewing the law relating to the religions, especially Islamic law. And in here, I use the concept of differentiation as part of the secularity, as the result of the secularization process. The secularization has been used as actually an ideological concept that has an evaluative connotation, containing a kind of positive or negative assessment of the separation of religion from social life. Secularization can also be seen as empirical phenomenon of the social development that separated the domination of institution and religious symbol. Given the concept of the secularization in terms of differentiation, religion is no longer the sole define all of reality. Differentiation allows religious institutions to make decisions autonomously, even though state institutions can, of course, influence them. With the differentiation, religion can also develop relative autonomy to provide a basis for morality to both support or oppose the state power. Religious differentiation from the state power does not eliminate all religion influence on the state. The religious community can influence the public policy, but is not a determinant. The influence is positioned as an aspirational equal to the other aspiration. And in this context, Wahhabsar and Fuson differentiate secularism and secularization. Secularism is a philosophical ideological movement, the ideology that spirit the state, especially the politics and religion. And on the other hand, secularization is the process of distinction between the religious domain and other social areas, including the reduction of the religion role in social life. And then secularity is a form, whether cultural, symbolic, or institutional, that saw the distinction between religion and other social areas. Thus, secularity is a result of negotiation or social contestation process. The boundaries between religious and secular area, of course, always negotiated, challenged, and renewed. And in Muslim countries, the rejection of secularism and secularization does not necessarily mean the absence of the distinction between religion and secular. Monica Wahhab and Burson divide the form of secularity in four models. The first is security for the sake of individual right and freedom. So security needs and enforced for the sake of individual right and freedom. The second, security in order to balance or reconcile religious diversity. And third, security for the sake of social integration and national development. And the last but not least, security for the sake of independence and development of the domain function of the society. Next slide, I will explain that for me, Pancasila is a form of the Indonesian secularity. Pancasila actually is in the middle point between the secular nation state and Islamic states. I think our Indonesian people are now well about this. Pancasila, on the one hand, affirms that the state is spirit organization that is not at the same time a religious organization. This means that the state remains in a profane or worldly territory with all its rules and devices that are also established and carried out secularly. However, what the state goal and implementation, even through deciding and executing secularly, remain possible to be influenced by reason derived from religious teaching. And Pancasila is a dynamic institutionalization of Indonesian secularity and experiences shift of meaning and implementation of the Pancasila. Pancasila was born as the result of agreement needed to overcome the problem of diversity of Indonesian people who need unity or integration in order to realize nationality. So I conclude that Pancasila is a form of secularity for the sake of national unity in order to achieve national goal. And Pancasila, of course, do not embrace the separation between religion and state, but it also does not become the basis of a religious state. Both are distinguished and interconnected, but still not mutually occupied. Religion is an area of the society where the role of the state is to protect and facilitate. On the other hand, the state or governance is the territory of the state, but religion can play a role by strengthening social ethics and influencing the state policy through the political and legal mechanism. And since the state has space to regulate the religion, there is a space for the state to intervene the religion. Considering that the state is a secular institution, the more the area of the religious life governed by the law, the state have the more potential to intervene the religion, which also means the more secularization process, which is formed and operated by the secular institution. On the other hand, the community adherence to religious law is no longer due to religious consideration, because this is the order of the religion, but the compliance of the citizen to the law of the state. And this is the relation based on Pancasila that's, I believe, used by the state in regulates the law considering law on the religion, especially in Islam, and also used by the constitutional court in decide the case before the court. And for the legal policy, we can see that actually for the independent state of colonialism, the reality of legal pluralism run by the colonial government was serious concern. It placed citizens in not the same condition and often discriminate on the basis of race, religion, ethnicity, and regionalism. So the struggle for freedom is not mere liberalism only, but also to end the differences in legal treatment. Therefore, one character of the post-national state is to reject legal pluralism. Legal unification is a state policy to replace the plural colonial law. Legal unification contains the consequences of not adopting different law based on the religion held by the community. However, current development have been different since many countries have adopted legal pluralism, particularly in private area. And in Indonesia, the state stands between the two interests of realizing a simple and definite legal unification and accommodating the plurality of law that live in society. The existence of some law concerning the religion, for example, marriage law, compilation of Islamic law, zakat management law, hajj law, waqf law, Sharia banking law, and state Sharia securities law. The reason it's concerning the halal law are widely seen as the success of Islam group incorporating Islamic law in state law. But in fact, it is more a necessity to unify the law. From various law concerning the religion, for me, there are three objectives of these laws. First is to unify the law that apply to Muslim. For example, for compilation of Islamic law. Second is to maximize the economic potency of the Muslim. And the third, to protect and facilitate the implementation of the religious life. And these three objectives actually are secular because only related to the social affair and made by the state as a secular institution. And this legal policy also strengthened by the state, by the Constitutional Court decision. And after the existence of the Constitutional Court, aspiration of the Islamic law enforcement, which in the past only through the legislation, after the existence of the Constitutional Court, also appear in the form of the petition for judicial review of the law relating to religion against to the Constitution. And based on the decision of the court, Islamic law goes along with the national law and can even be restricted by national law. The decision of the Constitutional Court also emphasized the different understanding of Western rule of law within Indonesia that use religion as one measure whether a law is good or not, even constitutional or not. The court decision have determined the differentiation and relationship between state and religion. Some of the decision in here, for example, first decision number 19, 2008, this is concerning the authority of the Constitutional Islamic Court or religious court. The court affirmed that Indonesia is not a religious state, although it's also not a secular state, and the national law must ensure the integrity of the ideology and integration of the territory of the state, and establishing justice and civility for religious tolerance. Thus, national law become integrating factor that unifying the nation. State service to the citizen is not based on majority or minority adherent of religion, tribe, or race. Islamic law is not a formal source of law, but the material source of law. Islamic law is indeed a sort of national law, but not the only one, because in addition to Islamic law, customary law and Western law, as well as other legal tradition, become the source of national law. Therefore, Islamic law can be one of the material source of ingredient of national law. Islamic law may be used in conjunction with the other source of law. The second decision concerning the marriage law, I think, concerning the polygamy that have to have permit from the judge, the state considered that the court considered that the state is the highest organization in the society formed based on the agreement. The state not only has the authority to govern, but also the obligation to regulate to ensure the justice. Therefore, the state also has obligation to support the realization of the happy family, including to determine the requirement to the polygamy, which is not concerning the worship in the court decision. The third decision, number 68, 2014, this is concerning the interfaith marriage. The court said that based on the constitution, religion become the foundation of the state, become the foundation of the marriage, and the state has interest in the marriages. The state play a role in providing protection to form family and to continue offspring through legitimate marriage that are manifestation and guarantees of human survival. Marriage should not be seen only from a formal aspect, but must also be seen from the spiritual and social aspect. And in here, religion establishes the validity of the substantive merits, while the state established administrative legitimacy. The decision number 140, 2009, the court acknowledged that the belief in God is the domain of the forum internum. However, that does not include freedom of non-religion. In the name of the freedom, a person or group cannot erode the religiosity of society that has been inherited as the value that animate various law and regulation in Indonesia. The establishment of the law by the state, the government, as well as the judiciary, use the divine and the teaching of the religious value as the tool for determine the good law and bad law, even the constitutional or not constitutional. This is how the court acknowledge the religion value in the development of the national legal system. And the last decision, number 97, 2016, regarding the population administration, I think Pak Palguna already mentioned about this case, that in this decision, the Constitutional Court emphasized that religion and belief are two different things that have equal status. The ICC stated that the right to adhere a religion or belief is a constitutional right, that not a gift from the state. And in conclusion, from the legal policy and from the decision of the Constitutional Court, have three conclusions. The first, this is a clear distinction between state institution, the state law and religion law. This is two spirit organ. The state remain in profane and or worldly realm with all its rule and devices, which also established and carried out in secular manner and different from the religion. And second, the state should not make law that obligate the implementation of certain religious teaching. For example, makes law that obligates Muslim to pray 5 times a day or to fasting in the Ramadan. But the state also will not make law that interfere religious freedom and worship. The state is in a position to guarantee and facilitate religious freedom and freedom of worship within the limit, shall not endanger public order and safety. The third conclusion, Islamic law could influence and enter the substance of the state law. But when it becomes a state law, it's actually become a secular territory, so that the state might limit the Islamic law in the state law. This can be seen from the limitation of the religious court authority, the limitation of polygamy, and the other. And the last conclusion, the religious life that can be governed by the state is related to the forum externum, which is the practice that has the social aspect and human relationship, especially related to family law. In the aspect of worship, of course, the state only regulates the implementation facilitate and not concerning the ritual, for example, for Hajj law. I think that's all my presentation. Thank you, Lutfi.
Thank you, Professor Muhammad Ali Safaat. Is never-ending discussion to make a statement that Indonesia is a secular or not. And I believe you already have a stand for that. And we will have my friends is our distinguished researcher that become the respondent for your sessions. And I would like to invite Miss Sinaga, Miss Erlina Sinaga. Please, time is yours.
Thank you for the opportunity. Thank you, Mr. Lutfi, as a moderator, ladies and gentlemen, and also Mr. Ali Safaat as a speaker. First of all, I'm very interested with this paper. Thanks to Dr. Ali Safaat for the great presentation. I have learned many things from the presentation, and I want to respond the presentation, the entitled "The Role of Indonesian Constitutional Court on Determining the Differentiation and Relationship Between State and Religion." As we know, based on decision of the Constitutional Court, there is no indication to afford to change the ideology or put the Sharia Islam above the Constitution. And then I interested about the paragraph in your paper that say, considering by the state is a secular institution, the more the area of religious life governed by the law of the state, more potential of the state intervention on religion, which also means the more secularization that is from on operated by secular institution. Talking about the differentiation of religion and state in Indonesia as a Pancasila state, that the statement of Indonesia as non-religious and non-secular state, which had never existed before, didn't get a theoretical basis at first, except as joint agreement from the people of Indonesia, various religion. However, referring of secularization as differentiation, it is clear that distinction between religion and state, which declared to be not a religious state and not a secular state, that religion is the best middle way to bring about a good public life. Seeing the history of the establishment of Pancasila in Indonesia as the basic for the relationship between religion and the state, it must be acknowledged that it cannot be separated from the active role of religion in Indonesia. Indonesian Muslim as a religion embraced by the majority of Indonesian people are also far from monolithic. Likewise, tribal religion are scattered in various regions of Indonesia. All religions in Indonesia have played an important role in the history of Indonesia's struggle for independence. This is guaranteed in Article 29, Paragraph 1 of the 1945 Constitution. The state is based upon the belief in the one and only God. And Paragraph 2, the state guarantees the freedom of religion for its citizens and to practice such religion and belief accordingly, which is basic norm interpreted as possible only with Pancasila democracy. Islamic rules for Muslim, Christian rules for Christian, Hinduism rules for Balinese Hindus, or Buddhist morality for Buddhists. In this paper, Dr. Ali Safaat have explained very well about the Constitutional Court decision that have determined the differentiation and relationship between state and religion, like the limitation of religious court authorities, polygamy state authority to regulate muamalah, blasphemy law, interreligion marriage, and recognition of belief. We know Constitution typically regulate the relationship between religious and state authorities. Some establish connection between the state and particular religion or religions, or even give religious law or institution privilege placed in the legal political system. Others declare the secularity or the state or seek to protect the neutrality of the state from any religious affiliation. Most constitutional design process will have to consider the problem of religion-state relations. There are particularly important constitutional designs associated with Muslim majority countries, religious diverse society, and society where there have historically been tension between religious and secular authorities. So from the all of presentation of the Mr. Ali Safaat, I have a simple question that I want to know more about. We know currently religious and political are hot issue to be discussed. There are many cases related to religion and political issue. So it can be said that religion can be related to politics. Religion as a political tool, especially in case they have occurred in Indonesia. So that political modernization in Indonesia in some extent has brought about political secularization. Yet in the Pancasila state, the process will not be will not lead to a secular state. The relationship between religion and the state are intersectional relationship, neither fully integrated nor completely separate. According to your opinion, how is the relationship between religion and the state in the context of political modernization in this reform era? I think that's all my question and
Thank
my
you, Erlina.
response to your paper. Thank you, and I give it back to the Mr. Moderator. Thank you.
Thank you, Erlina. Very interesting highlighted from Erlina, and also very difficult question for Mr. Ali Safaat. And and I thought that Erlina tried to ask about what about the law in book and law in actions in Indonesia's context. Please, Professor Ali Safaat.
Okay, thank you. First of all, I would like to comment about the conclusion that's actually the more of religious law become the substance of the state's law. It's actually the more secularization of the substance that's come from the religious law. For example, in the marriage law, that's I have mentioned about the polygamous clause that's in the law regulated needs to have permit not from the first wife but from the judges. Is actually a kind of limitation, a kind of the secularization. If we cannot say that it's actually a monogamous principle in the marriage law, it's different from the Islamic law actually. And in the other, we can find actually in the other law concerning the religion, for example, for the zakat law that give the authority to the Basnas to collect the zakat. And actually Basnas, it's a secular organ because created by the state, not by the religious authority. So if the more religious law become the substance, of course the legislative will choose and will limit based on the Indonesian condition. Even from the perspective Islamic law, we have the explanation from the Islamic law. This is the kind of the Islamic constitutionalism based on the Maqasid Sharia and the other. But from the perspective of the national legal system, from the perspective of the sociology, it's kind of the secularization of the Islamic law when enter to the substance of the state law. And the last question concerning the political, of course, we have to realize that first, the religion, it's a very hot issue that can be capitalized by the political group. It's not only in Indonesia, I think, even in the United States, America, even in the Europe that's declared they are based on the secularity, but the religion issue, it's very hot issue, very good issue for the political capitalization. So it's of course have influences to the relation to states and religion. But actually in Indonesia right now, in the reform era, we have a very big difference if we compare to the condition in maybe in the new order and then the old order. That's politically the society still have the idea to make Indonesia as Islamic state. The base of the state it's Islam. And this is not happen in the reform era. In the reform era, the aspiration is how the Islamic law become the substance and how the law is responsive to the need and to the aspiration of the Muslim society.
And politically, actually, we can see from the result of the general election that no one of the political party that based on the Muslim society, I'm not say the Islamic party because they not declare as Islamic party, never get the dominant influence, never gets the majority vote from the people. So this can be a manifestation of the shift of the society. That's not anymore become eager to create become eager when they give the issue of the religion with the politic and the other. This is also we can see from the result of the presidential election when two pair, the one use of the religion issue and then the other use the other not religion issue. So the people still choose. So it's mean at least that the religion issue it's not anymore very hot for the people. The people is going to rational when they choose the leader, the political party in Indonesia. I think that's the reality that we can see in Indonesia right now. Thank you.
Thank you, Pak Ali Safaat. I'm curious, what is religion? What is belief? And in Indonesia, we have recognized beliefs or religions, but we also have unregistered religions or beliefs. And if you, as you mentioned before, that so many law that made for the Muslim people, but is it possible to understand that they are more protected? I mean, the Muslim people more protected than the other religions because the state provide more law.
Not actually, more intervention.
Sorry,
yes.
before you answer the questions, we have one participant that want to raise questions. Please, Dr. Mujahid Aidin, can you hear? Dr. Mujahid Aidin, you can join us if you want it. Mujahid Bey, can you hear us? Please, Oscar Dines, I can hear your voice.
I have a question to Justice Yildirim. Is he still with us? I don't know.
I don't know. Probably you can just provide the
yeah, but that's a long question. I want to make sure you're around. Justice Yildirim, are you with us? Yeah, still, or can you hear us? Maybe not. I don't know. Well, I can make put my question in general terms if you would like. Yeah. Just some ideas. And I was encouraged to ask this because of the comments of Dr. Ali, his general comments on the interaction between the religion, the economics, and the society. And as Justice Yildirim explained, the laicism, the secularity played a very controversial role in Turkey in respect of religious freedoms. In the near past, indeed, it was used to oppress religious freedoms. For example, the headscarf ban at universities. And it's not a secret that these bans were not embraced by the public, by the big portion of the society, except very marginal small groups. And then in early 2000s, the political landscape has changed in Turkey, and the new government first distanced itself from such issues, but then gradually relaxed religious bans and expanded the religious freedom indeed. And today we can say that at least the majority of the society who are Muslims enjoy a great deal of freedom. So I was thinking, who played the decisive role in the relaxation of these bans or in the direction of the movement toward more religious freedom? Was it the society, the government, the state, or was it the court, the Turkish Constitutional Court? Because as Justice Yildirim gave us some examples, the court delivered many judgments on the freedom religions and finding violations and therefore expanding the freedoms. But I'm wondering if it was the government or the society who actually initiated this movement toward more freedoms, and the court then enjoyed a right on this movement, or was it vice versa? And how was this interaction? And that's, I think, an important issue to determine whether it is the law and the court who leads the change, or is it the society itself or the state institutions in government institutions play such roles. I think that's an interesting aspect of this topic too, and just wanted to bring that to your attention, and thank you for giving me a voice. Maybe we can hear from Dr. Ali if he has some commentary on and some comparison with Indonesia on that regard.
Thank you, Dr. Mujahid. Thank you, Doctor. Please, Professor Ali Safaat.
Okay, thank you. The first question from Lutfi. I think it's not necessarily that's the moral law that's concerning the religion, for example, from Muslim. It's mean that the rights of the Muslim people the more protected by the law, because actually some of the law it's already live in the society. For example, the Waqf law, the Sharia banking law actually can improve by the society itself, by the corporation, not needs to be legalized state's law. Even in some aspect, for example, for Hajj law, of course, this is needs the rule of the state, because this is a huge work to moving the pilgrimage from Indonesia to the Saudi Arabia. But the other aspect, I think it's not necessarily more protected. For example, in halal law, that's the makes the halal certificates as obligation for all of the thing that's distribute and sell in Indonesia. It's actually in Indonesia, all people have already care about the halal haram, and this is more burden for the corporation, for the enterprise to get the halal certificate. So the more law relating to the religion, it's not necessarily mean the more protection for the Muslim adherents in Indonesia. And
or people, or probably the more concern of the government,
the more political issue. And from the colleague from Turkey, I'm sorry, what's the name of the colleague from Turkey?
Mujahid.
Mujahid. Yeah, Mujahid. I think there are some differences between country and between time periods in Indonesia. During the old order and the new order, the government have the significant role in connection to the guarantee the freedom of religion. And this is, of course, depend on the political constellation in Indonesia, because the government have the rule. For example, in Indonesia, actually, in maybe 1980, actually the student in the public high school and then the university also bans to use headcraft, to use jilbab. But after the 1980, when the Muslim middle class have entered to the circle of the President Suharto, they can change the regulation. So the student, even from the elementary school until the high school, have the freedom to use headscarf based on their religion, that this is obligation for the Muslim. Even some of the Muslim in Indonesia still have believed that this is not the obligation for the Muslim. This is the part of the Middle East culture to use headscarf. And this is
connecting in the reform era after the creation of the Constitutional Court, some of the freedom of religions not introduced by the government, but by the decision of the Constitutional Court. For example, the recognition of the belief that equal rights with the religion. Before that, the belief adherent is the second class of the citizen in Indonesia. The belief it's have to support to become either a certain religion. Yes, we call Abrahamic religion actually. Abrahamic religion have the special position. This is more high than the other belief, than the other syncretic belief in Indonesia. But by the decision of the Constitutional Court, this is the recognition of the freedom of religion, including the belief. I think this is going to change, and I think it's also different with the India, because the India, the rule of the court is relatively dominant than the government in supporting the freedom of the religion. I think that's my answer, my comment, Lutfi. Thank you.
Thank you, Professor Ali Safat, and this is the end of our sessions. Thank you so much, honorable speakers, and also distinguished respondents, and also the participants. Thank you so much for your attentions. And back to the MC, please.
Thank you so much, Mr. Lutfi Widagdo Ediono, for very well moderating the previous sessions. Ladies and gentlemen, we have come to the last panel sessions for today's discussion, and I believe it's gonna be more and more interesting. Now, I would like to invite Mr. Lutfi Chakim to moderate the next panel sessions. So for Lutfi Chakim, the floor is yours.
The 4th Indonesian Constitutional Court International Symposium, ICC-IS. Following the success of our previous international symposia in Surakarta in 2017, Yogyakarta in 2018, and Bali in 2019, the Constitutional Court of the Republic of Indonesia will hold the 4th Indonesian Constitutional Court International Symposium. The Constitutional Court of Indonesia provides an international academic forum to discuss various constitutional issues in comparative perspectives, with the theme Constitutional Court, Religion, and Constitutional Rights Protection. The Constitutional Court of Indonesia gives opportunities to legal scholars, researchers, lawyers, and practitioners to participate in the Indonesian Constitutional Court International Symposium. For further information, please visit www.iccis.nkri.id.
Assalamualaikum warahmatullahi wabarakatuh. Distinguished speakers, respondents, and participants, ladies and gentlemen. Welcome to this special session of the 4th Indonesian Constitutional Court International Symposium. My name is Lutfi Chakim. I'm a constitutional researcher here at the Constitutional Court of the Republic of Indonesia. In this session, we have truly remarkable speakers. Our first speaker is Professor Anis Bajrik Tarefik, PhD. Professor Anis is a chairperson and a professor in international law and global political studies in Vienna, Austria. He has authored 8 books for American and European publishers and numerous articles on mainly geopolitics, energy, and technology. Professor Anis is also an editor of the Geopolitics, History, and International Relations Journal, an editorial board member of several similar specialist magazines on 3 continents. His 9th book, entitled No Asian Century, is scheduled for fall 2021. Our first speaker is Dr. Baldizar Sartali-Todd. Dr. Baldizar is a research fellow at the Department of Constitutional and Administrative Law in Budapest, Hungary. He earned his comparative constitutional law master from Central European University, Budapest, and his PhD degree from Eötvös Loránd University, Budapest. He is interested in cardinal law legislation with qualified majority parliamentary law, the limitation of fundamental rights, the jurisprudence of the European Court of Human Rights, the law of citizenship, and problem of legislative omission in the legislative jurisprudence. Our last speaker is the Dr. Al-Fitri. Dr. Al-Fitri is an associate professor of Faculty of Sharia Law, State Islamic University Sultan Haji Muhammad Idris Samarinda. He is also a social legal scholar with formal training in Islamic law. He obtained LLB and MA in Islamic law from Islamic State University UIN Sunan Kalijaga, LLM from the University of Melbourne, and PhD law from the University of Washington, where he was a Fulbright scholarship recipient as well. His teaching and research interests are Islamic law and its interaction with law and society and law and religion in Indonesia. He has published his works in International Journal, Non-Profit Law, Journal of Law and Religion, National Journal for Comparative Law, and Study Islamica. His monograph, entitled Islamic Law, Society in Indonesia, Corporate Zakat Norms and Practice in Islamic Bank, is forthcoming at the end of the 2021 with Routledge Publisher. So we have 3 different speakers from 3 different countries. We have 1 speaker from Europe. We have 1 speaker from Austria, we have 2 speakers from Europe, 1 speaker from Austria, 1 speaker from Hungary, and 1 speaker from Indonesia. So it's gonna be very fruitful discussion for this session. So without further ado, let me turn the floor to our first speaker, Professor Anis. Professor Anis will be presenting the topic entitled Indonesia Pivot to Asia, 3 Fundamental Challenges for the Republic of Indonesia in the Age of Technobiological Disruption. I believe that this topic is very useful for Indonesia as a religiously diverse country, and I guess there will be a lot of interesting discussion regarding the problem and challenges facing by the Indonesia, especially in the age of the digital age. Professor Anis, I will hand it over to you, please.
Thank you, and first and most of all, compliments and congratulations for the excellent conference that you have conducted in a row for so many years, and I've seen the program of this conference, so it's brilliantly done, conducted, and also I see that you are going absolutely on time, so it's perfectly like a Japanese bullet train. My full capacities are related to Austria and Switzerland, but right now I'm still on holidays in Italy. But still, I managed to have batik with me, so as a sign of appreciation, although it's not Friday day, batik day, so I just try to address you today, your audience, with the batik on me. So the topic that I'm trying eventually today just to galvanize audience and to trigger some thinking and further research is not really new, so it's adapted. I had a tour, a speaking tour through all of Indonesia. I think I've been at least at 20 places, so it's not something which is not known, and it's not something that I was not writing before. So I'm inviting everyone who is interested in the view that I'm trying to share today to find my text in Jakarta Post and elsewhere in Southeastern Asia, or in one of my many books. As for 15 minutes I can't be that structured, and of course for the conference there is no possibility to give a lecture to people. So it's not a lecturing, but exchanging of views. So essentially, Indonesia has a very pivotal role, not only territorially as being the, let's say, the smiley. If you see the ASEAN in a graphic, you know, you would see that Indochina would be somewhere where the eyes, and then the Malaysian peninsular part would be the nose, and then the smiley on the face of smiley would be the Indonesian archipelago. So it's not only geography of Indonesia that is giving its pivotal role for Asia and also beyond, but it also reflects the policy understanding since the liberation, since the independence of Indonesia, and the forefathers of Indonesia who concepted even the poor and wrecked country after the devastating actually fight with the Dutch forces, who were not eager to leave Indonesia that easily, who fought bravely the war with the Nazis for 4 days, but then soon after they've been liberated by someone else, because Dutch were not liberating themselves in the Second World War. It was Americans, but it was Americans or Anglo-American forces, because the Soviet and Yugoslav forces who were fighting Nazis consecutively for 5 years were actually knocking down the Nazis, and they opened the road to opening the Western Front with the Anglo-American troops. So physically, Anglo-Americans liberated the Netherlands. And then, so as I said, 4 days, the Dutch were fighting bravely Nazis. And then soon after, nearly the first thing that they conducted was actually they assembled the Navy, and they reconquered, or they restaged actually the positions in today's Indonesia. And they fought bitterly and savagely. So it was practically a sort of a genocide. And for 4 years before the liberation of Indonesia have been successfully conducted. But still the country, and this is a lesson of history that we should have never forget. We should not forget very important chapters of history, especially when it comes to Indonesia. And then, although the country was very poor, it was very soon going into big time internationally. There was a Bandung conference, which was practically giving a birth to the non-light movement, in which Indonesia, from the very first days, from the Bandung of 55, where you're conducting right now a conference. So practically through the first conference of non-light movement of 61 was playing the role. And for all let's say skeptical voices and individuals, I always invite them to come to the United Nations forums and to see the standing and this soft power that Indonesia enjoys. When Indonesian delegates talk in the international forums, especially in the UN, everybody listens, because it is a gravity, and also it's a history. It's a long it's a long period in which basically Indonesia was a champion of multilateralism. And if you want, and this is a known argument of mine, if you want to see the champions of multilateralism in Asia, then by the rankings, it goes number one comes India, then comes Indonesia, then comes Japan. So those are the champions of multilateralism. And if we talk about anything which would be going into further multilateralization of Asia, because Asia has a very successful economic story, has a booming and vibrant demographics, but still is missing political forces and is lacking actually the multilateral setting. This is the largest continent and the only continent that has no pan-continental setting. Europe, when you say Europe, you know, people would say European Union. European Union is far smaller than Europe itself, as an idea and as geography as well. So essentially, Council of Europe is the truly pan-European setting. And then the Organization for Security and Cooperation in Europe form a conference, the Helsinki, let's say, a multilateral setting. So Africa has African Union. It was Organization of African Unity. Now in Africa, they call it even Union. It's African Union, headquartered in Addis Ababa. So, and then Americans have Organization of American States. So basically every continent has multilateral pan-continental setting, but Asia is missing it. And ASEAN and eventually SAARC of Indian, excuse me, of Indian subcontinent would be those, let's say, potential candidates to spill over to true multilateralism. So Indonesia has this potential and this position basically to offer something into as a heavyweight of multilateralism, although Indonesia is relatively, especially for Asian measures, it's a smaller country or medium country. Of course, for Europe, we have no, even by far, a country close to that number of inhabitants like Indonesia. But as Asia is demographically enormous, it's composed of several heavyweights. So we can say Indonesia is, let's say, a middle-sized country, be it geographically or demographically. So this is one of the challenges as I set up. So the challenges for Indonesia and challenges which are universal, which Indonesia also, which are reflecting on Indonesia and which are relevant or they matter to Indonesia. So I've listened to the previous speakers and I saw the list of speakers. So it's a lot of talk about religion, about constitutionality, law, Sharia, secularization, how secular states should be, and so on and so forth. One of the fundamental questions in the crossroads of the Muslim world, of the Muslim Ummah, is actually a question of Islam and modernity, interpretation of the holy texts, and what sort of, let's say, state setting should be done. Is it the secular state based on the European model, the best model for the Muslim world, or it should be having a closer, let's say, tilt towards Islam, and what kind of Islam? We can't make a rigid interpretation of the holy text, be it of Bible, be it of Torah, or be it of Holy Quran, and put something from which has been revealed in the 7th century to be 100% fitting and applicable for the 21st century in everyday life. Of course, in a philosophical sense, those are immortal books. Those are let's say, timeless notions and the books in the philosophical sense, but not in a practical, in everyday life. So basically, it's a pan-Muslim debate, and Indonesia, which is the non-Arabic Muslim country, but largest Muslim country, I would rather say on periphery, so it's a periphery of the Muslim world, has, let's say, a special attachment to it and has a special, let's say, responsibility. First of all, to answer to the Islam, it's to its own Muslim people and inhabitants, then to coordinate this Islam with the non-Muslim population of Indonesia. I would just remind you something which you very, very well know. Let's say the Christian community in Indonesia is larger than nearly half of the Christian European Union states. You should know that you have over 20 million of Christians of different denominations. Czech Republic is under that number. Slovakia, Croatia, Slovenia, Malta, Portugal, Ireland. There are so many EU countries, Sweden, Finland. So there are so many, Greece. There are so many countries of EU which are actually having, and they are Christian countries that are having smaller number of Christian, let's say, population than Indonesia itself, and of course others like Hindus and other religions. So there is a special attachment to answer to the questions of Islam and modernity to its own people, then to accommodate this and to articulate this in a positive way by not alienating, not disfranchising the non-Muslim population of Indonesia, which would be a very destabilizing moment for Indonesia. And thirdly, to contribute to the overall Muslim debate. So it's a lot of homework to be done. And then Indonesia is a champion of multilateralism. I was already mentioning, this was my entree into the topic. And finally, the accommodation of the newly formed middle class. I can't go into explanation because we don't have time. But middle class, when you see when you try to analyze the rise of fascism in Italy and Nazism in Germany, when you see forces of ISIL or the Holy Caliphate of Syria and Iraq, you will see that the protagonists were well-informed, well-educated members of the middle class. Middle class is very, very, we can even joke, like a dual-use technology. Middle class could be very constructive in society, can bring the progress like Swiss progress or progress of the Western Europe, especially after the Second World War. So middle class is a carrier of it, but it can be a dark, destructive force. So one of the most important debates, and I'm always reminding people, my friends in Southeastern Asia, watch out the direction of middle class. Those are people who are migrating from the rural countryside. They come to the large cities, they get education, but it's in the one generation, it's sometimes too much for them. And therefore, the orientation, the ideological attachment, the cultural, let's say, the system of value attachment for this newly arriving middle class is very, very fragile. Indonesia, we talk about huge demographic numbers, has every year 2 to 3 million of new arrivals into the middle class. The ASEAN, by some calculations that I did nearly 10 years ago, annually, ASEAN has 5 million persons that are becoming a middle class, that are elevated from poverty, that are cutting more or less links, at least the permanent links with their rural hinterlands, and they are coming to new cities and they are starting with a new life. They are educated and they have to accommodate. So it will be a fundamental question to answer in the decades to come, and therefore very, very clear interpretation of a line. What is the state and what is the separation? Is it state separated from religion, and to what degree it's separated? I wouldn't say you should copy in Indonesia and elsewhere and in Southeastern Asia, you should copy European model. But secularization of Europe was coinciding with the prosperity, because everybody wants to live in the United States and everybody wants to live in Europe, and people are still admiring, the style of life and the living standards there. But it starts with the secularization. So what I'm inviting you is to energetically visit those chapters and to find the best actually line for yourself. So I wouldn't ad limine take one or the other option. I would say, okay, so state should be penetrated by religion and by ulema, or on the other side, it should be strictly secularized. It should be absolutely sterile from anything. I would not go into that, but I would say visit the chapters of the regions, especially of Europe or Western world. What has happened with this world when they secularize, when they separated state from the church businesses? Because divinization of politics is very dangerous. When you are actually finding or the misuse of religion for the daily political activities. And from Machiavelli on, or even from the old school of the antique Greece, philosophers and practitioners were discussing those topics when the divinization of the day-to-day political business, which is the art of possible, has nothing with the divine powers, is taking place. This is a dangerous ground, or as we in Europe, where we have snow and ice, we call it thin ice. Don't walk on a thin ice because, you can drop into the very cold water. So basically, those are challenges. And then also what is very important is to follow the processes in Saudi Arabia, because it's considered as a center of let's say, the Muslim world, and the pilgrimage, the main activities related to the religious persons are related to Saudi Arabia, which not only spiritually, but also in a way geographically is residing in the very core, in the very center of the Muslim world. So,
Professor Anis, excuse me,
yes.
I have to interrupt you. We have run off of time. Could you please conclude your presentations?
Yes. So practically, to see, whether ulema is going into anti-constitutional activities or not. So this is also something for intellectuals to let's say, to visit. It's impossible in the many countries, not only in the Muslim world, that actually the religious establishment is going into anti-constitutional activity, that they are undermining the constitutional order. This is unthinkable and this is unacceptable. On the three other things, which of course we are running out of time, nuclear self-annihilation and environmental holocaust, there is a lot of talk about this. We have unfortunate event in the Far East with the launching of new missiles, practically new escalation round, but also technological, biological disruption, which is related to so-called COVID event. We should return all activities from the narrow branch of executive power into constitutionality and into parliament. Parliament should discuss. Matter of public health is a matter of every citizen in the country. It can't be decided in the narrow circles. This is very important, and on this, our civilization will succeed or fail. Right now, we are directly into the world war, and this world war is a biological warfare war conducted against every principle that we have built for past 2 centuries. This is very important, and this is not so simple, vaccine or not vaccine, or delivery of vaccine into the let's say, poorer countries. This is absolute derogation and attack on the human liberties and freedoms. And we have to return things, not only in Southeastern Asia, but elsewhere,
Professor
to
Anis,
Parliament,
could you please
and
make it
also
short?
discuss it publicly, because matter of public health is a matter for each and every of us. Thank you so much.
Thank you very much, Professor Anis, for bringing us the very wonderful discussions. So we have now got 10 minutes for respondents. I'm going to invite my colleague here at the Constitutional Court of the Republic of Indonesia, Mr. Alboin. Can you hear my voice clearly?
Yes,
Mr. Alboin, I will hand it over to you to give a comment, feedback, or question to Professor Anis, please.
Okay, thank you, my colleague, Lutfi Chakim, for the opportunity given to me. Good afternoon, ladies and gentlemen, speakers, and all participants. First of all, I would like to thank you for this valuable chance, and it's an honor for me to listen to the great presentation from distinguished speaker, Professor Anis, regarding Indonesia pivot to Asia, 3 fundamental challenges for the Republic Indonesia in the age of technobiological disruptions. I would like to highlight an interesting issue related to the influence of technobiological disruptions on religion. Technological disruptions are impacting social as well as spiritual relationship, leading to the emergence of virtual religious or spiritual communities, weakening the territorial divide. One can argue that people living on the margins and peripheries have always experienced these disruptions. However, new technologies have enabled them to disrupt existing power hierarchies. It seems that technologies have disrupted the existing hierarchies to some extent, yet it has not changed the dominant public discourse. In this regard, I have a few questions based on my comment to Professor Anis. First, how does technobiological disruption relate to religion and constitutional rights? Will this negate or reinforce each other? And then on your slide, regarding to party ideology versus ideological function of state, you state that ideology of political party should not be mixed with the ideological function of state. So how do you think, can the state ideology be the standard of evaluation or parameter for judging the ideology of political parties? And the last, what do you mean by the new approach towards the doctrinate monotheistic religions, reinventing of religion in what ways and how to deal with it? That's all from me. Thank you, Mr. Anis. Hope your explanation will expand our paradigm towards this matter. And by the way, your rhetoric is very good, really nice. Thank you, and I return to the moderator.
Thank you very much, my colleague Albo in Pasaribu. Now we are having a feedback and answer from Professor Anis. Please.
Thanks for praising my batik. It's a solo one, so I got it in solo. The second intervention. So ideology of political parties and the state. So essentially, it's a frame and the painting. So it's very simple. And students usually always ask me, to clarify this. So basically, the state, one of the state functions is actually to provide the framework for the ideological contest of the political parties. Most probably, we talk about constitutional party, not forbidden parties, but also you have in many places in the world, like in Sri Lanka, in the Philippines, in Middle East, you had also those prescribed anti-constitutional or prescribed by law, so forbidden ones. But they also contested, in the sphere, on the realm of ideology. On the first question, it's rather complex, but one of the troubles of that also by this, so I'm not giving I'm old too much, I'm old enough, not to say to people, okay, take my argument, buy my argument, but I'm just opening, sometimes a splinter into mind, opening people to new horizons and new views, to make conclusions for themselves. So basically, since the technologies were introduced, if you follow, last 200 years, you will see that we've been rushing into new technologies. When Max Planck, when the theory of atomic physics was coming up, we have not explained, we didn't see, okay, we have a finally reconciliation between religion and science. There is a philosophical implication of quantum physics. What we did, we rushed to develop both, So unfortunately, there was something which Fukuyama calls defensive modernization. We always saw possibility in technology to expand our territorial domain and to satisfy our defensive or our offensive drives in the countries. So that's how we saw technology. And right now, it's not about, it's most probably not about health, or not to the degree that is explained to us. It's more actually to project power. This was a constant of our let's say evolution and the usage of technology. That makes me skeptical. It's not because I'm having a bad day here in Italy, It's simply I'm reading history enough, to see this as a constant. Another thing, unfortunately, some of the monotheistic religions are 2,000 or even more than 2,000 years. Unfortunately, on every critical conjuncture, on every critical crossroad of civilization, the clair was not with its own people. I would love to give you some other news, but there are no other news. See, Second World War, all leaders of the clergy, including also Muslims, a Grand Mufti of Jerusalem, they've been supporting and also enhancing the notorious crimes of the Nazis, not to mention Pope. Unfortunately, and also what is very striking today is actually a silence of the religious leaders, and there is even a hint of polemics. We can't take something which is a genetical therapy, because some of those injections are related to a modification of our genetic structure in cells. There is no even hint of the religious leaders discussing this. And that changes the nature. We are getting into a realm which belongs to God. Because if there is a God's hand, if there is a hand of the Lord, Almighty Lord in us, this is the DNA. Because DNA is such a fascinating thing. An intervention on our DNA is intervention into something which should be reserved for Almighty Lord. And we are not even hinting a debate about it. We're just putting this beneath the carpet, and people are completely confused. So unfortunately, for 2000 years, if you see every single critical moment of the human development, you will see that the leaders of the clergy were not with the people and were not giving. You know, when Europeans were conducting the genocide, the Atlantic Europeans, when they conducted so-called grand discoveries, which was the most brutal colonization, you know, it started with the Iberians and then French and Dutch and Britons, you know, the clergy was just supporting it. In the best case, they've been silent, you know. And unfortunately, you know, this is also a wake-up call for, I'm not talking about religion, I'm talking about the leaders who led or who participated into a misuse of religion for political purposes. And unfortunately, I'm telling you, I'm pessimistic because analyzing the entire history of human race, I see it today also. And this is something which is very tragic. And finally, before stopping, a very important thing, you know, if you are very frank, you know, I'm truly feeling myself as a friend, and I'm accepted in Indonesia as a true friend. I'm coming there for decades, you know. It's a shortcut to give, you know, to offer to a newly arriving middle class a rejuvenated interpretation of the religious text. This is a shortcut. This is so-called easy solution. Society, a vibrant society, very successful society like Indonesia, and Indonesia is not the only one, should do it better than to offer, in a way, a cheap religious replacement for the fundamental questions that are asked by the middle class. And it's not fair, you know, it's not fair for the religion, and it's not fair for the middle class to give them a short, cheap, let's say, shortcut. So, and we can all, you know, we can all think about, you know, how much this, let's say, the rejuvenated religious view, especially among the Muslims, you know, in Indonesia and Malaysia and elsewhere, is actually a cheap shortcut for the newly arriving fundamental question of the newly arriving middle class, which are asking existential question, who am I? You know, I'm the first one who has a tertiary education in my family. My family lives the rural life, and the rural life has its own system of values and order. And frankly speaking, you know, if we see the pictures of, I don't know, of KL, of Jakarta, of Surabaya, you know, of 2020 or 21, and if we see the pictures, you know, of 1970 or 75, or if we see now daughter, and if we see the picture of grandmother, we will also see striking differences. So is it really traditional? So I'm not taking side. I'm not telling, okay, do A, do B. I'm just telling, you know, if you are frank, we will go, you know, into introspection, and we will try to find answers. I think offering a cheap, quick interpretation of religious text to the whole spectrum of the identity crisis and identity questions asked by the newly arriving class is not fair. It's not fair for the middle class, and it's not fair for the religion. Is it a Christianity? Is it Islam, Judaism, or whatever religion we talk about? It's not fair to offer them, because newly arriving middle class should be giving a societal support. And this is also a hidden cost. You know, we say Indonesia has a growth of 6.9, 6.1, 5 point whatever, you know, and then the economists are happy. And then you go to World Bank, you know, World Bank says, oh, impressive. Indonesia is in the next century, in the next decade, you know, maybe 7th or 9th largest economy. It's beautiful, but there are costs of it. And costs are not only environmental, costs are also social. So we have to support academia. We have to support conferences like yours, you know, brilliant activities with your magazine in order to discuss and to explain and to understand firstly for us and to give answers. Giving, you know, shortcut and cheap interpretation from the holy text is not fair, and it's
Thank
a
you very
time
much,
bomb.
Professor Anis. It was a very good, wonderful explanations. But we have now got a 5 minutes question for an answer. So we have, I will remind all of the participants, if you have any question, just using a raise hand function in the Zoom. Okay, but what I can take a note based on your presentation is that at least we have, Indonesia has 3 challenges, including Islam and modernity, Indonesia, champion of multilateralism, accommodation of newly formed middle class. But do you have any kind of comparatively suggestion for Indonesia when it comes to the relationship between one religion to the other religions? Because you know that Indonesia is a religiously diverse. We have 6 recognized religions. So how to keep living in harmony among 6 recognized religions? And you know that the relationship between religion and state is also has posed challenges. So could you also give some kind of advice how Indonesia and the government should protect freedom of religion without any violating their fundamental rights to believe and to practice their religion? Thank you very much, Professor Anis.
It's very simple answer, you know, go to your grandees, you know, and ask your grandees how traditionally life was running. You know, Indonesia was not having frictions, you know, especially in the pre-colonial times. There was no friction. In Africa, there were no, I mean, everywhere you had wars, you had some calamities from time to time, but there was no systematic and poisoning of the population, division and disfranchising, you know. So if you want to see what is traditional, you know, because people sometimes say, okay, you are so smart, you know, so you give us, suggestions, but give us concrete example. I say, just ask your grandee. You know, if I want to see for my community, I would go to my own grandees and I would ask, you know, what is the interpretation of Christianity, of Islam? How do you treat your neighbors? This is the way. It can't be authors of the books, you know, who are published in New York, that they know better life in Surabaya, in Solo, or Marang, you know, than you know. So this is the best way. And what is also important is actually to publish, to voice yourself, to read, and to participate in debate. I tell you, the non-Arab Muslim world should answer the fundamental questions. Arabs are consumed by their own calamities, unfortunately. And the Arab Muslim world will not be able to give the comprehensive and, let's say, all-embracing answers to Islam and modernity. That puts additional burden on Indonesia because of its size, you know, of its geographic and demographic size. But first of all, that comes to Indonesia. And therefore, friends are serving, you know, and conferences like that. And I welcome more events of yours, and I congratulate for brilliant event. And also for your good moderation.
Yes.
Thank you so much.
Very well, Professor Anis. And we can't wait to read your upcoming new book entitled No Asian Century. Will be published in fall 2021 this year. So please let us know if the book already published.
Yes, and
thank you very much,
soon
Professor Anis.
see physically in Indonesia. I miss Indonesia. I was not traveling for a year and a half there. I was usually coming sometimes even 2 times a year. For days. Yeah.
Wonderful. Thank you very much for Professor Anis for your kind presentations and very good for fruitful discussion for us. Thank you very much and have a good day. We are moving on to the next speakers. We have Dr. Baldizar. Dr. Baldizar, can you hear my voice clearly?
Yeah. Can you hear me?
Okay, but can you please check your videos? We can't see your videos, or we can. Dr. Baldizar? Or can you please check your sound and microphone, please? Dr. Paul Desires?
Yeah, can
Is
you hear
everything
me?
good?
Yeah, can you hear me?
Sure, we can hear your voice clearly. Okay.
Yeah, okay.
Dr.
It's
Paul
fine now?
Desar, in this occasion,
Mhm.
Dr. Paul Desar
Yeah.
will be presenting the topic entitled A Little Research Aspect of Religious Freedom, the Negative Aspect. What can I talk and interest about this topic is that I have also published several articles on the freedom of religion protection in Europe, including the implementation of the margin of appreciations published by the Routledge. And we can, from the Dr. Paul Desar presentation, we can listen more detail about the European Court of Human Rights decision in terms of the freedom of religion protection. Dr. Paul Desars, the time is yours, please.
Thank you so much. So I am Wadija Galitot from Budapest, and thank you also for the invitation and the distinguished honor to be here. So my presentation would add some comparative aspect to this very rich discussion, even from Europe, even from other continents. And my focus would be the negative aspect of freedom of religion, because in most of the time, so when we are talking about freedom of religion, so there is an activity to express our religion, there is a faith, there is a belief which is protected. But in sometimes, so freedom of religion constitutes that we have to refrain
Dr.
from
Paul
certain-
Desars, would you please check your camera and put it right in front of your
Now-
face? Very good, very good.
Now-
Okay,
now
it's
it's
good.
fine,
Yeah,
it's fine.
thank you very much. And you can continue your
Okay.
presentation, please.
Okay. So it's fine. So freedom of religion have negative aspect also. And so most of the time, freedom of religion means that we express our religion by an activity, or there is a faith or a belief which is protected. But the negative side means that sometimes so we have to refrain from certain activity, or we have to look for an exemption under law with general applicability due to our religious views. And so this constitutes the negative aspect of freedom of religion. And so my presentation will cover this aspect especially in a comparative perspective. And this might be interesting also to Indonesia, because I guess that this negative side is also relevant to this country. And I also expect that you may clarify the Asian situation in this regard, because so my presentation will cover all the continents. Europe will be more detailed, but in other continents I will have some samples also. And obviously, because I haven't visited Indonesia before, so you may have deeper background from the situation there. In the Central European University, where I did an LLM some years ago, so I had a very good friend from Indonesia, but so this is my most relevant connection with your country. First of all, I will be talking about the freedom of religion, the most important approaches of freedom of religion, and then within freedom of religion, where is the place of the negative aspect? And then I will analyze which are the fields of social life where this negative aspect is the more important, and then in the third part, brief comparative insight will be provided. So freedom of religion might be described from a procedural aspect. So if there is a procedure to acknowledge religion or to acknowledge church as an established one, maybe there could be another approach, which is the functional one, that what can be the function of religion, what can be the function of the church in the society. So we might outline religion with certain characteristics which might be relevant for all of those faith, all of those views which are defined as religious ones. And maybe the fourth potential approach is based on self-understanding. So which communities which views are described themselves as religion. And it has been also mentioned that freedom of religion has an internal and an external aspect also. So the internal aspect is an absolute one because you can have such faith, whatever you would like to. But the external might be restricted by the state because the rights of others should be protected, and the fundamental rights of others and also public interests may mean any limitation of freedom of religion. And there is also an important distinction between the individual aspect and the collective aspect of freedom of religion, because in sometimes some ceremonies should be celebrated with others, but in certain religion activities, everyone should be alone. Maybe it's another interesting issue at the end of this part, that what kind of arguments may support freedom of religion or may justify freedom of religion just from a societal perspective. And so it is argued by several scholars, even in Europe, even in North America, that so when freedom of religion is protected better, the social well-being is also higher. So it's even the best interests of the society to secure a high standard of freedom of religion. Regarding the negative side, so within the religious freedom, there are such cases when, for example, there is a legal mandate to wear a uniform, for example, or there is a legal mandate to participate in certain celebrations, or maybe you have to be involved in certain social activities as a legal mandate, but this might be against your religious faith. For example, military service. So when you have to kill or you may kill others. So this can undermine your religious freedom. And so in these cases, certain special rules, exemptions should be provided for those people who faces with this situation. So in these conflicts, there is fundamental rights, which is freedom of religion, which is expressed by refraining from something. And in the other side, there is a public interest, which expect that everyone should follow the same legal prescriptions. And then we have to make a balance between this fundamental right and between this public interest, and somehow to find out which should prevail over the other. And this might also make a difference between regions, between countries, because if the facts are similar, for example, this military service, which I have already mentioned, so this might be approached differently, even in Europe, even in America, even in Asia, even in Africa. There are 4 main branches of the social life which are concerned by the negative aspect of freedom of religion. The first of all is the educational system. For example, if there is a mandatory prayer before a class, so is this constitute a limitation on freedom of religion, or the primary purpose is that you have to somehow symbolize the cohesion of the community, the unity of the community? It also depends from the text of the prayer, whether you have to express your religious identity, or there is just a general term of God and a general reference to the well-being of the community. So this might determine whether you have to participate in the prayer, or you could reject the involvement legally on religious freedom grounds. Maybe another issue, whether you have to consume any food in the school which is against your religious freedom. So, for instance, when most Muslim people should consume such kind of meats which are not permitted to them. So, and then in this case, you have to also the right to refrain from such kind of activities which is prescribed by the educational system, by the secular educational system. But the secular educational system should be also sensible to your special needs, which are justified by your religious faith. Maybe another issue is the religious classes. So when, and this should be a distinction again made. So there is a difference between teaching on the religion and that is the teaching the religion. So when in the class you try to convince the students, for example, that you have to convert a particular religion or leave or something like that. So this should be a restriction on the freedom of religion. But if that is just the purpose to make you know the main characteristics of religion, the main dogmas of religion, without the intent to convince you from the truth of the false of this. So this should be the inherent function of the secular educational system. And there is another issue, maybe the state funding of religious schools, which might be also contested. But when the school fulfills such a function, which is should be also fulfilled by the state, then such kind of funding might be justifiable. The uniform issue is it's also interesting, and this also leads us to the next branch of the social life, which are the armed forces, because even in the educational system and even in the armed forces, sometimes you have to wear uniforms, and as part of the uniform wearing, so maybe it is denied that if, I don't know, you would like to wear a cross, for example, or you would like to wear a half moon, but this is prohibited because you have to wear the uniform of the school or the uniform of the armed force. And there is another side also, when the school prescribe mandate to wear uniform, and as part of this mandate, you have to also wear certain religious symbols. Or when, for example, in the classroom, there were such cases in Europe, several of them, that, for example, in the classroom, there are also crosses on the wall, whether this means restriction on your religious freedom or this is just a symbol which should not concern a person with average religious sensitivity. The third branch of the social life is the healthcare, because sometimes some people reject the medical treatment on religious grounds. Whether you have the right to reject this kind of treatment due to the religious freedom, or you have the legal mandate to accept the health care, and you have the mandate to protect your health and your life. This is also another issue, especially in the light of the pandemic, the vaccination. So if some person says that I'm refrained from vaccination because this is against my religious freedom. So this fundamental right issue is very important, but in the other side, there is the interest of even of yourself, or at least the alleged interest of yourself, and that is the public interest that, so if you are not vaccinated, you may threaten the health of other people also. So this is again a balance. This should be again a balance found between these two things. And then the fourth branch of the social life is the military service, which I have also mentioned that in several countries, an exemption might be provided on religious grounds. And then now just a brief cursory glance to the case law of the ECTHR and then other continents also. Because so in the ECTHR, there is Article 9 of the Convention of Fundamental Rights and Freedoms, and the proportionality analysis on which the ECTHR judgments are grounded. So maybe the first interesting case amongst several of them is a Greece one, is the Alexandridis versus Greece. That so if you have to make an oath of office when you will be a public servant, and then during this oath you have to reveal your religious identity.
Dr. Paul Dizar, excuse me,
yeah.
I have to interrupt. interrupt you. Could you please conclude your presentations?
Yeah. So so if you have to reveal your religious identity during taking a note, so this should mean violation of your religious freedom. So in Europe, the scope of your negative religious freedom is relatively broad, but it is a little bit narrower in the practice of the Supreme Court of the United States, and especially in Asia, this might be even narrower. So I would like to just mention one more case in the Indonesia blasphemy law case, which is about that there are the aforementioned 6 established religion of Indonesia. And so the freedom of religion of those people who belongs to these 6 religions is protected efficiently, but there is no such protection for those people who fall outside from these 6 major religious community. And so your negative religious freedom also means that you do not belong to any religion. So there is a scale, just my closing remark, that there is a scale between the continents in how broad they protect the negative religious freedom. The ECTHR has a relatively broad protection. The US Supreme Court interprets the scope of negative freedom a little bit narrower, like the South African Constitutional Court. And even in Indonesia, even in India, it seems to me that the protection of this aspect is a little bit narrower. But so if you may add any clarification on the situation in Indonesia and in Asia in this regard, this will be highly welcomed, and I will use it for my further work. Thank you so much.
Thank you very much,
for your
Dr.
kind
Poldizar. Thank you very much again for bringing us wonderful discussions. The topic is very interesting. I also very impressed with your presentations, especially the protection of human rights and especially the freedom of religion in Europe under the European Court of Human Rights decisions and the US Supreme Court. But now, we have now got 10 minutes for respondents. I'm gonna invite my colleague again here at the Constitutional Court of the Republic of Indonesia, Ms. Sharfina. Can you hear my voice clearly? Are you ready to give a comments, feedback, or question to Dr. Poldizar? Okay, I will hand it over to you, please.
Okay, thank you, Mr. Lutfi Chakim, and thank you, Mr. Poldizar, for your presentation. I would like to express my appreciation of your paper for its comprehensive elaboration on freedom of religion based on cases from court ruling in Europe, US, Asia, Africa. And I want to point out some things on your paper. The first one is in exercising our rights or freedom of religion, there are limitations or restrictions, which is the right of the others, right? Like your title of the paper is the other side of the coin, the negative aspect of freedom of religion. The main issue of your paper is what is the proper assessment for someone to refrain from his or her legal duty or refuse to participate in binding commitment based on his or religious grounds, right? The main concept in this paper is like the rejection or refrain of certain activities means the negative sides of freedom of religion. In your opinion, how far the state should involve or intervene to reduce the impact of negative religious freedom, or could it be that the negative religious freedom literally means negative, or it can be positive impact? And based on what case did you agree on the court's ruling? Like what case gives the most influential impact in reducing the negative impact of negative religious freedom? Because there are some cases that pique my interest. From the Europe, there are the evaded compulsory military service, and in the US we have lemon cases, and in Africa we have the Prince versus President of Law Society. Right? It piqued my interest. So, what is the most influential cases that, in your opinion, can reduce the impact of negative religious freedom itself? I think that's enough for me. It's such a short and simple question, but it is quite
Wonderful, Ms.
interesting.
Sharfina. Thank you
Thank
very much
you.
for your comment and feedback and also questions. Dr. Paul Dizar, you have several questions from Mrs. Sharfina. She's my colleague at the Constitutional Court of the Republic of Indonesia. The question is about the restrictions or limitations of the protection of freedom of religion, especially how should the state interfere or restrict the protection of freedom of religion, and also what is the most influent cases, including like the practice of the protection of freedom of religion based on the negative aspect of the freedom of religion. Thank you very much.
Thank you so much, Mr. Moderator, and thank you so much, Ms. Sarfina, for the question. So this negative side is a very complex issue because there is a secular state which has seemingly religiously neutral law, a general legal mandate to everyone. But due to the religious sensitivities of certain people, the secular state somehow should show any religious sensitivity. And so we have to bound the scope of this sensitivity very clearly, because a balancing should be made between the weight of the religious argument of the individual or certain group, and then the interest of the whole community to maintain the legal order, to maintain the unitary legal prescriptions. So in my view, so although it's secularity of the state, so it should take into account the religious views of certain citizens as soon as it do not undermine significantly the public interest, which is furthered by the particular law. But so if this religious activity might undermine the protection of significantly the rights of others, or may undermine the public interest, which is protected significantly, then the state should maintain its legal order, and the exemption should be rejected. Obviously, this balancing is depending on the particular social context, the different countries, the different composition of courts. For instance, the US Supreme Court has a controversial case law depending on the current composition of the court, that how many judges from different views are represented in the body. So so this is not a black and white issue, but this balancing should be made, and the judicial bodies who deal with such issues should at least make an attempt to conduct this balancing correctly. It is obvious that the outcome of this balancing will be also contested. There will be people who will say that the religious freedom should prevail over the legal mandate, and there will be also people who will say that the legal mandate should prevail over the religious freedom in that particular case. So in the ECTJ case law, there are these Greece cases, which I've already mentioned about the oath of office. You know that whether if religious activity should be done during your oath, then this constitute and so if you should have a right to refrain from making an oath of office because the secularity of the state. Maybe I have to mention an American case which is very interesting, and this is the Lemon case, which is about the facially neutral laws, and so what is the system of criteria which should be met by an exemption under the scope of religiously neutral laws. So the law should have a secular purpose, and it should not advance or inhibit religion. This is also an important criteria. and should not result in excessive entanglement between state and the religion. This means that the state, although it's secularity, the state might show any religious sensitivity on constitutional grounds, but it should be avoided that the main purpose of the law would be the inhibition of religion, or just to make an entanglement between the church and the state.
Okay.
So the purpose should be secular and just on an exceptional basis, just to respect certain sensitivities. The law may permit some smaller exemptions. Thank you so much.
Thank you very much for your explanation. So what can I take a note is that the proportionality test or analysis is one of the function developed by the court to assess whether the state is proportionate or can be balanced between the freedom of religion and the limitation of freedom of religions. But now we have got 5 minutes for question and answers. If the participants have a questions, you could use the hand raise function in the Zoom. While I have one more interesting issues when I read your article and your presentations, Dr. Baldizars, especially in the protection of freedom of religion in Europe, as we know that the protection of religious freedom in Europe is regulated under Article 9 of the European Convention of Human Rights. And you know that this article has been interpreted in many cases by the European Court of Human Rights. And you mentioned a lot of cases, such as the case including the ban of the headscarf, and then the religious freedom in school, and the burqa ban. One of the interesting cases that I remember is about the headscarf ban, Leyla Sahin versus Turkey. The cases was mentioned by the previous speaker, Professor Engin. These cases, the court, on the European Court of Human Rights, developed or grant the margin of appreciation to state with the several considerations, such as the compatibility of Islam and democracy, the issue of secularism and gender equality. Another cases is such as the burqa ban in SAS versus France. In these cases, one of the interesting issues is that the court developed the new concept of living together to justify that the limitation of freedom of religion can be justified. One of the other cases is such as the Lauzi versus Italy. This is one of the interesting that it's about the legitimacy of the crucifix as a cultural symbol. So I just want to ask you several opinion or based on your perspective, whether the protection of Europe, the protection of freedom of religion in Europe is kind of something that really difficult to, because you know that Europe, we have, there are so many countries in Europe, for example, like laicity in France, and then secularism in Turkey, neutrality in Belgium. So that's why the European Court of Human Rights always grant the margin of appreciation to state just to escape to deal with this kind of issues. The reasons, one of the reasons is because there is no European consensus of these issues, and the state is better positioned to deal with this kind of issue. How is your opinion about this kind of issues, or whether the case law is also can be involved to the state when they want to restrict the freedom of religion to the citizens?
Thank you so much for the comment and for the question, Mr. Moderator. So there is an interesting difference between Europe and the US, because in Europe, so the system of the ECTHR is based on the national legal systems. So there is European supervision, but this has been confirmed.
Okay, just make it short, Dr. Baldizar, so we have run out of time.
Sorry. Yeah.
Okay, just continue your explanations, but very briefly.
Okay. So very briefly, so that in Europe, so this is based on the member states, on the legal system of the national systems, and there is a European supervision over the national legal systems, but this is the exemption, and a broad margin of appreciation is provided. In the United States, So the protection of freedom of religion is based on or started in the federal level. And later the Supreme Court said that this protection is also valid for the member states, not only for the federal government. So the direction of the protection has been different in Europe and in the United States. I don't know whether in Indonesia what is the model. So
Okay.
maybe I think it's yeah. So,
Very well.
but this is
Yeah.
an important difference. Thank you so
Okay.
much.
We truly understand your explanations and we appreciate your very great presentations. Thank you very much, Dr. Bordizar, and hope you enjoy the whole session of the International Symposium of the Constitutional Court, organized by the Constitutional Court. We are now moving on to the last speaker of this sessions. We have Alfitri, PhD. Dr. Alfitri will be presenting the topic entitled Constituting Islamic Law Through Judicial Reviews in the Indonesian Constitutional Court. Dr. Alfitri, the time is yours, please.
Okay. Am I audible enough?
Sure, yeah, it's very good.
Thank you for helping me with my PowerPoint presentation. Thank you, Mas Lutfi Chakin, for your generous introduction. I'm honored to be invited into this prestigious international conference and present my paper side by side with other distinguished scholars in the field of constitutional law and religion. Good afternoon, everyone. Thank you for attending my presentation. My last is the last session for today's conference. The topic of my presentation is still related to the previous speakers, such as Nadir Shah Hussein and also Siddiq Armia, who discussed the relationship between Islam, Islamic law, and the Constitutional Court decision. If they focus their discussion on aspect of Islamic law reform through judicial review or the suitability of the Constitutional Court decision from the theory of Islamic constitutionalism, I will discuss more about why there is still disobedience with this decision. Next. Okay, here is my presentation. Next. Okay, before I discuss further about this constitutional disobedience, I need to explain the context of the problem. In the last few decades, an increasing amount of Muslim countries have reformulated or amended their constitution by making Islam the official state religion. These Muslim countries also include articles related to Sharia as a source or the source of national law, and the implication that there should be no national law that contradicts Sharia or repugnancy clause. Therefore, the question of how to determine whether the state law is against Sharia or not is not a constitutional issue in these countries. Indonesia is different because Indonesia has not constitutionalized Islam and Sharia. As a country with the largest Muslim population in the world, the founding fathers of Indonesia agreed to make Pancasila, the 5 principles, as the basis of the state, and its embodiment in the form of a religious freedom in the constitution. However, the state bureaucratized religious affairs, especially Islam, through the Ministry of Religion, and incorporate certain aspects of Sharia into the legal system through legislation. This condition often triggers inconclusive debate in society about the suitability of state laws and policies involving aspects of Islamic teaching with Sharia. After the Constitutional Court established in 2003, it is certainly hoped that the debate on the suitability, conformity of legislation with Sharia can be resolved because the position and nature of the Constitutional Court as a final and binding decision. However, this expectation is certainly problematic because of the absence of Sharia repugnancy clause in our constitution and the lack of epistemic authority in my argument of constitutional court judges to perform ijtihad. Next. Next slide, please. Okay. Even so, many researchers believe that constitutional court decisions can be considered a or the official interpretation of Islamic law in Indonesia by using the Siyasa Sharia theory. However, if the constitutional court decision that implicate Islam can be justified in theory, then why is there disobedience with these decisions? Next. Okay, my take on this issue is that there are complex conditions that affect compliance with this decision. As a non-Islamic and non-secular country, the Constitutional Court can minimize, in my argument, the disobedience to its decision, which implicate Islam by doing first, accommodating the existence of Islamic legal authorities and doctrines in the court consideration. Second, by balancing the demands for protection of rights in the Constitution between the principle of belief in one Almighty God and the principle of liberalism exists in our constitutional right. Next. Okay. I mentioned earlier that the principle of belief in one Almighty God must be a factor that should be considered by the Constitutional Court in its effort to fulfill constitutional rights through its decision. The question is, what is the meaning? Can we go back to previous slide, please? I think you skipped one slide. Yeah. What is the meaning of belief in one Almighty God and its embodiment in religious freedom court norm in Article 29, paragraph 2? I here use Hazairin interpretation of chapter 29, paragraph 2, because it includes the initial interpretation to this constitutional norm. The Constitutional Court then also confirm the validity of this interpretation in several of its decisions that implicate Islam. For example, first interpretation can be seen in the Constitutional Court decision on the ban on interreligious marriage, and also the second interpretation, I think, related to the court decision on the constitutionality of state intervention in the application of Islam, for example, zakat, hajj, and maybe forthcoming halal product certification. Next. Okay. On this slide and the following slide, we will look at the concept of Siyasa Sharia and how it can be used to justify state laws and policy related to Islam. Because of the time limit, I will not explain at length, but the important point of this slide about Siyasa Sharia are the state is authorized by Sharia to make laws and policies that supplement Sharia as long as the legal products and policies mentioned above are not prohibiting the mandatory and not mandating the prohibited. Next. Next. Yeah. I think we can also skip this slide, but the important point that I want to point out here is that the judicial review process in the Constitutional Court has, in theory, fulfilled the Siyasa Sharia elements. For example, at the examination stage, the Constitutional Court has listened to the opinion of Islamic jurists regarding the disputed Islamic law issues. And also in formulating this decision, the court also referred to this opinion and used the technical term of Islamic law, for example, maqasid syariah, and then maslahah and so forth. We can see it at the court decision. However, in the decision of Machicha case, my case study in this presentation, regarding the status of children out of wedlock, the Constitutional Court was deemed to have stepped outside the limit of Sharia by ruling that children out of wedlock also have civil relationship with their biological fathers, and consequently can have full civil right from their biological fathers, including kinship, child support, guardianship, and inheritance. Next. We can skip this. Yes. In this slide, I present all the decision of Constitutional Court which implicate Islam, especially because they are related to the interpretation of Sharia. So mainly this type of...
Dr. Alfitri,
yes.
Could you please check your microphone and sound, because we can't hear your voice clearly?
Okay, it's actually still active. How about now? Okay.
Wonderful.
Thank you. So I said the first type of Constitutional Court decision related to the interpretation, Sharia, mainly this type of decision related to marriage law, mainly. And based on my observation and also other researcher observations, so far there have already been 1, 2, 3, 4, 5. I think five cases related to marriage law in Indonesia, but I pick up Machicha case because it's quite complex in its trial process, and also its implications quite significant in Indonesia, especially among Muslim society. Machicha submit petition to the court on the constitutionality of legal child article, anak sah, in the marriage law, because it was considered to have violated her right and also her child rights to form a family and continue offspring through legal marriage. This right enshrined in our constitution on Article 28B1, and also her right and her children's rights to survive, grow, and develop free from violence and discrimination in Article 28B2. Machicha, for your background, acquired her child through an unregistered marriage to a former state official who is still bound by another marriage. Because of the condition of her marriage is not recorded according to the state law, her child is not recognized by the law as a legitimate child. And she also cannot sue the biological father of the child to fulfill his civil obligation. Therefore, Machicha also challenged the constitutionality of article on registration of marriage as a condition for valid marriage. Long story short, the court then decided that her claim against the marriage registration article was rejected because according to the Constitutional Court, what determined the validity of marriage is its matrimony following religious law, not registration. Second one, her claim regarding the article on legitimate children was partially granted, or in its technical term, conditionally unconstitutional. The court then add a norm to the original article as follows. So I will read the article on legitimate children in our marriage law with addition from the Constitutional Court. A child born outside the wedlock has only a civil relationship with her mother and her mother's family. This is the original text of the provision in marriage law. And the following is from addition from the Constitutional Court decision. And with the man as her father and her father's family, if it can be proved using science and technology and other evidence, according to the law, that the child and the man have blood relationship. The Constitutional Court decision was responded in various ways. Human rights activists and progressive Islamic law thinkers consider this is a landmark decision for the enforcement of constitutional right in Indonesia, which is shackled by textual and conservative interpretation of religion. The majority of Muslims, however, including Majelis Ulama Indonesia, Indonesian Council of Ulama, criticized this decision and considered it to have violated the legal doctrine agreed upon in Islam, that is, children out of wedlock only have kinship relation and civil right with the mother and her mother's family. Okay, so this is the case law to showcase about disobedience to the court decision on Machicha case. The Constitutional Court decision should open up opportunities for parents and children born out of wedlock to get full civil right. Unfortunately, the Constitutional Court decision is seen as contradicting the Islamic legal doctrine agreed upon by the majority of scholars that children procreated out of wedlock are illegitimate.
Dr.
And
Alfitri, I'm sorry to interrupt you. Could you please make it short and conclude your presentation, please?
Okay, so from this slide, we can see not because the decision of Constitutional Court related to a child parentage case in the Sharia court, we can see because the nature of decision, we can see that not all Sharia judges in the court observe and or obey the Constitutional Court decision on Machicha. This can be proven from this 4 case law. Even Machicha itself, after the court decision, submit application to Sharia court, to get her child full right, but rejected by the court of the first instance and also appeal. Only after she submitted her application to the Supreme Court that her child full right is granted. And in this case, the Supreme Court also referred to Constitutional Court decision. On the other hand, 3 other cases, we can see that the court decision are not completely followed. And to some extent, even though they refer to the Constitutional Court decision in its consideration, Sharia court judges sometimes further qualify what they mean with the civil relationship. So they only give civil relationship to have father's name written in the birth certificate, not full right, not full civil right for children, for example, guardianship and especially inheritance. So
very good.
Okay, we can go to the conclusion. Okay, going back to my presentation, whether the Constitutional Court decision can be justified from Islamic legal theory, the answer is yes. However, the reason why not all decisions obeyed by the addressees or subject of law, for example, Sharia judges, legislature, and also bureaucrat related to the case zakat collector agency criminalization, because in my opinion, the decision already exceeded siasa syariah limit, which is it's not allowed for the state to prohibit the mandatory or mandate the prohibited. And also, I think the court failed to balance the complexity of Islamic legal authority and also religious state concept in Indonesia with the constitutional right in our constitution. With that, I end my presentation. Thank you.
Thank you very much, Dr. Alfitri, for your great presentations. We have now got 10 minutes for respondents. I'm going to invite also my colleague here at the Constitutional Court, Mrs. Intan. Are you ready to give a comment, feedback, or question to Dr. Alfitri? Okay, I will hand it over to you, please.
Okay. Thank you, moderator. First, I will send my gratitude to the moderator and Mr. Alfitri about the impressive presentation, and I think I will asking some questions, as I know the paper is about two issues. It's content to issues and to decision, I think. But the last issue is doesn't mention because at the time is run out. Okay. And the first issue is about illegitimate child, and I think it's very interesting, and I think this paper is very impressive if the perspective is not just the Islamic perspective. I think a multi-perspective will be elaborate the paper perfectly, and I think I knew some reference that can maybe can elaborate this paper. I think Mr. Alfitri, but if you want to know, there is many country response these issues differently, and first alternative is country has restricted paternity relation child who born out of wedlock, and this example of the country is Iran and India. And my question is why the only Islamic perspective is used in this paper? Why India and the other religion does not include? And I think the second alternative is country has equalized the child who born in or out wedlock. And I think the example of the country is very a lot. Like Australia, Canada, Croatia, Denmark, France, Germany, and another others. And last alternative is very common use. The country has been allowed to claim paternity relation with the child who born out of wedlock. It's like Japan, Romania, Spain, Netherlands, UK, USA, and Venezuela. And I think the paper just mentioned the case law of Macica Mukhtar, and I think I knew some case law. In this case law is Mark versus Belgium government. It's in the European Court, and the issue is the same, is prohibited of discrimination about the Convention of European about the restrictive rules to establish the maternal affiliation about the child who born in out of wedlock. And I think the case law will be perfect if you mention and elaborate the case of Macica Mukhtar, I think. Okay, and the second issue is about the criminal penalties for Amil Zakat, and I think that's not didn't mention because the time was run out. And if although I still have a question, Mr. Alfitri, and the question is, does the state not have the authority to collect tax besides zakat? Because as I know, in Sharia, the levy that prohibited is called mukus. And what do you think about the value-added tax and tax on luxury goods? And is it also prohibited or not? If I don't, that's not mentioned in your paper, I think. And if the decision, I think, is very clearly mentioned that not every people can be shoot in the article of 38 and 41. There is a category in decision and person or society, we call it alim ulama, and the
Very good.
organization in charge of administrative to the most. In addition, in the area didn't have official amil from the government. And I think my time is out.
Thank you very much,
And
Ms. Intan.
yeah, thank you, moderator.
Thank you very much,
Mr.
Ms.
Alfred.
Intan. So I'm gonna give Dr. Alfitri to answer and expand more detail about the comment from Ms. Intan. Thank you, Dr. Alfitri.
Okay, terima kasih. Thank you very much for Mbak Intan for your thoughtful observation, feedback on my paper. Yeah, because of the time limit, unfortunately, I don't have enough time to present my second case studies on criminalization of zakat collector agencies in Indonesia. Now I will use this moment to explain a little bit about the case. Yeah, if we look at my slide, yeah, the case brought to the Constitutional Court by non-governmental collector zakat agencies or lembaga amil zakat, because they perceive or they see that the state want to dominate zakat collection in Indonesia, while if we looking back at the history of zakat administration in Indonesia, we see a great role played by the society, and including non-government zakat agencies, yeah, to promote and raise awareness among Indonesian Muslim to pay zakat. So it's not fair, according to the applicant, if the state now dominate the zakat collection by limiting the establishment of lembaga amil zakat. So the state set up rigorous requirement for zakat collector agency to be acknowledged by the law. They challenge this provision, and also they challenge the provision that the state will sanction non-authorized zakat agencies, yeah, if they still continue collecting zakat without state authorization. So the result is the Constitutional Court confirmed the constitutionality of zakat administration by the state, but recognize the role of zakat collector agencies, yeah, in zakat management in Indonesia. So that the court, I don't know what happened, but it's like the way we read the provision on rigorous requirement to set up zakat agencies will be relaxed. Now. Zakat collector agencies, yeah, now can choose the provision to legalize their existence, yeah, So the provision is not what we call as facultative or combination that must be exist, yeah, to legalize. But now the lembaga amil zakat, zakat collector agencies can choose whether they are mass organization or Islamic education organization and so forth. But the most important thing is about the sanction for unauthorized zakat collector agencies. The court like state that decide that the provision is still constitutional but conditionally. So as long as there are no enough state zakat collector agents or society zakat collector agent in the area, so individual zakat agents and also civil society zakat agents can still operate even though they don't have authorization from the state. But I think right now, in my opinion, there was a complete disobedience to this decision because the condition required by the court, the availability of zakat collector agencies in certain areas are already been made, yeah, especially in the big cities or in the major cities in Indonesia. But we still can see that individual and also civil society zakat agencies without permit from the government collect zakat. So, but I think the reason why there is this complete disobedience to the court decision as a non-Islamic state, if Indonesia, because you mentioned in your feedback before that the state enforced the obligation of zakat, I think the state will face societal challenges, lots of challenge from the society because people are divided about zakat enforcement in Indonesia. You can read in my paper. But to make it short, the option to enforce zakat obligation right now in Indonesia is not applicable. And also it's contrary to the norm of religious freedom in our constitution because the state guarantee freedom of religion and also to manifest one own belief, and it will be counterproductive to the state protection of religious freedom. And also there is a problem from criminal law theory, if the concept of criminalization for non-authorized zakat collector agencies, because the problem is not authorization or non-authorization, but the problem is embezzlement of zakat funds. So this point should be regulated, and already regulated in our zakat law and should be enforced. Another point that I made is it is technically problematic to implement this provision because lack of lack of legal enforcers from the state apparatus. For example, who will investigate that there are indication of non-authorization of zakat agencies operate in certain areas, and to which court the case will be prosecuted, Sharia court, district court, or our tata usaha negara. So
administrative court.
This is homework for the revision or amendment of our zakat law next. If we still want to keep the provision of criminalizing non-authorized zakat collector in Indonesia.
Okay.
I think.
Thank you very much, Dr. And I'm sure that your idea about the corporate zakat norm and practice in Islamic bank will be discussed in more detail in your new forthcoming book. So we can't wait to read your new monograph entitled Islamic Law and Society in Indonesia, Corporate Zakat Norm and Practices in Islamic Bank, that will be published at the end of this year by Routledge Publisher. So congratulations for your new achievement. So now we have question and answer sessions. If there is a question, you can just use the raise hand using the Zoom menu. If not, because we have run out of time, so I may come to the end of the sessions. As a moderator, I would like to say thank you very much for all the great speakers, respondents, participants, and I will give it back to the MC. Thank you very much for your kind attention. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much for Mr. Lutfi Chakim as the last moderator for the last sessions of the 4th ICCIS Day 1. Honorable speakers, distinguished participants, ladies and gentlemen, this is the end of today's symposium. We will meet again tomorrow morning. The symposium will start at 8 a.m. and it is advised that you will join the Zoom meeting 15 minutes before the symposium started or began. I am very thankful for your participations in this challenging day. 9 hours full of very interesting and amusing discussions. I really wish that we can have a better and more experience tomorrow morning. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
The 4th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of our previous international symposia in Surakarta in 2017, Yogyakarta in 2018, and Bali in 2019, the Constitutional Court of the Republic of Indonesia will hold the 4th Indonesian Constitutional Court International Symposium. The Constitutional Court of Indonesia provides an international academic forum to discuss various constitutional issues in comparative perspectives, with the theme Constitutional Court, Religion and Constitutional Rights Protection. The Constitutional Court of Indonesia gives opportunities to legal scholars, researchers, lawyers, and practitioners to participate in the Indonesian Constitutional Court International Symposium. For further information, please visit www.iccis.nkri.id.